Good morning, everybody. We are getting ready for the continuation of the Daubert hearing for Dr. Marie Russell. And I am watching it, so as soon as it starts, we will pull it up and watch it all together. Before we do, just want to say hello to everybody in the chat. Thanks for joining us so early in the morning, 9 o'clock in the morning, if that's early for you. But I also do want to kind of do a quick recap of exactly where we are, because this is a continuation of the previous Daubert hearing, which took the entire day. So if this is going to take the entire day again, I hope you're comfortable and have a good seat, get some snacks, and but I don't think this is going to go the whole day, because I think a lot of it was really from Robert Alessi. He went through a lot, very methodical, very slowly, very carefully. So I don't think this is really going to be going an entire day again. So just want to say again, hello to everybody. We've got Sybil. Good morning to you. We got Rainey. And if I'm saying your name wrong, I apologize. That's always my disclaimer. Lorna McKenzie, nice to see you again. Thanks for coming. Blurry Lights, how are you? Steph Ennie, good morning. Good morning to you. Thanks for also becoming a Brother Counsel Sidebar member. I noticed. Appreciate that. We're actually going to be having another Q&A session, which is always fun, just for the members only. We've got Just Joe, good morning. Got DI, good morning. Elizabeth Hughes, nice to see you. Brooklyn, good morning. That's Yiddish for morning. We've got hello from Ireland, Ramona. We got Lisa. Good morning, Lisa. Holly, good morning. 2 p.m. in the UK is what Katrina Valento has told us. Good morning to you, or good afternoon to you. We've got Michelle's Mixed Media Madness. Good morning. And look at that. We got a new member already. Brooklyn, thank you for becoming a new member. Submit your Q&A, your questions, which we are going to have on the members only. So that's always fun. Submit your questions to me, and we will go all types of topics, completely off topic. But whatever you want, you can ask, and we'll try to get to them. So, okay. So all right. Good morning, all. Thank you. I appreciate it. So just to give you a quick recap, and by the way, in case you're joining me just right now, I am keeping an eye on the hearing for it to get, as soon as it gets started, we're going to live stream it right here on the channel. So I'm just keeping an eye on it, and once it starts, we will put it up. But I do want to kind of go through a little bit of a recap to catch everybody up to where we left off last time with Dr. Marie Russell. But first, a little sip of my coffee. All right. So last time we left off with the cross-examination was just beginning with Hank Brennan. And like I said, I thought that Hank Brennan definitely seems to be a fierce advocate. I think we're going to get a little bit of a different feeling from him than we did from Adam Lally. Looks like they take different approaches. I think it's going to be interesting seeing Hank Brennan as the new prosecutor. I think he's good. I think it's going to be interesting. So that's just in terms of Hank Brennan. Just to kind of quickly recap what happened. So we had a lot of the background of Dr. Marie Russell, which the Robert Alessi went through. We're not going to go through all that again. I want to just talk about the points that the defense made and kind of some points that they scored. Okay, so these are questions that Hank Brennan asked. The first thing I think, which is more obvious, which I just tweeted out, was the fact that he kind of got her a little bit on this idea that she's not a specialist in orthopedics. Okay, and this is something that I speak about a lot when you're talking to your experts. You got to tell them, don't worry if the other attorney is going to say, you're not an expert in this, you're not an expert in that, you're not an expert in this. And that's common for cross-examination. You always want to point out what they're not an expert in. So I always tell my experts, don't worry about it. That's just regular cross-examination techniques. Admit, I don't need you to be an expert in everything. I just want you to be an expert in your field. But don't worry, I'm going to take care of everything. I'm going to fix up everything when I'm talking to the jury about it. So, but Dr. Marie Russell kind of fell for that, because he was trying to say, well, you're not an orthopedic specialist, and she tried to create this. Well, I'm an emergency medicine, or specialty orthopedics or whatever, emergency medicine as orthopedic, and there's no such thing. So we know what you're trying to say. You're trying to say that as an emergency medicine physician, you're going to be seeing cases which involve broken bones and involve orthopedics, and that you have to obviously have some sort of knowledge in that. Of course, we understand that. But you're still not a specialist. Don't create new categories. And then once you try to create a new category, you're going to be made to look like a fool. That's what attorneys are trained to do on cross-examination. So she kind of fell for it, and he scored some points. Okay, so you gotta, we're calling balls and strikes here. That was a win for the Commonwealth, at least that line of cross-examination. Now moving on, he then kind of created his new a new specialty, which he said, self-defense. Are you a self-defense expert? Now, I don't know really if there is such a thing as a self-defense expert. Is there a category of a self-defense expert? Not sure. But he was saying, well, you're not a self-defense expert, kind of trying to show that what she was trying to say were defensive wounds on John O'Keefe's arm. That was, you're not an expert to be able to opine about that. So that was another point that he scored. Now, also another point is that he showed her a book, and I think a lot of people are talking about the book. But what happened with the book is, I think, kind of went back in his face, because he was trying to show, look, you don't know what this book is, and I guess he's going to try to bring some opinions from this book. And she right away took a look at the book and said, oh, it's not even written by anybody with degrees. So that kind of right away takes some of the wind out of that argument. But he may continue with that. We'll see. But also, I think a really strong point was the fact that she said in her testimony in last trial, and again, while I was watching this, the first trial, while I was watching this first trial, it kind of struck me as odd, and I don't know why Alan Jackson didn't tighten this up a little bit. That is that she said that her opinion was that this attack was an animal attack, possibly a large dog, and that possibly language is not what you want to hear when you're the defense. You want them to say it's probably a dog attack. You don't want to hear possibly. Yeah, possibly can be, anything's possible, I guess, right? So you don't want that language or verbiage, and that's what she used, and it really wasn't corrected by Alan Jackson or the defense attorney, and that should have been done. So therefore, Hank Brennan hammered her on this language that she used, that this is just a this is just a possibility. It's just a possibility that it was hit by a dog. It's also a possibility that he was hit by a car. So that was another part. Now, I also want to make a point here, which I spoke about in the last video. And by the way, for all of you joining just now, I'm keeping an eye on the live stream. As soon as it starts, we are going to live stream it here. But I'm just trying to catch everybody up. So something also that I thought this time the defense should definitely make an argument for, and I don't know if they're going to, but they definitely should. That is that last trial, Dr. Marie Russell was only allowed to testify that these injuries are consistent with a dog attack. That's what she was allowed to testify about. She was not allowed to testify that they are inconsistent with a motor vehicle strike. She was not allowed to testify to that. So I think now that they're having, again, a full Daubert hearing, and it's not last minute, they could really make a strong argument. Again, Karen Reed's side, they can really make a strong argument that she should also be allowed to testify that this injury is inconsistent with a motor vehicle strike, because she definitely has experience as an ER physician, 30 years diagnosing and treating injuries resulting from a car crash. And she can definitely testify, she's qualified to testify, that these are inconsistent with a motor vehicle strike. So I think that that's a point that the defense has to argue this time around much stronger. I think last time they're just happy that she allowed her to testify. So they're like, okay, fine, whatever you want. If Judge Canoni, if you're just going to allow her to testify that that's consistent with the dog attack, well, okay, we'll take it. But now that the prosecution is getting this full Daubert hearing, they should be able to argue now that, Your Honor, not only is she qualified to testify that these are consistent with a dog attack, but also that they are inconsistent with a vehicle strike. So I think that is something they have to argue by the time of the conclusion of this Daubert hearing. So I'm not sure if that's going to happen, but that's what I would do if I was there. Now, there's another point also that I want to point out that before I go back to the chat and see what's going on there. There's another point that I wanted to bring out, and that was the question for the necessity of this Daubert hearing at all. Because remember, there was a Daubert hearing already in the first trial. So if there's a Daubert hearing, why are we doing this again? You don't just get to do over everything that happened in the first trial because there's a second trial. So why are they redoing this Daubert hearing in the first place? Okay, that was also a question that we have to deal with. And I think that part of the answer to that is that Judge Cannoni said that things can change. Okay. And since things can change, so therefore, that's why she heard the testimony of Dr. Marie Russell. And since she heard it already, now she wants to have another Daubert hearing. So things can change, and that's why she's asking for another. That's why she's allowing a full Daubert hearing. Now, like I said in the last video, again, I don't know why anything changed by the fact that she testified. She testified exactly what she said in the Daubert hearing. So, all right, it looks like they're starting now, so I'm going to pull it up, and we will get this underway. Here we go.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, is Dr. Russell in the courtroom? All right, so why don't we have Dr. Russell take the stand?
Doctor, I'll remind you, you're still under oath. Thank you.
All right, good morning, doctor.
And I'll stop it every once in a while
All
to
right,
take some
Mr.
questions.
Brennan, whenever you're ready.
Thank you, Your Honor. Good morning, Dr. Russell.
Good morning.
Dr. Russell, it's fair to say that your opinions have changed between the time when you first testified at the voir dire to when you testified at the trial and then at our last time we met at the Lanigan hearing. Do you remember we spoke about when you testified at the voir dire hearing, you had uncertainty about what had actually caused the wounds?
I did not.
Do you remember using the words like most likely a dog?
No.
Let me remind you, in the voir dire, do you remember the court asking you what kind of animal caused the wound? And you said most likely a dog, a large dog? Yes, you may. Counsel, page 51, line 18.
Thank you, Stephanie,
Yes.
for the brother council membership.
Russell, I'm showing you a copy of your voir dire transcript. I'm going to ask you to read it to yourself when you're done reading it. When you're comfortable with that time, I'm going to ask you the questions again. You can look at any part of that you would like. Thank you. Do you now remember when the court asked you what kind of animal you said most likely a dog, a large dog?
Yes.
Do you remember at trial your perspective and opinion changing?
No.
Do you remember you were asked at trial whether or not the patterns appear to be injuries you would see consistent with an animal or a large dog, and you said yes? Do you remember that?
May I see that?
Yep, you may. Trial transcript, page 23, line 3.
So he's kind of continuing of what we kind of just spoke about this idea that she said in the last trial, which I was talking about, that Jackson or Yannetti should have tightened this up a little bit, that she was just saying it's possibly a dog, it's likely a dog, instead of saying this is very, very, very likely that it's a dog, not just use this other language, which is not as strong. Let me just stop to take a few questions here. We've got Lisa. Do you think the prosecution will come out stronger this time? Absolutely. That's what it seems like. They're filing all types of motions. Hank Brennan is really doing his best to tilt this whole case in his favor. You know, he's trying to exclude experts. He's trying as hard as he's going to try to attack Dr. Marie Russell. So he's a fierce advocate, and he's going to be definitely, I think we're going to be seeing a lot more of that from this prosecution. Okay, Michelle's Mixed Media Madness, Brother Counsel, what do you think of this judge? And I know that for the FKRs that they don't like this, but I'm going to say what my opinion is. From what I've seen in the last trial, I did not see any blatant bias. I know people are calling her Aunt Bev, and people are saying that she's biased and, you know, trying to point out different things. I actually saw certain rulings which I thought could have gone in the prosecution's favor, which she didn't make of those rulings. So this is my objective opinion. I've been in front of biased judges before. I know what that's like. I've seen judges like that. It's very extremely difficult. I'm not saying I agree with all of her rulings. I don't really like the way that she conducts certain things in her courtroom. I don't like that her cross-examination, she extremely limits the defense and prosecution in both ways of their cross-examination. But I have not seen, okay, and this is just my objective opinion, I have not seen blatant bias by Judge Bev. So I think she's doing, an okay job for what she's supposed to be doing. I haven't seen any clear bias. So we'll see. Well, you know, I'm still watching. My opinion can change. But as we sit here today, and as I pointed out other times as I was covering the first trial, there were definitely rulings that she could have made very easily in the Commonwealth's favor, and that would have shown perhaps some bias, and she didn't. So I pointed those out while I was watching it. And again, I know people don't like that on the free carry and raid side, but I'm just giving you my objective opinion as a trial lawyer and my experience. Okay, let me see what else they have here. First, I just want to thank BBMag23 for becoming a new member. Thank you for that. We are going to be having a special Q&A for the members only. Definitely a good time to join. Submit your questions, and we will get to them. All right, let's get back to the hearing. I'm just going to speed it up a drop. And by the way, it's as loud as I can get it. No problem.
Do you remember now saying that?
I didn't say it. The question had that word possibly in it. I didn't say it.
You can finish, please.
I didn't use the word possible.
You were asked, does this appear as a pattern of injury that you see appear consistent with an animal or a large dog? And you said yes. Do you remember that?
You sure that's me, dear?
Yes.
Okay.
Let's read it together.
That's a good idea.
Your Honor, may I make a suggestion, if I could, please? I realize it's crossed. Mr. Brennan and I have agreed that with regard to transcripts and the use of them, I have as well. Given that we've agreed for transcripts being in evidence, can the witness keep the transcripts and look
Do
at
you
them?
have an extra copy for her?
The answer is I have a copy, yes, that
Do
she
your
can.
colleagues each have a copy?
I don't know if they do, but I can give mine
Okay.
so that she
Problem
can
with that,
have.
Mr. Brennan? Okay.
Go Lions.
Okay,
Absolutely.
I know what they say.
Let's go.
You might want to go through a lot of it, so you might as well give her the whole.
1:16 a.m. in Australia. Wow, that's wonderful that you're joining us at 1:16 in the morning. Thank you.
All right, so that we can continue. We can give yours to the witness for a few minutes, and then when these are done, you can have yours.
Thank you, Your Honor, I appreciate that.
Thanks, Tom.
I think a lot of people agree with this comment. The case should have never made it to trial. I don't say I disagree with that, by the way. I don't think that this case should have made it to trial. I'm just saying that
Why
I
don't we
haven't
take a 5-minute recess? Mr.
blatant
Brennan,
bias.
Mr. Leslie, why don't we take a 5-minute recess? Mr. McDermott will be back with clean copies of the transcripts that I have as part of your exhibit.
Thank you very much.
And the witness can
So
vote.
Mr. McDermott doesn't have to-
Okay, it looks like they're taking a 5-minute break now.
Is just-
So I do want to say that
So is Mr. McDermott going to copy the?
lower the
DVD
volume a little
and
bit.
I have the voir dire and the trial testimony. So we'll take a 5-minute recess.
Thank you.
So, like I said, I don't think that this case should have gone to trial either, knowing with the ARC experts and all that. I'm not saying that it should have. I'm just saying, just to talk about this comment for a second. I don't know why it went to trial. If I was a prosecutor, I don't know if I would brought this case to trial when I have those ARC experts against me and I have nobody to rebut them. I'm just saying that from the judge, I haven't seen really blatant bias that a lot of people are complaining about. And that's just my objective opinion. So, that's what I do here. Nelly Bubbly, hello, brother counsel. Enjoy your commentary. Thank you. Let's get another Go Lions. Well, we got to make it this year. This got to be the year. Also, something that just came out. This is true. January 15th, Proctor is appearing before disciplinary board. Quote, permanent discipline may be immediately imposed. So yes, Proctor's disciplinary hearing is coming up, but that's not going to be live streamed for everybody, although many, many people would love to see that, but that's not going to be live streamed. And here we go, playing guns and ammo. I've definitely heard this before, that the judge is biased, and I've definitely been hearing that. I'm just telling you from what I've seen, and I've been in front of biased judges. I know exactly what that's like, and I'm just telling you, I haven't really seen it straight out in this case just yet. And again, it doesn't mean I agree with her rulings, doesn't mean I agree with the way that she's conducting the courtroom or allowing the attorneys, what type of leeway that she's giving the attorneys, but I'm just telling you, in terms of her rulings, I haven't seen really some blatant bias. Your thoughts on Alessi's direct? Well, this is actually cross-examination. I think you're doing a good job. This is exactly something that I would also point out. If she said possibly, if she said likely, I would absolutely hammer that. He's got to take what's given to him, and that was something that was given to him. And the fact that she's going to try to fight back is not good. Okay, you've got to concede certain things. Something that you got to tell your experts. Concede certain things. Don't worry about it. I'm going to take care of you on redirect, whatever it is. But don't try to fight everything, especially when there's a transcript right in front of you saying that you said those things. So. All right, let's see where this is. All right, well, they're still on break. Here's a question. PB Mag 23, the newest member. Are you going to get into Blake Lively? So I'm kind of on the fence about that. I know it's very popular. A lot of people are looking into it, but it's really salacious. It's really, all that stuff. I know that's why people like it, but I'm not sure. It's hard to just, talk about those type of things. And, I'll think about it. I'm definitely looking at it and following it. And if there's, a legal issue that I can talk about without getting into all the details of exactly what was alleged and done and all that, we'll see. But also the P. Diddy stuff, the P. Diddy stuff and the Jay-Z stuff. I know a lot of people love it and they're looking into it, and I would get easy clicks that way. But I just don't know. It's hard to talk about those things. So we'll see. Okay, answer. If a judge is biased in your favor, do you notice as much? Yes. I one time had a judge who I had a trial, and definitely the judge liked me and liked the way that I was conducting my trial, my opening, my closing. I could tell. And there was a certain ruling specifically, which I really didn't need. And I almost wanted to tell the judge, please, just don't rule in my favor in this case, in this situation, because I don't really need this. And, I couldn't say that on the record, but the judge actually ruled in my favor. It was one of those questionable rulings, and because of that, the case got reversed, and I had to try the case again. So, in front of the same judge, and the second time around, he was a little bit more careful to make sure, on those questionable rulings, to make sure to lean in the other way, because I didn't really need them, and I won the case again. So, it was just sometimes you don't want it in your favor either, because it just makes it easy to win the appeal. So that I have noticed it, but sometimes it's the other way, and quite often it's the other way, and it's difficult when it's against you. And look at that, another Carla D from Australia. And I think did someone just say it was 1 o'clock in the morning that was the earlier one? So if you're joining us at 1 o'clock in the morning, I appreciate it. Hope the insomnia doesn't last too long and you can go back to sleep and catch this tomorrow when you wake up. But, I appreciate you
Yes,
joining.
no, that's fine.
We have different stenographers, so sometimes the transcripts might be different, so I just want to make sure you have the same copy I'm
Okay.
working on. 'cause I don't want-
Hypothetically, if you're the defendant, would you
No, I don't
hire
mind.
Alan Jackson or Nettie or Hank Brennan as your
Tell me
lawyer?
your holidays.
From what I've seen, again, we haven't seen much of Hank Brennan, but what I've seen so far
I did
is
some work here.
he's
Did you?
Well, not really.
he's definitely a fierce advocate. He's filings, he's arguing, he's very comfortable, he's very strong in his positions. So I think he has some facts that are tough to deal with. He's thrown in the middle of this, and we're going to see how he conducts the trial. Alan Jackson or Yannetti, they both are amazing attorneys. If you can afford Alan Jackson, you hire him. I think that's like the obvious choice. If you can't hire Alan Jackson, then you can reach out to Brother Counsel. But yeah, these are all A-level attorneys that we're watching. I think right now. So that's why it's good to watch some good lawyering and read their briefs, by the way, which is what I do. I read their briefs and I research them, and they definitely know how to argue. Here from Brooklyn, would rather if you covered the Adelson and Luigi Mangione than the SA cases. And yeah, that's the thing. I'm not sure if I'm going to cover SA cases. I think maybe if there's a legal issue that comes up in those, like what just happened with the Jay-Z lawsuit, which we talked about, we devoted one of our episodes to that. If there's a legal issue that comes up, which I don't have to get into the dirty details of what the allegations are and all that, maybe I'll be able to do that. But it's just a very sensitive, and I'm not sure if I'm going to cover the all that SA stuff. So we'll see. Okay, so in Australia it's 10:30 p.m. So it was 1 o'clock in the morning somewhere else. Maybe I missed that. Good afternoon from Jerusalem. This is great escapism for me, and I'm here for your commentary. I hope they fix the mics. Yeah, I hope they fix the mics too. Stay safe there in Jerusalem. I know my sister lives in Modin, and she's constantly telling us that she has to run to bomb shelters. So hope everyone's safe there. And CRISPR, I love from American Living Taiwan. Found you from STS, Surviving the Survivor. Nice to catch you live. Thanks. Surviving the Survivor is always a fun show to appear on. I love going on that show. We have a good time talking. They usually have, they for some reason always have me on with Tim Jansen. I don't mind because Tim's an amazing lawyer and it's always a good conversation. So I've gone on Surviving the Survivor a bunch of times, and that's where some of you have found me. So that's great. I'm not going to complain about that. Here's a ringing endorsement from Carla D, all the way from Australia. Jackson's worth the money, as would you, Brother Counsel. So if you can afford me, I'm a little bit cheaper than Alan Jackson, just a little bit. But that might be a choice for you to make. Okay, so here it is. So it's 1:30 a.m. in Melbourne, Australia. All right, we're still waiting. But yeah, I mean, I just wanted to circle back to that point about this hearing even being necessary, because, like we said, on a motion for reconsideration, when you want the judge to reconsider an issue that she already ruled on. So if that's what you want to do, well, then you have to bring up a new reason. There has to be some new facts or some new law to argue about. You can't just say, Your Honor, can you just reconsider that ruling? That's not proper. And anytime you want a judge to reconsider, you got to bring some new facts. And in fact, this is one of the favorite lines the judges love to put in their orders when you file these motions for reconsideration, that you're not bringing up anything new, so they're not going to revisit the order. But it looks like they are going back, so we will crank up the volume, and let's get back to the hearing. And the answer to this is Jackson from California. Does that mean he has a license to practice in Massachusetts? No. It's called pro hac vice, which even if you're not licensed, you could, for one case, get admitted into a jurisdiction.
I'm sorry, Your Honor, I'm just conferring it from Your Honor's permission, Mr. Brennan. I want to make sure.
Hold on. Only one person can speak at a time. I don't know. All right, so you were speaking to me, Mr. Alessi. I think Mr. Brennan was speaking to his co-counsel. No, that's okay.
I just wanted to let you know what we were doing. Mr. Brennan and I are conferring to make sure we maximize the chances of the exhibits being right. So I've offered to Mr. Brennan something he wants to consider and look at what he has to make sure we do this efficiently.
Okay. So the copies that Mr. McDermott made are the attachments to the motions that were filed.
And provide a copy with the court's permission of the voir dire testimony, the trial testimony, and the Lanigan hearing.
Sure. Okay, I did not have Mr. McDermott do a copy of the Lanigan hearing.
I've had an extra copy that I've given
Great.
to Ms. Russell. I'm
Oh.
sorry, Dr. Russell.
Okay.
And if I may, can I write on the top of each transcript which each one is? That way it'll be easier for
Is there a
Dr.
problem with that, Mr.
No
Alessi?
problem at all.
Okay.
May I again approach the witness?
Yes,
May I speak, Your Honor?
yes.
Dr. Russell, I'm handing you two documents. You have a third. The one before you is a transcript of the last hearing called the Lanigan hearing that you attended. This is a copy of your voir dire testimony. I've noted it on the top right for you, and also trial testimony.
Thank you.
Thank you. May I proceed, Your Honor?
Yes.
I had asked you if you had expressed any uncertainty in the past about your opinion as it relates to the opinion you gave at the Lanigan hearing, at the last hearing, whether your position has changed or evolved is what I'm getting at. And you said that your position has not changed. Is that right?
That's correct.
You were asked at the trial about the injuries and how you think they happened. I want you to turn to the trial transcript. If you turn to page 19, line 21.
Nineteen,
Page
Line-
19, line 21, may I approach, Your Honor?
Yes.
So the page number is here?
Yes.
And then line would be. Sorry. My apologies. This one is the trial.
And as you know, I agree with those two statements. I mean, as we sit here today, there's definitely enough reasonable doubt. Question is if whether Hank Brennan's going to be able to actually debunk these ARCA experts and Dr. Marie Russell. So that is yet to be seen in the next trial. So we'll see what happens in the next trial.
Do you recall at the trial, you were asked about the injuries, and you said, I believe that these injuries were sustained by an animal, possibly a large dog, because of the pattern of injuries? Do you remember saying that?
That's not here in front of me.
Okay, but I'm asking you, do you remember saying that at the trial, that you believe the injuries were sustained by an animal, possibly a large dog?
Something to that effect, yes.
Okay. And when you said that, you used the word possible because you weren't certain, were you?
Can you show me where that is?
Well, I'm asking a question, not asking about the transcript. The reason why when you were asked and you said it was by an animal, possibly a large dog, is because you were uncertain.
You know, Mr. Brennan, I think I explained that before, that in medicine, there are no absolutes. And that's what, physicians are ingrained to think, is there are no absolutes in medicine. So that's why I expressed it that way. But
Yeah,
I was certain that it was a dog.
Yet you were testifying as an expert witness, weren't you?
Yes, I understand that, but I was thinking like a doctor.
I see. And you understood as an expert witness that you were asking the jury to rely on your opinion. You were trying to be as accurate as possible, weren't you?
Yes, I usually do. Yes.
You were trying to be precise in your testimony under oath, weren't you?
Yes. And I don't see a difference really between those.
And when you use the word possibly a large animal, that's different than an opinion to a reasonable degree of medical certainty, isn't it?
Objection, Your Honor.
In this witness's view. She can answer that.
That's not what the transcript says that he's referring to.
So he's not asking about the transcript. I'm going to allow the question.
Would you like me to repeat that?
Yes, please.
When you chose the word during your testimony to precisely describe what you thought, and you said possibly a large dog, that is different than to a reasonable degree of medical certainty, isn't it?
No, I don't think so.
You were asked whether or not you could tell what type of animal left these marks, and you said you couldn't with 100% certainty. Isn't that true?
With 100% certainty, that's correct.
And the reason why you don't have certainty when you first testified is because there really is no methodology in identifying dog bite wounds, is there?
But that's incorrect.
I see. When you talk about methodology, is there any standard you're comparing your comparisons to?
There are multiple published peer-reviewed articles that describe what dog bites and dog injuries look like.
Is there any standard that you use? Is there any particular things you look at with specificity that you compare to a standard model?
The pattern.
The standard model of patterns, where do you get that from?
Pattern recognition is used throughout medicine. And, it's something that I have been trained on since actually before medical school, but certainly in medical school.
Pattern recognition, you understand, is different than a standard of comparison. You understand there's a difference between those two things, don't you?
Oh, yes.
Okay, we'll talk about pattern recognition analysis in a minute. But what you're saying is that there's a methodology in identifying dog wounds. I'm asking you, where does that standard come from?
It comes from multiple published peer-reviewed articles.
Okay, tell me one.
Munich.
I'm sorry?
Munich. We talked about that one last time.
The gentleman who studied human teeth.
No, he wrote about dog bites.
Okay, and what's the name of the article that you've relied on?
The name of the article, I have to refer to my report, but it's something to the effect of forensic evaluation of
Do you have any specific memory about what you're relying on as a standard of comparison to identify dog bite marks?
Yes.
Okay, share that with us.
Again, the standard would be what the wound looks like, and the pattern recognition that goes along with it, along with the configuration of the wounds. It's a multifactorial
I'm
process.
trying to have you assist us in distinguishing between pattern recognition analysis, which we're going to get to, and when you're looking at a wound, the standards in the science, the standards, the methodology you would actually use to look at it and see if there's points of comparison, to see if there's similarity. What standard are you working with?
I'm not so sure I understand what you mean by standard then, because I know how I evaluate wounds.
You have personal experience where you've treated dog wounds and you look at it and you're simply deciding whether or not to you this looks similar. You're giving your personal aside, aren't you?
I actually find that offensive.
Oh, okay. Well, is that what you're doing?
No.
So if you're comparing it to an actual science, a standard, a methodology, I want to learn that methodology from you. So what I'm asking you is tell us, where does that come from? The methodology where you have a point of comparison, where you look at a wound and you compare it for similarities to another item.
So this is all what the Daubert hearing really is supposed to be about, like the methodology. That's why I keep saying methodology, methodology, methodology until it's coming out of your ears, because that is the stand. That's what we're talking about during a Daubert hearing, not just your expertise, your knowledge and training and experience, but also what type of methods do you use in order to determine your expert opinions? Is it just something that you pull out of your head, or is it just something that's based on some, like articles? Is this something that you've learned about, that you read about? So that's kind of where he's going, but he's wording it in a way that's confusing for her and trying to get her on this so that he can move to strike her. So we'll see if she falls into this trap and whether she's going to be able to be rehabilitated by the defense. So let's see. It's interesting.
There are several published peer-reviewed articles that describe what to look for, how to observe, evaluate, and then sometimes treat wounds, dog bite wounds. There are, several authors that have published similar things. And in terms of there being an organization that says, here is the standard for dog bite wounds,
Right.
I don't think that there is one.
When you say you don't think there is one, if you're an expert in this field, you would know that there is not one, is there?
There is not one that I know of, correct?
Well, you're not guessing there might be one you don't know of.
I don't know of any published standard by an organization.
So it'd be fair to say, when you are giving an opinion, what you personally believe to be a dog bite wound, there is no standard in dog bite science that shows you what the standard is. There's nothing to compare it to.
Again, it's based on a combination of the experiences that I've had over the last 30 years, observing, evaluating, and treating dog bite wounds, plus the numerous articles that I have read on dog bite wounds, their characteristics, morphology, patterns, and other things like complications, et cetera.
Okay, so to get back to my question, I know that you're using your experience and your memory, but there is no standard of comparison. There's no methodology that is accepted as a practice.
I disagree.
Okay. Can you share with us one of those articles that you've been relying on to combine with your personal experience to come to conclusions in dog bite analysis?
Well, there's the Munich that we talked about.
I didn't talk about. Can you tell us a little bit about it?
Oh, certainly.
Okay, please.
Okay, would you like to go through it together?
I'm asking you to tell us about what you're basing your opinion on, and you said it's Munich, so I don't know much about.
Okay, that's one of them.
Well, tell us a little bit about that.
Okay, well, in that article, the authors described a fatal case, but also described what some of the characteristics are in dog bite wound cases. What types of wounds you see, their appearance, their distribution, their configuration, the different aspects like that. Many of them are parallel. Things that would affect the appearance of wounds that physicians know about, such as elasticity of skin and other ways that wounds can be distorted from one to another wound. So you have to know a little bit about wound characteristics, and basically things to look for in the forensic evaluation of dog bite wounds.
Did that article lay out a standard of methodology?
I guess I don't understand what you're getting at.
Rather than having a particular case study where that article talks about a person that was attacked by a dog and deceased, correct?
In that case,
Yes.
however, it
And
referenced.
and
I'm
it's,
sorry, Your Honor, if you could finish the question.
Yes. I'm going to let her finish.
please.
And Mr. Lessie, for objections, just simply objection.
I'm sorry, Your Honor, I will, thank you.
Okay.
Again, one of the more annoying things that we have to deal with when watching these trials that Judge Cannoni does not allow. There's a fine line between speaking objections and stating your basis for an objection. Okay, so we all understand that you're not supposed to speak your objections and tell the witness essentially why you're objecting, because that will teach the witness what you're trying to help them say. So there's speaking objections which are not allowed in any courtroom, or not, or definitely not encouraged. But then there's also just objections about what the basis of your objection is at all. And she doesn't allow that either. So you can't say the word, like in Judge Cannoni's courtroom, you can't say objection, hearsay. She won't allow that. You can't say, objection, authentication, objection, foundation, objection form. You can't do any objection leading. You can't say the basis of your objections either, which is a little annoying because you don't really know sometimes exactly what they're fighting about. And sometimes they have to go to sidebar a lot. I shouldn't say sometimes. A lot of times they're going to sidebar because they say objection, and then the other side will look at them like they're not sure what their objection was, and then they have to go to sidebar. So that's a little bit of annoying part of this. And like here, objection, allow her to finish the question, answering the question. Like that's just allow her to finish. There's not like a speaking objection. It's just he's trying to cut her off. This is improper. So here again, she's saying, well, don't say that. Just say objection. So
That article, it was a case report, but it was also a review of previous literature. So in the review of the previous literature that had been published, they came up with recommendations. So yes, there are recommendations in that article.
In that article, it talked about a wound to the neck where the deceased bled to death, correct?
Yes,
Okay. It didn't talk about pattern recognition analysis
I
in that article.
disagree.
Okay. And did it talk about a standard of practice of methodology?
Recommendations.
No, but that's not what I'm asking you. I'm asking you, did it have a standard, a methodology that it discussed?
These were authors that were practitioners, and I don't believe they were in a position to create a standard.
In fact, you can't point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites. You can't point to one article, journal, book.
So again, what he's trying to hammer home here is that, there's a certain standard, generally speaking, when it comes to certain injuries. So let's say a broken bone. The standard is there's an X-ray, it shows a certain break in the bone. That's your starting point. That's a standard, right? Here we have a dog bite wound. So what he's saying is, okay, what's the baseline? Where do we start when it comes to this is the standard dog bite? It has these characteristics, it has these patterns, and now you work off of that and you say, okay, well, let's say it has this type of pattern. Let's say it has that type of pattern. Let's say it's this, let's say it looks like this. Then where do we go based on the standard that's already accepted in the medical field? So it seems what she's saying back is like this. She's saying there's a lot of things that I've seen and read that tell us about the different patterns that you could expect to find or how a wound is supposed to look without saying that there's a standard. Okay, so he's trying to, and this is going to be his argument, obviously, that if there's no standard, that means that you don't have an appropriate methodology. Now, that's why he's trying to put them both in the same cup. He's trying to put them both in the same thing, saying if there's no standard, that means that there's no methodology. And that's not necessarily true. And this is something that they should fix on redirect, saying saying to Dr. Russell, let's explain the difference, exactly what you do know and what you're basing your opinion on, and what the prosecutor is trying to create of this standard. And does there have to be a standard in order for you to be able to say these patterns aren't consistent from all the literature that I've read and all the studies that I've read, that these patterns and these wounds point to this being a dog attack? Even if there is no standard where like every single dog attack is going to have this specific pattern or this specific wound, but still, when you see these type of patterns, most likely they are from a dog. So we'll see if they get to that.
That's correct.
And so because there is no methodology or standard for you to look at, it involves a great deal of your subjective opinion based on your experience treating dog wounds, doesn't it?
With all due respect, Mr. Brennan, I'm not somebody that just came in off the street. I have at least 30 years as a physician, and I use that information in helping me form my opinions about wounds. I've seen all types of wounds.
Okay, so my question was, because there is no methodology, because there is no standard comparative analysis.
But you see what he's doing, and this is what good attorneys do. They say one thing, and then they decide that thing is the ultimate question. So here he's saying, well, there's no standard. That means that there's no methodology. And therefore, since he got her to agree, and this is just good lawyering, okay? Since he got her to agree that there's no standard, so now he's saying, well, since you agree that there's no methodology, and he keeps stressing that because that's going to be his argument to the judge, since you're agreeing that there's no methodology, so then you're just saying it based on your experience. That's not enough. There's got to be some sort of methodology. Now, the response to this would be, listen, Mr. Brennan, it's not about specifically a standard that the entire medical community has agreed that all dog bites are going to look a certain way at least, but there still is enough evidence that would show that there is a methodology that you can employ when you are treating and determining and diagnosing dog bites. But he's doing something very smart by saying, trying to get her to say, you agreed that there's no methodology. And we'll see, I mean, if they're going to fix this on redirect, but he's doing a great job for the Commonwealth right now.
You need to rely almost virtually on your personal experience treating wounds.
No, I believe you're again mischaracterizing it. I'm relying on my personal experience plus what I've learned from these numerous articles.
And so because there's no methodology and standard to compare to, you've introduced the idea that you have used a process known as differential diagnosis.
That's one of the processes used.
And as far as differential diagnosis, what that suggests is when, as a doctor or a person looking at symptoms, you try to rule out other conditions that have similar symptoms.
Correct.
Okay. And so you said all that's traditionally used in a doctor assessing a cause of a patient's symptoms, you're using that in identifying dog bites, this differential diagnosis you speak of, right?
I used it to assist me, yes.
Okay. And so when you're using differential diagnosis, it means that there are
By the way, I did speed it up just a drop so we can kind of catch up. If it's too fast for you, just let me know and I'll slow it down. But I'm trying to catch up a little bit.
many other ways or reasons why the same symptoms can occur.
Not always. Not always. It could mean that there's just one or two other conditions that would
Okay.
resemble this, but it's a process that a responsible physician would go through.
And in this case, you went through differential diagnosis to exclude other causes of these abrasions on Mr. O'Keefe's arm.
I did.
If you had used your training and experience and you were certain to a reasonable degree of medical certainty that these are dog bites, you would not need to go through differential diagnosis.
Oh, that's so incorrect.
Okay.
I'm not perfect. I'm not 100% perfect human being. And so so I have to, as a responsible physician, in every case, go through a differential diagnosis to make sure I'm evaluating and treating the right thing if there's treatment involved.
Okay, just to be clear, differential diagnosis just means that she thinks about what else can this possibly be. As a physician, you don't just say, well, okay, well, this looks like a dog bite. From the literature, it looks like a dog bite. From, my experience, looks like a dog bite. So this must be a dog bite. No, as a physician, what you're supposed to do is say, okay, what else can this possibly be? Let's think, let's think out of the box. What can this possibly be? Oh, maybe it was a vehicle strike. Maybe this was a knife attack. maybe this was a fall down the stairs. And then you go through all of that, and then you say, well, it can't be that because of this. It can't be that because of this. And that's called differential diagnosis. So aside from applying what you've learned through peer review and through medical school, that this is absolutely pointing towards a dog bite, but you also have to rule out all the other things.
When you chose to go through differential diagnosis, you recognized that these abrasions could be caused by a lot of different mechanics of injury, didn't you?
I considered that they could have been caused by others, but I went through the process.
Well, you were uncertain, weren't you?
No.
Yet you went through this process of differential diagnosis anyways.
Yes, absolutely.
Because he's saying, well, you must be uncertain that it's a dog bite because you went through a differential diagnosis. Why would you do that if you're so sure? Like if somebody walks in with a gunshot wound, are you going to go through a different differential diagnosis? Well, maybe he fell down the stairs. No, it's a gunshot wound, right? So there's no doubt at all. But he's trying to point out that if you even employ this differential diagnosis, so that means that you yourself are not sure whether this is a dog attack or not. So how can you come testify to this jury and say, yeah, you're sure it's a dog attack if you had to go through this differential diagnosis process? Which again, it's a little bit flawed because certain things are very obvious, but as a credible physician, when you have something that's not 100% certain, you have to go through this process. But then after you go through the process, then you can say, yes, in a reasonable degree of medical certainty, this is a dog bite attack. You're right. I have to go through the steps to make sure of that. But after I did go through the steps, and that's why I think that there's really nothing wrong with her saying, it could have been something else, and that's why we had to rule everything out. But once I went through everything that I know and all my knowledge and experience and training and all that I've learned from all these peer-reviewed articles, and I applied that information into this specific scenario, I came to the conclusion, to a reasonable degree of medical certainty, that this is a dog bite. There's nothing wrong with saying that, and it doesn't destroy her position.
Okay. And when you did that, you decided that you should focus on car accident.
No, I didn't focus just on car accidents.
Well, what other subject did you focus on in differential diagnosis other than car accident?
Could these have been self-inflicted, for instance?
You went through that process?
I did.
I didn't see that anywhere in your report
It's in
whatsoever.
my head. I didn't write it down.
Well, aren't you supposed to report the process you go through before coming to conclusions? Isn't that why you wrote a report in discovery and disclosure?
Yes, but
Okay. Is there anything else in your head that you thought about that you didn't put in the report or tell anybody? So we have car accident, we have suicide, we have dog bite. What else did you think of?
And this is just good cross-examination. I mean, this is exactly what you're supposed to do in cross-examination. Is there anything else you forgot to tell us about that you conveniently left out of your report? Like, that's just to hammer home your point. Now, again, it's in front of a judge, so she shouldn't fall for all this stuff as much of a jury does. But it's still, you get to see good lawyering. This is absolutely good lawyering, whether you like the Hank Brennan or not. He's doing as good as he can with this witness, and she wasn't prepped properly. I'm just telling you that. I mean, again, I don't know what the interaction between her and Yannetti and Jackson were, what to fight back, what not to. But this is an important area where, they're always, this is what lawyers do. They try to point out certain things that you left out of your report. And why did you do that? Well, of course, you're not going to include every single detail of every single thing that you've done in order to prepare this report. That's just, obviously you don't do that. So she could have said, yeah, I didn't put that in the report because I'm not going to put in every single tiny little detail into the report. But she's really fighting back. And this is exactly what Brennan wants, because then, he's going to continue down this line, saying, oh, what else did you forget? Make her look very uncredible.
In your differential diagnosis.
Incredible.
well, I thought, could it possibly be road rash?
Okay. What else did you think?
Oh, I don't remember all the things I thought of at the time, but it wasn't a very large list, but it was a list, and it was a differential diagnosis.
Well, it was important enough to think about and distinguish and go through differential diagnosis. Can't you remember what it was that you thought could have been the cause other than suicide, road rash, car accident?
Well, of course, I mean, there were some things I thought of and immediately ruled out. Were these stab wounds inflicted by someone else? No.
Okay.
So the list, there was a list that I went
Okay.
through in my head. Would it be worth writing down? No, I don't think so.
Well, was there any other significant causes that you went through and vetted through differential diagnosis that you didn't write down?
Not that I remember at this time.
And that's why it helps to write it down.
See, this is just
So one of those causes of these abrasions that you went through differential diagnosis for was car accident, wasn't it?
Yes.
In fact, when you first met the defense attorneys, you had an interest in this case, didn't you?
I thought I could clarify the issue of what those wounds were caused by.
So you were learning about information about the case publicly before you got involved in this
No.
case, didn't you? Well, you knew there was an issue.
I heard, yes, I did know that there was an issue. I saw something in the Boston Globe, and Mr. Brennan, I wasn't following the case at all. I don't even subscribe to the Globe for information about this
You don't-
general region.
You don't have to be defensive about it. I'm just asking you.
Okay.
You knew
Just
enough
clarifying.
that you wanted to get involved and you made some phone calls to offer your services.
I didn't want to get involved, but I thought that I should.
I see. And so you learned enough through your study or the Boston Globe or television that you knew generally that there was an issue about the abrasions, correct?
I knew there was a question, yes.
You knew that the defense was claiming that a dog caused those injuries.
I wasn't even sure who was claiming what at that point.
So you didn't know much about anything, but you still made phone calls to introduce yourself to get involved in the case?
Again, I know that there are very few people in this country that have the combination of experiences that I do. And I thought that I could just clarify the issue and maybe, help people move along in the case.
Before you decided that you were going to offer your services, what did you know about the case?
I knew that a police officer had died. I was a former police officer, so I knew a police officer had died. And I knew that there was a trial. And
I'll bring up this question before we continue. Can the defense have this type of hearing for all the experts on the prosecution side? The answer is yes. They just have to file a motion and ask for a Daubert hearing and argue why a Daubert hearing is necessary. And they can go ask the judge for a hearing like this also. So if they want to do this to their experts, that's fine. Yeah, I mean, except, okay, whatever. We can talk about their experts, but let's just get back to this.
I didn't know details really. I just knew that I believe I read that there was something about a car accident versus dog bites. That's about all I knew about the case.
Had you seen any photographs?
No.
And so just generally knowing that there was an issue, you thought you could help because of the word dog bite in your experience?
Correct.
Okay. So when you ruled out motor vehicle accident, is it fair to say that your perspective was a motor vehicle accident would have caused injuries to the other parts of the body, and that's why you consider car accident as not part of the cause of these abrasions?
That was not the only reason.
That was one of the reasons?
Yes.
Did you look at the wounds and you thought based on the accident, there would have been broken bones or other injuries?
That was one of the reasons.
Okay. So based on those two reasons and other reasons, you decided to exclude car accident as the cause of these wounds, correct?
Correct.
And when you made that decision to do that and exclude car accidents, you didn't really have the experience in car accidents to decide whether a car accident was the cause of these injuries, did you?
Mr. Brennan, I've seen thousands of car accident victims through my emergency medicine career. So I had plenty of experience.
Have you ever been trained as an accident reconstructionist?
No, I'm trained as a physician to treat car accident victims.
But that's not what I asked. What I asked you is, you have been trained as an accident reconstructionist.
No.
Have you ever taken classes and certifications in accident reconstruction?
No.
Have you ever gone to a scene of an accident and been asked to give your opinion and help reconstruct the accident?
No.
Have you ever served as a witness in court as an accident reconstructionist?
No.
In fact, when you decided that this accident couldn't have happened, you hadn't even read the investigative reports, had you?
No, I didn't decide that an accident didn't happen. What I decided was that those injuries were not from a motor vehicle accident.
When you first gave your opinion in this case, she was done.
Hold on, Mr. Leslie. Next question, please.
When you first gave your opinion in this case, excluding car accident, you had not even read the investigative reports in this case, had you?
That's correct.
And when you were asked about materials that you reviewed to give your opinions, you said you were just trying to focus on the wounds and you hadn't read those reports, right?
That's correct.
Have you read the reports to
Yes.
date? You now have read the reports.
Yes.
Okay. When you excluded the car accident, did you know anything about this collision between the Lexus and Mr. O'Keefe? Did you know anything about it?
Objection, Your Honor.
Can you answer that question, Dr. Russell?
Did I know anything?
Yeah.
I think that I don't know why that objection was not sustained. He's assuming things that are not in evidence. I mean, he's definitely making an assumption there that foundation has not been laid for. He said that, were you aware of the accident between John O'Keefe and Karen Reed? Who said that there was one? Okay, I don't think that was the correct ruling right there by Judge Cannone to allow him to ask that question. Now she has to answer that question. So no, I don't, that ruling I have to take issue with. It was an improper question. It assumed certain things in evidence that have not been proved. He could have said, are you aware that there's a possibility that he could have been hit by a car? That's true. But he's assuming that there absolutely was a contact between Karen Reed and Karen Reed's vehicle and the John O'Keefe, and that has not been shown yet. So I don't think that's a proper question.
Did you know anything about how it happened?
I was somehow I knew that. Well, I believe I knew that the car was backing up. That's what I was somehow I got that information.
So when you were
Car backed up.
excluding the collision in this differential diagnosis, did you know how fast that Lexus was going back when it struck Mr. O'Keefe?
No.
Do you know how far it traveled when it hit Mr. O'Keefe?
All these questions are completely improper because it's assuming things that are not in evidence. It's assuming that this accident actually happened, which has not been proven yet, and what she's saying didn't happen. So you can't ask the question, did you know how fast the car was going? I don't think this car was going anywhere. That's not my testimony. I'm looking at this. And by the way, just so you should know, this type of line of cross-examination, which he's doing with doctors, you're not an accident reconstructionist. You never testified as an accident reconstructionist. This is the same type of thing that we do with accident reconstructionists. When they try to say that certain injuries are either consistent or inconsistent with the vehicle, we always say, are you a doctor? Have you ever treated injuries? We always flip the script. I mean, that's what lawyers do. You know, that's what we do. But again, this is something that she should just concede on. Yes, I'm not an accident reconstructionist. I'm viewing this as a doctor, as someone who's treated thousands of car accident victims and thousands of dog bite victims. And that's where I'm coming at this. That's my angle, not as an accident reconstructionist. And quite frankly, Mr. Brennan, I don't need to know that. I don't need to know accident reconstruction in order to treat and diagnose injuries. But he's doing a great job.
So it's a question. The question's proper. Let's see if she can answer it. She may not be able to answer it as asked.
See, again, she's saying the question's proper. I don't believe the question's proper at all. Okay, I'm sorry. I have to take issue again with this whole line of questioning. And I'm glad that there was an objection made, but this line of cross-examination is completely improper.
Do you know how far the Lexus traveled backwards when it hit Mr. O'Keefe?
Your Honor, I'm objecting to the
I
assumption in
understand.
it.
I understand, counsel. Can you answer that question as asked, Dr. Russell?
As asked, no, I don't know.
When you excluded this collision as differential diagnosis, did you know the angle of the collision between the car and Mr. O'Keefe?
I'm going to see counsel at 7.
Okay, there we go. See, this is okay. I'm glad that I didn't have to get involved there, but you see exactly what the problem here is. And this is what the defense is doing. Exactly what I was talking about. I was like, this is absolutely ridiculous. Did you know the angle which the car hit her? Do you know how fast the car was going when there is no, you can't assume that the car hit her. Where's the evidence for that? And why does Dr. Marie Russell have to adopt that interpretation of what happened? You're creating this scenario, which you're just creating out of your own mind, that your theory of the case is, but you can't just assume and then ask questions based on your assumption. Completely improper. So we'll see what the judge does with this. We'll just speed it up to get through this sidebar. Completely improper. This is like if the prosecution has a witness and they say, and you get the witness on the stand and say, you know, how strong do you think that bite was of the dog when he was biting John O'Keefe's arm? How strong do you think it was? How many, you know, where did he, which angle did the dog bite his arm? You know, the same way you can't ask that if you're the defense, because you're just assuming your theory of the case without the evidence, you know, and which this expert is not agreeing to. You can't just ask your questions based on your assumptions. So this is the same way, and I don't know why she's allowing it the other way. I appreciate this. BC, you were great on SDS yesterday. I was on Surviving the Survivor last night, in case you guys missed it. You need to give us a heads up when you're going to be a guest somewhere. I know I actually forgot to post it on my community post. I apologize. I was just crazy busy yesterday with so many different things going on, and I forgot to post it. I actually almost forgot to post that I'm doing this live. You know, I ran back to the office last night at like 10:30 and posted it. Well, anyway, so but you'll never get me to buy Joel's book. That's hilarious because I always plug his book for him.
May I?
Yes.
When you engaged in differential diagnosis, excluding a car collision as the cause of these abrasions, did you know or learn any information about the angle of the strike between the Lexus and Mr. O'Keefe?
It's completely improper. It's just, I don't know what happened at that sidebar. And maybe that's why Robert Alessi, we saw get a little animated. This is completely improper.
Do you know whether or not the person, John O'Keefe, who had these abrasions on his arm, do you know if that person used his arm in any way to defend himself from an oncoming vehicle?
I considered that.
You did.
Yes.
And in considering that, did you consider the body position of John O'Keefe?
Oh, yes. I considered various possibilities.
Okay, what was his body position at the time the car allegedly collided with him?
Objection, Your Honor.
This is absolutely ridiculous that he's able to ask these questions. It's absolutely nuts.
He was the word allegedly.
What was his body position?
I considered several possibilities. I considered if he was standing, I considered if he was kneeling or sitting or even lying down. I considered multiple
Was
possibilities.
he standing?
I don't know that. I don't know, but I considered all of those possibilities.
Was he kneeling?
I don't know.
Was he lying down?
I don't know.
So you considered all these things, but you have no information, fact, or understanding of what body position he was, do you?
I went through the process of what the wounds would look like in those various positions.
I see. So if John O'Keefe was trying to defend himself, pulling his arm up to brace himself, what would the injuries have looked like?
Well, if they penetrated his clothing,
If what?
if there was penetration of his clothing,
Uh-huh.
from broken parts, for instance, they would have been quite irregular. There would not have been multiple parallel abrasions and punctate wounds that were seen in those pictures
How do you know that?
from my many years of experience.
Did you do any comparison analysis of the broken taillight in Mr. O'Keefe's arm
Actually, eventually I did.
before you gave these opinions, did you?
I didn't need to because I've seen thousands of accident victims.
Every accident is dynamic and changes, isn't it?
Yes, but I also had that in consideration. That's why people train for the number of years that I trained.
Every accident is different, isn't it?
Yes, probably.
And so you can have a number of people in an accident and they can have different injuries from the same accident, can't they?
Oh, absolutely.
Right? Car drives down the street and runs into 20 people. They may all have different injuries.
I agree.
Same car,
I agree.
might be the same speed, but they could hit people differently. Some people, unfortunately, they could kill, right?
Yes,
Some people could be catastrophically injured but still alive.
correct.
Some people could have scratches and bruises.
Correct.
Some people could be in that type of situation, bounce off the car and escape without a scratch.
Possibly, yes.
Right? So there's no science or standard when you say car accidents would have had a certain result. The truth is you don't know.
I disagree with you.
Okay. And so when you were excluding these causes, you have no idea his body position or angle, correct?
I went through various scenarios in my head.
But I'm asking you, not the scenarios in your head, Dr. Russell. I'm asking you about detail, fact, science, okay? I'm asking you, do you have any idea the position of John O'Keefe's body when he allegedly was struck by the car?
Objection, Your Honor.
No, I'm going along.
I considered multiple scenarios.
Tell me the facts you have. Tell me the facts you have. You can tell us how is his body postured on fact.
This is the absolutely $1 million question. I don't understand this at all. Okay, I don't understand how she's allowing this to go on. I think I've made that very clear at this point. This is completely improper.
What facts do you have?
Again, I considered multiple scenarios.
Did you go to the scene of where Mr. O'Keefe was found lying on the ground? Did you go and visit the scene?
No,
Did you take and look at photographs of the scene?
I looked at some photographs.
What did you see in those photographs?
They were very difficult. It was very difficult to see much useful information in the photographs.
When you're engaging in differential diagnosis and you're excluding causes of abrasions to Mr. O'Keefe's arm, wouldn't it be important to either go to the scene or look at clear photographs so you could see all the debris and the land and the turf and see what it looked like? Wouldn't that be important?
No, in the 30 years of emergency medicine experience I've had, I've never gone to the scene of a car accident victim that was brought into the emergency room.
And you've never gone into court and testified as an accident reconstruction expert.
A reconstruction expert? No,
You've
but I've
never-
testified about vehicle
And
accidents.
you've never gone to court and
Victims.
testified as a dog bite expert before this case, yes?
I was never asked.
And so when you say what you used to do, you treated people who came in with injuries. I'm talking about when you're going to exclude something as a cause. I'm asking if you have any experience in actually going out and looking at the facts and using science to exclude something fairly.
I used medical science.
Do you know what the ground looked like when Mr. O'Keefe lay that morning?
There was snow.
Know how many inches of snow were under his body?
Under his body?
Yeah.
No,
Do you know what the ground was? Do you know if it was smooth like a turf football field or frozen jagged like dirt tends to do in the Northeast during the cold winter?
I considered several different possibilities: grass, dirt, asphalt. So I considered several different possibilities to see in my differential diagnosis.
You considered all these different possibilities, but you never even went and looked at the scene to see what it looked like, did you?
I didn't have to.
Do you know if there was twigs or roots or a brush nearby?
I don't know.
Do you know if there was a fire hydrant nearby?
There was a fire hydrant
Do
nearby.
you know if there's a curb nearby?
That I don't know.
So you have no idea really, other than a fire hydrant, what this area of impact, alleged impact looked like, do you?
Well, again, a curb would not have caused those wounds. So that's irrelevant.
You have no idea.
I disagree.
Did someone tell you what it looked like?
No.
Okay.
And she did say that. Why can't you just say I ruled it out? She did. She did, but he's just hammering home on these other irrelevant issues. And
You said that you ruled out car accident or collision in part because there were no broken bones. Yes?
In part.
And we've
Except
agreed,
for, excuse me, except for no skeletal broken bones.
and we've agreed that car accidents are a dynamic process. Not all car accidents result in broken bones, do they?
That's correct.
It depends on how and where and a number of other factors in the collision. Yes?
That's why it was only one of the factors I used.
It's one of the factors you excluded. Do you know the difference in force between head-on collision and a side swipe?
I have a general idea.
Is there less force when someone is hit on the side of the car as opposed to being run over?
Is it supposed to be run over?
Yeah.
Generally, yes.
Right. And I'm sure in your thousands of treatments, you have treated people in the hospital who have come in contact with a car who did not have broken bones.
Oh, yes.
Plenty of times.
Excuse me?
Many times.
Yes, but they weren't dead.
What's that?
They were not dead.
Right. Okay. Well, you don't know when Mr. O'Keefe died that morning, do you? Do you know what time he died?
I have I have a range.
You didn't think he died from the abrasions on his arm, do you?
No, he did not die from the abrasions.
Okay. He died from a break in the back of his skull from hitting the ground, right?
Oh, he died from a skull fracture and brain injury and
Yes.
hypothermia.
Hypothermia.
And I want to make a pointer because I think that last comment was important. I'm just going to pull it up again one more time. Lisa, I know there are lots of people in the chat that are not like the prosecutor, but Jackson is just as ruthless, if not more. And the answer to that is yes. Jackson is just as ruthless. And there's everything that Hank Brennan is doing now is exactly what you're supposed to do if you're the lawyer for the Commonwealth. He's pushing as much as he can. And somehow he got Judge Cannoni to agree to allow him to ask this entire line of questioning. So he's doing his job. He's not doing any, I mean, you know, as a prosecutor in this case, you're trying to win, you're trying to exclude this witness. And once Judge Cannoni opened up that door, allowed him to ask these questions, there's nothing wrong with what he's specifically doing. I don't agree that the judge should have allowed that whole line of questioning, which again, I'm going to talk about more in my recap, but that was definitely, I think, improper. And now it just allows him to hammer home now. So let's be honest, you just don't really know, do you? And that's sometimes what lawyers do after this whole like strong arming and arguing with them back and forth. And then you'll say, so, you'll calm down your voice and say, so let's just be honest. You don't really know what you're talking about, right? And then sometimes people actually agree with you. And these are just great tactics. Anybody who wants to go to, to become a lawyer, trial lawyer, this is great. What he's doing is a good job. Again, I don't agree with the whole line of questioning that the judge should have allowed it, but what he's doing is very strong and ruthless. And that's why we're seeing that the defense is going to have a much different trial this time with Hank Brennan as opposed to Adam Lally.
Yeah, not from an abrasion to his skull.
Right. The abrasion for his arm had nothing to do with his death, did it?
It did not cause the death.
Okay. And so is there a difference between the force when a car hits somebody directly on or hits them on a side?
Generally, yes.
Right. And you've seen many times somebody has been in contact with the motor vehicle with no broken bones, many times.
I have seen that, yes.
I mean, there's a difference between being run over and hitting the side of a car, isn't there?
That's correct.
So if someone didn't hit them, they just clipped them, that might be different than being run over in the middle of the crosswalk in the middle of the car. Yes?
Yes, that'd be correct, but you have to put it in context.
So here's a question I'm gonna have to rethink. BC, are you ready to change your opinion of the judge being biased? Again, I think the ruling was wrong. Sometimes judges just don't know and they make a bad call and a bad ruling. Okay, so but to say that she's really rooting for the Commonwealth and she's biased towards the Commonwealth, I'm not sure if I'm ready to go there. I'm absolutely pointing out that it was wrong. I think it was improper. She made the wrong ruling. I've seen a lot of judges make a lot of wrong rulings, but I'm not going to automatically say that she's biased just yet. So, well, the jury's still out on that.
Now, you said in addition to your experience treating injuries, you also have experience as a police officer.
Yes,
Yes. And you responded to many car collisions as a police officer, didn't you?
I did.
And when you respond to car collisions, whether it's a pedestrian or another car, there are certain things as a detective you detect that are in the street, right?
As a detective?
Yeah, a detective or a police officer, you go to a scene
Mhm.
and there's a collision, you certainly see things often as a
Yes.
result of the collision, don't you?
Yes.
Tell us some of the things that you'll see as a police officer after a collision. What do you
Oh,
see?
After a collision, you oftentimes see debris from the car,
Right.
from
Debris
the
from the
vehicles.
car.
Yes,
You can see rubber, right?
probably. I don't know if I have, but yes.
Now, again, I don't think if this was my expert, if Dr. Marie Russell was my expert, I would not say to her to rely on anything that she knows when she worked as a police officer. I don't need you for that. All I need you for is to use your medical knowledge and experience and training and everything that you've read to diagnose that this was a dog attack. That's all. I don't need anything more. I don't need you to talk about when you were in law enforcement. And he's getting all this good stuff from her, maybe because she just wasn't prepared properly. But he's really getting. I'm telling you, he's going to have a field day with her right now. I don't even know what he's going to say because we didn't see it. But he's going to have a field day with her, and so would I, because you're going to use your experience as a doctor, as a police officer 25 years ago. Okay, let's talk about that. I mean, it's like just handing him some great lines for cross-examination. I'm sure that's what we're about to see. So buckle up.
Sometimes metal pieces, parts of the car.
Right.
And sometimes when there's a collision, maybe often, you see glass, don't you?
Yes, you do.
Yeah, glass breaks when a car collides with something, oftentimes, doesn't it?
Yes.
And so when you were doing this, engaging in this differential diagnosis, did you consider the circumstances, the physical evidence at the scene from where Mr. O'Keefe was found?
I considered the possibilities. Yes.
Okay, well, there's a phrase, getting knocked out of one's shoes. You've heard that phrase, right?
I've heard the phrase.
Well, you've heard the phrase in relation to car collisions, haven't you? A person getting knocked out of their shoes.
And other things. Yes.
Yeah, but not other things. We're talking about car collisions.
Okay.
That's what we want to talk about today.
Okay.
You've heard the phrase knocked out of one's shoes in car collisions, haven't you?
Yes.
Yes, because the force is so great when a car hits a body, it moves the body, and the shoe from friction on the ground can sometimes be left behind. Yes?
I don't know the actual causation, but yes.
Well, you did know when you review this case that at the very area where that car backed up and Mr. O'Keefe was found, one of his sneakers was found next to the curb on the street. You know that, don't you?
Objection, Your Honor.
Are you aware of that fact?
No.
Okay, next question.
You were never given any of the information, the physical evidence.
And again,
at
he
the scene?
assumed that he was hit. He said that in his question. So that's why the objection, and Judge Canoni allowed it.
Mr. O'Keefe was found to help you engage in this differential diagnosis?
I eventually saw reports.
So you do know. You do know about the sneaker.
I also, well,
What
I
about-
don't know that. I don't know where the sneaker was found. No.
Well, what do you know about the sneaker? It sounds like you know a little bit about the sneaker. Tell us
No,
what you-
I know that in hypothermia, there's a condition called paradoxical undressing, where people sometimes are found without their clothes and shoes,
Was
because
Mr.
and in this case, there was hypothermia.
Do you have any opinion that Mr. O'Keefe undressed his shoe before he died?
I have no opinion about that.
Do you have any information, evidence to support such a comment like that?
I'm just advising you that there is a phenomenon called paradoxical undressing. So that is possibly a cause.
In that phenomenon, does somebody take off one shoe and leave all their other clothes on?
It's possible they could, yeah.
Right, and you have a case that you've seen
No,
just like that?
I have not.
No? Okay. And so in this case, at what point did you learn that Mr. O'Keefe was knocked out of his shoe?
I don't know.
Objection, Your Honor.
Phrase it differently.
See, again, well, what point did you learn that he was knocked out of his shoe? Again, he's doing this because he's a good lawyer, but it's all completely improper. And the judge just and that was the objection. The judge actually said to rephrase it. So that one she got right.
At what point in this case did you learn that Mr. O'Keefe's body was about 7 feet off the street, fully clothed, not undressing himself, and that his sneaker was on the roadway right next to the curb?
Objection, Your Honor, state paper.
Did you learn that fact?
No,
Next question.
So as you sit here and testify today, you didn't know that?
that's correct.
When you're ruling out car collision in your differential diagnosis, wouldn't it be helpful to know a little bit about the physical evidence of where it was found at the scene?
Again, my focus is injuries. The injuries caused by car accidents, not the scene itself,
Right.
injuries. So, so that's what I focus in.
A dog wouldn't knock somebody
So the answer is no. No, I don't need that. That's the answer to that question.
out of their shoe, would they?
Excuse me?
A dog wouldn't knock somebody out of their shoe, would they?
I don't think so.
Okay. When you were excluding car collision as the cause of these abrasions, and you consider circumstantial evidence as a police officer, if there was trace evidence on that shattered taillight, would you want to know about that?
Yes, I would.
Yes. And DNA is a form of trace evidence, isn't it?
Yes.
It's a pretty sound piece of trace evidence, wouldn't you say?
Yes, if collected properly and chain of evidence, yes.
One of the most formidable pieces of scientific evidence that is used in medicine and science, isn't it?
In forensics, yes.
In forensics. And so when you used differential diagnosis and excluded the car collision as the cause of the abrasions to John O'Keefe's arm, did you know that there was DNA on the taillight of the defendant's car?
I did not know that.
Would you wanted to have known if there was DNA, particularly would you wanted to have known if the DNA on the taillight of the shattered taillight was John O'Keefe's DNA? Would you want to know that in your differential diagnosis?
That would be helpful. However, again, that the car accident did not cause that configuration of wounds.
And when you're considering the cause of the wounds and you're trying to rule out car accident, you know that that taillight had been shattered, leaving glass and jagged edges. If you had known there was John O'Keefe's DNA on that taillight, would you wanted to have taken a closer study of the taillight casing and the broken glass?
I don't think it was necessary. Those wounds are so characteristic of a dog attack.
Do you know there was other trace evidence on the back of Ms. Reed's car that morning?
Such as?
Hair?
No.
You didn't know that one of John O'Keefe's hair was left on the bumper?
No.
And engaging in your differential diagnosis, considering the mechanic of injury, wouldn't it be important to know?
And again, the question of that his hair was left on the okay.
So that the trace evidence coming from John O'Keefe was left not only on the defendant's car, but in the particular area where the damage to the car, the taillight.
Objection, Your Honor.
Were you aware of that fact, Dr. Russell?
No.
Next question.
When you were excluding a car collision as the cause, did anybody share with you the digital forensics, the black box information showing and demonstrating where the car was, the speed it went back and the distance? Did anybody share that with you?
No.
Did you know that John O'Keefe had a cell phone?
Not surprised.
And
By the way, if the judge is allowing all these type of questions, what I would do if I was Alan Jackson or Yannetti, Robert Alessi, I get up there with Dr. Morelson and say, Doctor, were you aware that Jennifer McCabe made a 2 a.m. search? How long to die in cold? Were you aware of that? And if there's an objection, I'd say, Your Honor, you just allowed Mr. Brennan to assume that he was hit by a car. Why can't we talk about all this other evidence pointing in the other direction that she was either aware of or unaware of? You can't have it both ways, Your Honor. If it's good for the goose, it's good for the gander. So, start asking all those questions. Were you aware about all these butt dials when you came to your analysis? Were you aware that the dog was rehomed? Were you aware that the house was never searched? Were you aware of all these things? Oh, you weren't aware of all? Okay, I just wanted to know if you're aware of it and all, because Mr. Brennan also wanted to know if you're aware about all these other issues in this case that have nothing to do with your opinion. But I guess I should also ask if you're aware of these things or not. I think that would be a good way to make your point. But we'll see. I wouldn't think Judge Cannoni would allow that, but I think that the argument can be made. Hey, you allowed him to ask all these questions about things that, is she aware of this DNA and hair and anything to do with, and that have nothing to do with her opinion. So why can't we ask these questions also?
do you know that at a certain point when that car left his cell phone, which was found near his body, never moved. Did you know that?
I read that, yes.
And when you were using differential diagnosis and thinking about the potential causes of abrasions in the arm, does it seem important to you that all these facts coincided? The car reversed, the damage, John O'Keefe on the ground, the phone under him.
Objection, Your Honor.
We're going along that question.
Did you consider those things, Dr. Russell?
As I mentioned earlier, I considered various possibilities of a car accident and a pedestrian accident, I should say. And I went through many scenarios in my head, and no car accident scenario could create that configuration of wounds that's on the arm.
You've done advanced studies on wounds related to car accidents and broken taillights.
I've seen thousands.
Have you done any studies? Do you have any journals that you rely on to say that there's a expected pattern that's going to happen when a taillight intrudes through a sweater and into one's skin?
I have, yes, there are many textbooks that I have relied on. It's a fundamental area of study in forensic medicine and emergency medicine. And in fact, the examination of the exterior of the body in a motor vehicle accident case is emphasized, and special lectures are given about that topic to the forensic doctors.
You never examined John O'Keefe's body.
By photographs, yes.
You never examined his body.
Personally, no.
No, personally, you never examined his body.
I never touched his body. I examined
No,
the
no, you
photographs that
didn't.
were taken in the hospital and in the coroner's office, medical examiner's
When
office.
you're treating at the hospital and people are coming in telling you there was a dog bite, you're relying on that reporter's history, aren't you?
Usually, yes.
Or an eyewitness who saw it and told you about it.
Correct.
When I asked you before when we were here the last time about any cases where you had to make a diagnosis without information, you couldn't point to one. I asked you to give me one example and you couldn't give me an example, could you?
I don't remember patients' names.
And so when you rely on the reporter as a medical expert, you take what they say, right? And you assume it's true.
Oh, not always.
I
No.
see. You
No,
look and see if it's
absolutely
not.
not.
Objection,
One,
Your Honor.
excuse me, one person speaks at a time.
Please.
Let her answer, Mr. Brown.
No, I don't always take what they say is true because there's many reasons why people do not tell the truth.
Did somebody ever come in and say it was a dog bite and you did differential diagnosis and pattern recognition analysis and determined they were lying, it was not a dog bite?
No,
In all the hundreds, thousands of cases, never has anybody reported to you a dog bite and you determined independently through your powers that it wasn't a dog bite.
not dog bites, but other wounds, gunshot wounds, stab wounds, many other kinds of wounds. People report that they occur a certain way and actually they have occurred a different way.
With respect to dog bites,
Mhm.
every time you've treated a patient, they've either told you what happened or somebody with them has told you what happened.
Or they didn't know what happened.
Okay. In this case, when you were excluding the collision as the cause of the abrasions on Mr. O'Keefe's arm, did you look at witness statements?
As far as I know, there were no witnesses to the event.
Okay, well, did you read the testimony of Officer Sarif? Because the witness who talked to him was Karen Reed. Did you read that?
Objection, Your Honor.
So ask the question differently, Mr. Brown.
Okay. Did you know that Officer Sarif reported that Karen Reed said, "This is all my fault. This is my fault. I did this." Did you consider that or know about that when you made?
I'm telling you, if she's allowing him to ask these type of questions, there is no reason in the world why the defense should not be able to ask questions. Did you consider that Jennifer McKay made that search at 2:00 in the morning? Did you consider all those things that I brought up before? I don't understand the difference. Maybe somebody can enlighten me why there'd be a difference between the questions that he's asking now about what Karen Reed allegedly told Officer Sarif to whether Jennifer McCabe actually did that Google search at 2:00 in the morning or not. And they can, and the prosecutor should be able to object all they want. Oh, well, that's a question in the case. Well, what you're also saying is a question, like it's so, look, if it's good for the goose, it's good for the gander. And this is absolutely what I'd be arguing if I was on the defense right now and I get up for redirect.
your differential diagnosis regarding the collision?
At some point, I did know that there was a statement like that.
Not like that. Did you know about this statement? This is all my fault. This is my fault. I did this. Did you know about this statement?
Objection, Your Honor.
Did you know that statement? I'm allowing the question.
No.
Let's move on.
Did you know
Mr.
about the statement to Mr. Fomati? I hit him. Oh my God, I hit him. Did you know about that statement?
Not that statement, no.
Did you know about the statement that she repeated repeatedly? I hit him. Did you know about that?
I learned that there was some question about whether there was a statement or a question, did I hit him? I learned that, but that doesn't,
Where
okay,
did you learn that from?
I don't remember.
Okay. You said that you had experience in domestic violence cases?
Yes.
Okay. Did you know that it's reported that the defendant and Mr. O'Keefe got in an argument shortly before this happened?
Yes, I know that.
When you were considering the cause of these injuries, did you consider Ms. Reed's statements herself to not just witnesses, but to the public, to national magazines and programs? Did you consider any of that?
I don't read the national magazines.
Well, would it help you if you knew she told Boston Magazine that maybe John hit the back of her car, telling her to stop, and then she ran over his foot, or she clipped him in the knee, and in his drunkenness, he passed out? Would that help in your differential diagnosis?
Objection, Your Honor.
I'm going all out.
It wouldn't help because those wounds were caused by a dog.
Well, if you believe that statement that she said about running over his foot and clipping him, it would help you conclude that it wasn't a straight-on accident, that it was on the side, right?
Objection, Your Honor.
I'm going to allow it.
Even if it were on the side, the car did not cause those injuries.
And we talked about when someone's hit on the side, they could brace or defend themselves, correct?
Oh, correct.
Right. And do you know that if John O'Keefe was standing up and his arm was bent, it would be about the same height as that taillight?
Yes, that I understand. I've been hit on the side. I know about side injuries, side swipe injuries.
Yeah, a clip. It's different, right? And so knowing that his height matches up with the taillight, what other evidence would you want to know before you excluded the taillight as a cause of injury? To be thorough, what else would you want to know?
Well, I see pictures of the fragments of the taillight, which I eventually did. And were there any pieces of metal that had the configuration, anything that could cause those parallel lines with the punctate injuries in between?
How about taillight fragments?
Yes.
Little pieces of glass, right? When glass shatters, it shatters randomly, doesn't it?
Well, it depends on what kind of glass. So
How about, I'm sorry, please.
it depends on what kind of glass.
I want you.
Well,
I need
motor
to interrupt
vehicle glass, a lot of motor vehicle glass is tempered glass, and that shatters a certain way
Okay.
and creates a characteristic injuries.
you. Okay. Tell me about your experience in Lexus rear taillight coverings. What is the pattern injury on that?
I'm not aware of any pattern injuries.
And are you aware when the rear taillight of a Lexus breaks, the different pieces it breaks into? Is it random or is there a standard in how it breaks?
I'm not sure, but I have an idea.
I'm sorry?
I'm not sure.
Did you look at any photographs of the scene in the debris field showing the different size taillight fragments at the very scene where Mr. O'Keefe was found on the ground? Did you look at any of those photographs?
I attempted to, but I couldn't see much detail.
Okay, so
Photographs were not good.
Okay, so you don't really have a command of what the debris field looked like relative to the taillight fragments that were on the ground that morning.
Again, I imagine various scenarios of what broken glass and taillight would look like. And again, I could not come up with any scenario that would cause those parallel marks and the pattern that we described.
Well, I don't need you to imagine a scenario. I only want to talk about one scenario. That's the scenario that led to the death of Mr. O'Keefe that morning. That's the scenario I'm asking you about. And the debris field that actually existed that morning. So what I'm asking you, when you engage in differential diagnosis and you take the position that this couldn't have happened, I need to understand what you actually know about the physical evidence that's at the scene. So that's what I'm going to ask you about, that scene. If you don't know, it's okay. But I want to ask you about that scene that morning. Do you know how many pieces of taillight were found on the ground where Mr. O'Keefe was found?
No.
Do you know the shapes and sizes of the shattered parts of the taillight that were found in that debris field where Mr. O'Keefe was found?
I've seen a picture of various safe pieces of taillight. Yes,
And if you've seen that, you would see that there are a number of different pieces of shattered taillight, yes?
correct.
Of different sizes.
Yeah.
Of different shapes.
Uh-huh.
Different diameters, right?
Yes, they're irregular, very irregular.
Different, irregular.
Yeah.
Irregular. Many of them sharp,
Yes,
perhaps almost all of them. Yes?
possibly.
Well, you say possibly because you never actually have looked at the physical evidence. You just looked at a couple of photos.
I looked at photos, correct.
And as far as the housing for the taillight, what is that made out of?
I believe it's made out of a plastic, and there's a metal around it.
It's metal.
Yeah.
What's the shape of the metal around it?
What's the shape?
Yeah, what is it, when you're describing the metal that you saw, what does it look like?
Well, it looked like there was some curves in it.
Curves?
Yeah.
Any straight lines in it?
Yep.
Yeah. Any jagged parts of it from the breaking?
Yes,
Okay. And inside, were there other parts other than just the casing, like wires or metal sticking out?
yes.
How many pieces?
I don't know how many.
Did you ever measure those angles or study the angles of the pieces of metal in the casing?
No.
And you never studied the angles or took measurements of any of the shattered taillight, did you?
No.
Okay. Now, sharp objects can cause puncture wounds, can't they?
Yes,
Sharp objects can go through clothes and tear a, no, let me finish, you can answer. Sharp objects can puncture a hole through something like a sweater, can't they?
They can.
And if that object comes back out, it can pull the threads back out with it, couldn't it?
Theoretically, yes.
Yeah. And a sharp object, like glass, can poke or push a hole in a tear in a sweater and then rub up against the skin, causing an abrasion, couldn't it?
And, well, yes. Yes.
And if the glass and the angles and the shattering is irregular, it could cause irregular type abrasions.
Not like that pattern. No.
That's not what I'm asking you. I'm asking you, can irregular glass that penetrates a sweatshirt or a sweater and rubs up against the skin, can it cause irregular looking abrasions?
Yes.
And if there's two pieces of metal or glass that are straight, could it cause a linear abrasion?
Yes.
Would you agree with this statement? In a car accident, linear wounds are most commonly caused by contact with shattered glass from the windows, particularly tempered glass, which breaks into small, sharp shards that can create linear cuts on the skin when the body impacts it during the collision. These are often referred to as dicing injuries in forensic medicine.
Yes. And so they're not really very long linear. They are tiny linear abrasions or lacerations.
Abrasions come in all different sizes.
Right. But the ones that caused by tempered glass are very, very characteristic.
Does glass cause a slicing pattern?
It can.
And it can cause a linear abrasion.
Yes, but there's a specific pattern with tempered glass.
I understand that you have an opinion.
Oh, no, it's fact.
Okay.
It's in textbooks.
Yeah, it's in textbooks that glass can cause linear abrasions.
The tempered glass pattern is in textbooks.
Glass from this broken taillight could cause linear abrasions.
That probably, yes, I agree.
Okay. So the glass that was in this debris field that you got a little look at, it had sharp edges, some of it, right? Yes?
Yeah, I
Yeah.
imagine so. I don't know for sure.
Do you know if it had parallel edges?
Parallel?
Yes.
I don't know.
Now, when you're looking for trace evidence to see if something caused an injury, you look for remnants of that evidence, don't you?
Yes.
In this case, you didn't do any study of the clothes and you didn't do any study of the actual Mr. O'Keefe's body, right?
I did not have hands-on
Okay.
study.
Um,
Correct.
But you did learn that there was something remarkable in Mr. O'Keefe's sweater, didn't you?
Can you be more specific?
I can. Glass shards or broken taillight plastic shards. You understand they were found in Mr. O'Keefe's sweater, right?
Doesn't surprise me.
Well, I know it doesn't surprise you, but the question I'm asking you is when you decided to engage in differential diagnosis and you decided to exclude collision as the cause of this abrasion, didn't you want to know all the facts and information in considering whether it was the taillight that caused the abrasion? Didn't you want to know that information?
Yes.
Okay. And when you were considering that information, did you know from the criminalistics reports that shards of that broken taillight were littered in his sweater?
I did not know that.
When's the first time you learned of that?
Right now.
Right now. And so when you've prepared for this case and you've received materials from the defense, nobody has ever sent you, ever, the criminalistic reports that show taillight shards were in his sweater where the abrasion was. No one ever showed you that?
I don't recall seeing that at all.
Oh boy. Wow. Talking about being a detective and using circumstantial evidence and trace evidence. I want you now to consider this new evidence that you didn't know before you testified at the voir dire in the trial in the first Lanigan hearing. I want you to,
I'm sorry.
So let's say the question first.
when you were ruling out the taillight as the mechanism of injury, when you excluded it in your differential diagnosis, and you said to a reasonable degree of medical certainty that these injuries that you looked at were caused by a dog bite. Now that you know that there's a debris field of shattered taillight right near the body of Mr. O'Keefe, and now that you know in his very sweater with the abrasions, the same arm under them, is littered with shards of taillight from that Lexus, does that in any way change your analysis in your differential diagnosis, excluding the car as the mechanic of injury for that abrasion?
Objection, Your Honor.
I'm going to allow that minus the police officer, the detective part.
No, it doesn't change my my conclusion that those injuries, those abrasions were caused by a dog bite.
How do you think the shards of taillight got into his sweater?
They could have got into the sweater from an accident, correct?
From an impact with the taillight, yes?
Could be.
Right. And when the taillight breaks and there's jagged, irregular, linear, sharp edges from that break, what do you think is going to happen to the skin when those shards impact the skin?
They could cause injury,
They,
yes.
they could cause puncture wounds, couldn't they?
Yes, they could,
They could cause scratches, couldn't they?
but not in that configuration.
I need to ask you the question so you can answer my question. They could cause scratches, couldn't they?
They could cause scratches.
And you have no studies on how abrasion looks after an impact with a taillight that is shattered. You don't have any studies or comparative analysis there, do you?
I have no studies. I just have my years of experience.
You know what wasn't found for trace evidence in that sweater? DNA of a dog.
I understand that.
You know when dogs bite, saliva, foam, sweat in their mouth, correct?
I also understand that there were issues with the collection.
Well, we're going to get to your claims and see if there's any basis for it. That's not the question I asked you, but I will invite you to talk about that in a second. Looking forward to that. What I'm asking you, you know when dogs bite, they can froth at the mouth,
Yes,
sweat,
probably.
yeah, saliva,
Saliva, yes.
right? And when they get active and aggressive, it increases the production of those viscous materials, doesn't it?
I believe so.
Yeah. Well, it's in some of those studies and reports and books you've studied all these years, isn't it? That's exactly what happens.
That they increase their production
Yes.
of saliva? No, I haven't seen that, but
Okay.
it makes sense.
And so when the dog bites a person, if they're biting through material, that saliva naturally could be embedded in the material, couldn't it?
Could be, yes.
Yeah. And something like a sweater, right? It traps liquid, doesn't it? Been out in the rain in the sweater. You don't want to wear a sweater in the rain. You'd be soaking all day, right?
That makes sense,
Yeah.
yes.
There was no dog DNA found anywhere on the holes in that sweater, was there?
No.
You understand that the crime lab took swabs of every one of those holes, right?
I don't know how many holes they took, but
Well,
yes.
before you
multiple.
discount or allege a conspiracy about DNA taint, wouldn't you want to know what they did before you criticize them?
I know that they took swabs.
Okay. Do you know that they took swabs of every hole?
No.
Do you know that they then packaged them and they tested and they sent them to UC Davis?
I know there was an interval of time
Well,
between the,
people are exonerated.
Your Honor.
Hold it, I just need to hear the answer. Next question. please.
People are exonerated decades after they've been wrongfully convicted based on DNA. Yes?
yes,
DNA lasts for a long time sometimes, doesn't it?
it can.
Okay. And so you know that the DNA or the samples that were swabbed from the sweater was sent to UC Davis. You know that.
Yes,
And you know when they did the analysis, there was no dog DNA,
right.
right, on any of those holes.
Right.
And you've opined.
Well, I guess I have to say something because please say something, Brother Counsel, to break up this harrowing onslaught. So actually, that's a lot of times you just make an objection when the other attorney is getting too good of a rhythm and he's really getting places and he's getting the expert to be uncomfortable. So you just call up, you just have to break it up. So you just make up an objection, even if it's not true, just to kind of break it up a little bit. Yeah, but I mean, he's doing everything that he's supposed to be doing. He's pushing it as much as he can. That's what you do as a lawyer. You go until the judge stops you. So all of the sarcasm, all of the intonation, everything that he's doing is exactly what the good lawyers do. So he's doing his job as the prosecutor. That's his job. That's what he's going to do. And as long as the judge lets him get away with it, he's going to continue doing it. That's what good lawyers do. They'll keep going until there's an objection or until the judge cuts them off. So yeah, it's getting uncomfortable for her, but that's exactly what he's doing. And when you say things like, "Oh yeah, don't worry, we're going to get to that. Don't you worry, we're going to get to that. I'm looking forward to that." That is, I've done that. All the good lawyers, that yeah, don't worry, we're going to get to that. You just take your time. I'm gonna slaughter you on that. So that's exactly what he's doing. He's good. That nobody's saying he's not good. He's very good. And but again, the range of where he's allowed to go is extremely broad, way too broad. But Judge Cannoni's allowing it. So here we go.
Find that these are bites, teeth going in and out of those holes all the way up and down the arm.
Yes,
Now, it is remarkable that there is no dog DNA on any of those holes in the sweater, isn't it?
again, there's an issue with the collection and transportation of that.
I'd love to talk to you about that. We're going to, but you got to get through my questions first. It is remarkable as a doctor, as a scientist, that there is no dog DNA in any of those swabs?
I just want to bring up this comment because, you know, we accept all comments. So I'm assuming you're talking about me. I'm not sure. But this quack sounds like Turtle Boy's assistant. I'm not sure if Turtle Boy would give so much praise to Hank Brennan. I'm not sure if he would do that. So I'm actually saying that Hank Brennan is doing a great job. He's doing exactly what the prosecution should be doing in this case. Again, legally speaking, objectively speaking, I'm telling you that this is too wide of a range, which Judge Cannone is allowing. Nevertheless, that's what we're seeing. So that sounds too much like I am Turtle Boy's assistant. I don't know what to tell you.
Holes. It's remarkable, isn't it?
Remarkable would not be the word I use.
Extraordinary.
No, I disagree.
Hard to believe.
I disagree.
Okay. Now, there is no dog DNA. Do you think somehow that hurts your cause or your case, for your opinion?
Objection, Your Honor.
Assistant.
Do you think that somehow challenges your opinion that there's no dog DNA?
No.
Because many times you've interrupted and tried to talk about a suggested or a supposed taint that doesn't exist. And I'm just curious, why is it so important for you to discount dog? Why is it so important for you to discount the fact that dog DNA does not exist on any of those holes?
Objection, Your Honor.
I'm aware of the multiple,
Again, I think that's an improper question also, but Judge is allowing it.
many of the steps that are involved in the collection, preservation, and transportation of evidence. And there are multiple places where that can go wrong. So the absence of the evidence is not as remarkable as the presence of the evidence.
What training and experience do you have with regard to DNA evidence? Your answer, not very much. Does that still stand today?
Correct. I've had lectures, but I'm not a DNA person.
Not very much, right? And so now you're suggesting, without any fact, that many things could have gone wrong.
Absolutely, with any specimen.
Right. So you're willing to come into court and just float an idea without a good faith basis of fact?
Objection, Your Honor.
Assistant.
What went wrong in the collection of this DNA? What went wrong in it?
I can't tell you what went wrong, but I can tell you that there were possibilities that there were errors at various steps.
Okay, well, if you want to claim and allege an error to demean or discount the evidence, tell us what the error was that happened with the production, the preservation and testing of this DNA. What was it?
I can't tell you the exact error, but there's, first of all, the decedent was in the snow for a while.
Mhm.
So it may have washed off some of the evidence.
What evidence do you have that it washed off?
I don't have any proof, but you asked me possibilities.
I didn't ask you possibility. You're raising possibilities. I'm asking you what evidence, what fact do you have that DNA was degraded or taken from that sweater because he was lying in the snow? What evidence do you have?
I don't have evidence. I'm considering different possibilities.
What about the preservation of it? What evidence do you have before you make such a claim that somehow there was an irregularity or a taint? What evidence do you have that there was something about the accumulation of this evidence, this item that was tainted?
I didn't say, or I didn't mean to say that there was a definite error in the process. I'm telling you that there could be. So that's why a negative finding is not all that remarkable.
When you're in a courtroom, you know as an expert witness and as a doctor, you can't spec.
So just to highlight this one, please be kind. No need to disrespect Brother Counsel. He's always fair and states his experience. Yeah, I state what I objectively believe and I'm watching based on my experience and what I know. I don't mind. People can disagree with me. I'm a lawyer. I have people disagreeing with me all day. That's what I do. We disagree. Me and the other side. I mean, that's what we do. So it doesn't bother me. It's okay. People have different opinions and I don't mind it. You can put in the chat. You can say that I'm a hoax. You can say whatever you want. It's not going to bother me that much. I'm just calling it the way that I see it, balls and strikes. That's kind of what I do. And if you don't like it, because I may say something that's favoring to one side or the other side, that's why people call me grifting, whatever. That's okay. You know, everyone can say whatever they want. That's the nature of this, following this case. It's very difficult to claim your objective. And then when you say one thing that can be possibly construed as favor to one side, then the other side will attack you. I mean, I'm used to that. That's what happens in all the trials. By the way, this is not my only trial that I'm covering. I'm covering a whole bunch of different trials. I'm covering the Adelson trial. I'm covering, I covered Ashley Benefeld, all these types of trials. Anytime that, you have people on both sides, you say something, people get upset at you, but that's fine. That's just the nature of the game. I'm still going to report to you based on what I see objectively as a trial lawyer. So appreciate the comment, but I don't mind if anyone wants to speak their mind and say how terrible I am.
Speculate. That's not a reasonable degree of medical certainty, is it?
I'm telling you, with a process, just like when blood is drawn from a patient, for instance.
This is coming from somebody who says they don't know very much about DNA. You're floating an idea that you have no factual basis for?
I'm talking about a specimen in general.
I'm not
Not,
talking about-
not, it doesn't have to be DNA specimens. Specimens in general there can be errors in the process.
But we're talking about DNA here because you brought it up last hearing. You suggested that there was an irregularity at the last hearing.
There could be. You asked, for an explanation why DNA was not found. Well, that's a possibility.
So when you're using words like something could have gone wrong, you're not suggesting in good faith, and in fact, that you believe something went wrong, are you?
Objection, Your Honor.
No, I'm going to allow it. Are you suggesting that, Dr. Russell?
I'm suggesting there's a possibility that something could have gone wrong.
But you can't tell us what that was.
No, there are multiple steps.
Tell me one of the steps that went wrong. Tell me anything.
No, I can't tell you definitively that anything went wrong on a particular step. I'm telling you that there are multiple steps where error can occur.
Not
That's
the-
all. So, and any physician, even not only scientists, but physician knows that not all test results are 100% accurate.
All right, let's wrap this up. So
Okay.
you've been through the UC Davis report.
Yes.
You've been through now you know there's a criminologist report and they swabbed all the holes, right? There is an absence of dog DNA. We agree about that, right?
That's what you tell me.
Right. And we also agree that you have no actual science, medicine, or fact to suggest that there was anything wrong whatsoever with the collection, preservation, and testing of this dog DNA.
I have no evidence. That's correct.
Okay, let's bring up this question because it's important to know. BC, can witnesses be disqualified based on qualifications or based on their opinions? Well, that's exactly what the Daubert hearing is for, to see whether Dr. Mae Russell is qualified and whether her opinions are based on sound methodology and research. That's exactly what this Daubert hearing is for. So yes, the answer is yes, they can be, and that's exactly what they're trying to determine right now.
I want to now turn to the actual exhibits and photographs and ask you some questions about the photographs and about some of the statements you've made prior about those.
Okay.
Okay. Can I have exhibit 5, please? You've seen this exhibit before.
Yes,
You've testified about it a number of times.
yes,
And you understand this is a photograph of Mr. John O'Keefe's right arm.
yes,
You've described different abrasions on that arm on different dates in court, haven't you?
yes.
I want to start from the left to the right. And although we haven't used numbers, I'm going to characterize it as a number so we know which wound we're talking about, so that we can discuss the different statements you've made about each wound. The wound closest to the shoulder, you see that wound?
Yes.
I'm going to call that wound number 1, if you don't mind.
Okay.
When you look at the wound closest to the shoulder, is it fair to say that you've given different versions or statements about what you think was the cause of that abrasion?
Not that I'm aware of.
Remember testifying in the voir dire in this case when you first came in before the trial?
Yes,
And you described that that is a pattern, saying there are 2 wounds with potentially a scratch in the middle?
yes,
Okay. And do you remember saying in that voir dire that they were consistent with teeth marks?
with teeth marks?
Yes.
I believe I do.
And do you remember when you first testified in this case at the voir dire, you said they could also possibly be consistent with nail marks?
Yes,
Okay. So when you were looking at this, and isn't this an example of no methodology in dog bite science? Because when you're looking at that, there's a very big difference between what teeth would have caused and what nails would have caused, isn't there?
no,
Teeth on a wound start with a puncture and then pull down, or the bottom teeth puncture and then pull up. Is that fair to say?
not always.
And a nail, a dog's nail shaped kind of like a horseshoe, right? The nail. And so when it pulls, it's going to leave a very different pattern than a tooth, isn't it?
Not necessarily. It depends on how deep the contact is between the nail or the tooth and the skin.
Suffice to say, when you first testified under oath about wound number 1, you expressed uncertainty whether it was teeth or whether it was nails.
Yes,
And so you didn't have any standard criteria to look at the wound to try to match up a comparative analysis. There's nothing specific where you would have a standard where you would say, well, this is what I would need to determine it's a nail, and this is what I need to determine it's a tooth. You didn't have that, did you?
There is none. And in the literature, authors have mentioned that it's very difficult to tell the difference between a claw wound and tooth mark sometimes.
When we look at wound number 1, when you originally said it was either teeth or nails, you then testified at trial, and you said the same consistent thing at trial, that this could either be teeth or it could be nails.
Would you repeat that?
After the voir dire, you said that this wound, number 1, could have been caused by a dog's teeth or a dog's nails. You then testified a few days later at trial. And you said the same thing, didn't you? That this wound could have been caused by teeth or nails.
May I look?
You don't remember?
It sounds right.
Okay. Well, I want you to look and be sure. It is trial transcript, page 20, line 3.
And I would agree with Jessica here. If this is any indication of how the trial is going to go, it's going to be intense. It is. I've been saying this from the beginning. I think we're going to see a very different trial the second time around.
Page 20.
Question is when?
Dr. Russell, do you have the same transcript as us?
Yes.
Okay. When you were talking about the number of patterns, you started with the upper part of the arm. You talked about the parallel lines, and you said they were inflicted by either teeth or claw marks.
Line 3?
Well, start at line 3. Teeth or claw marks is actually line 5.
Line 5 says the word photographs here.
Okay. You must have a different version. Yes?
Are you talking about the trial?
I am, so you have a different copy than we do. My apology.
20, line 3?
I'm going to have to show him my copy only because there's different versions of the transcript going around.
All right,
It's not
so
going to reconcile.
what I have that Mr. McDermott copied on the trial transcript is what you just read from page 20, starting at line 3.
And that's what we have, but it's not the copy that Dr. Russell has. So if the court would allow me, I'll show her my transcript.
All right, I thought Mr. McDermott's copy went to Dr. Russell. Okay. Sure, go ahead, Sherry.
I mean, I believe one copy has a sidebar and one copy does not.
Okay. Okay.
Do we have a second copy of this trial transcript that I can give her? Sure. Thank you. Here you go. So at trial, you similarly said that this was caused by either teeth or claw marks.
Yes.
Okay. And so there was obvious uncertainty by you whether this was teeth or claw marks. You testified before the.
Yes.
You told counsel when you had your direct examination on the last case that between the time of the trial and between your testimony at the first hearing and this Lanigan hearing, you had not reviewed any further materials.
No, I don't think I said that.
Oh, you did review further materials,
In the process of writing my report,
which Mr. Lisi helped you with, yes?
Objection, Your Honor.
in the process of writing my report, I did review articles. I re-reviewed the photographs, and and my opinion even, became a little clearer.
So when you testified in front of the first jury, expressing an expert opinion, you weren't very clear?
No, I was certain that these were either teeth or claw marks.
Okay. But things have evolved, haven't they?
Yes, I have, in the course of reviewing and also being challenged, I'm being challenged. I needed to re-review everything. Yes, things have evolved.
So things have changed.
Changed? No,
Well,
it's one of the, I said teeth or claw marks.
well, it's not one or the other. You're supposed to testify with specificity.
Again, in the articles, in the literature, medical peer review literature, it's mentioned that it's very difficult in some sets of marks to determine what's a claw mark and what's a tooth mark.
So based on your reading of the literature that tells you it's very difficult to distinguish, you nevertheless then come into the hearing and you change your testimony and distinguish, because what you said now at the last hearing is this wasn't claw marks. Your position now is that these were teeth marks, not claw marks.
I also mentioned that I saw some punctate wounds up here, these two little wounds up there, and that helped clarify.
That picture hasn't changed since you looked
Yeah.
at it before voir dire.
Perhaps I didn't see them the first time. They're very faint.
You made a mistake.
No,
Oh.
either teeth or claw marks included, both of those.
So because you overlook certain things, your opinion you gave to the jury was not an accurate opinion.
At the trial? Is
Yeah,
this
at the trial.
Is this the trial?
Yeah.
This is the trial. It isn't accurate. It's
Well,
either
the-
teeth or claw marks.
Well, that's not what you're saying now. Now you're saying it was teeth, not just teeth. You're saying it was canine teeth.
Yes, I believe now
Right.
that they are more likely canine teeth.
Well, you didn't say more likely. You said to a reasonable degree of scientific certainty.
Well-
Is it more likely or is it to a reasonable degree of scientific certainty?
Reasonable degree of medical certainty.
Is that what you're saying?
Yes,
To a reasonable degree of medical certainty, those are now dog bites.
those are, teeth marks.
These right here.
Correct.
All right, and to a reasonable degree of,
It's my opinion that to the reasonable degree of medical certainty, those are marks made by teeth.
and the teeth that you claim that these are now made are the canine teeth.
Yes, I believe so.
Well, not you believe so. I want to know if you're certain about this, the medical certainty.
Yes, to a reasonable degree of medical
Okay.
certainty, those are made by canine teeth.
Okay. And so your opinion from the time when you first testified at trial, the opinions you gave to the jury, it's now different.
I don't see it as different.
Okay. What else did you overlook in this wound when you first gave your opinion to the jury? What else did you miss?
I don't think I missed anything. There's another abrasion in the middle.
Well, no, we're not going to move on. We're going to stay right here in one until we're done.
Excuse
Staying
me. I
on
mean,
this-
there's an abrasion right there in the
Right.
middle.
What's that caused by?
It could be caused by one of the incisor
Well,
teeth.
when you say it could be, I want you to use science and not just speculate. How many incisors are on the top row of a healthy dog?
6.
And the bottom?
6.
Okay. And if a dog has healthy incisors that are not irregular, that are even, you know it's not going to have one incisor leaving a scratch and the other one's leaving no mark.
No, I disagree with that. It's very possible. Skin is very elastic,
Mhm.
and teeth are not always the exact same
Right.
height and have the exact same configuration.
And if they're irregular, one's bigger or missing or there's a gap, it could leave an irregular mark. Could,
It could.
but you don't know that. You don't know anything about the dog that is claimed to have caused this wound, do you?
I don't know about his specific teeth. No.
And do you know whether there's any irregularities in Chloe's teeth that would cause this irregular scratch by the incisor in the middle and leave out any other marks?
Even if there were no irregularities, the fact that skin is elastic and that that
By the way, you see what he did there also? I mean, he mentioned Chloe. Now, her testimony was not that it's from Chloe. Her testimony is that that was a dog. But he's pushing Chloe into that equation to make her sound a little more silly. But that's just something you got to be on the lookout for.
could mean that not all teeth made contact.
Do you know anything about Chloe's incisors on the top and whether there's any irregularities or missing incisors? Do you know?
I don't know.
Would it help you to know that?
It'd be nice to know, but
Well,
but
when you say
I don't
nice,
need
when you say nice, is that a medical term of yes, it would be helpful to know that?
it could be helpful.
And so when we look at wound number one that you now say is a bite mark, not a scratch mark, caused by canines, how many canines do you think caused these two linear lines?
I believe that those are caused by 2 canine teeth.
Okay, so did the canines teeth start at the top and work their way down, or did they start at the here and work their way up?
I can't say.
Or wouldn't you, if you're going to say the canine teeth, wouldn't you want to look at the wound and see where the puncture starts and then where it tears from? Wouldn't you want to know that?
You know, excuse me, there is no puncture.
Uh-huh.
There is no puncture in this one.
Right.
And by the way, just so you should be thinking from the other perspective. Okay, so he's pointing out, how can this be? You see that faded line between those two lines all the way on the left, right? So he's saying, wait, how did that get there? I mean, if this is a bite, how is it that the 2 teeth are really deep and the middle tooth is not deep at all? I mean, like, how does that happen? I mean, come on, if this is a bite, all 3 are going to be the same size, unless there's some crazy deformity in their teeth, right? And she's saying back, well, no, because skin's elastic, so skin can move around, But again, if you use the same type of argument with the car, and you say, well, let me ask you this question, doctor. I mean, assuming this was a car accident, is there any way to explain, just as well as you had this problem of how to explain that this would be from a dog biting, wouldn't you have the same exact problem with a car hitting that person's arm? Wouldn't that also be the same exact problem that you have? And remember who the burden is on. The burden is on the prosecution to prove that this was absolutely a car. Well, who is going to testify and explain to the jury that these 3 marks were put there by a car and how it was possible that 2 of them are deeper than the third one? Was there any witness at all that testified to that? And is there any witness that is going to testify to that? So if I'd be the defense, I'm making a note about this argument right now and making a note that if they try to argue this, if Hank Brennan tries to argue this, that there's no way that this can be a dog, because how are you going to explain that? I would flip it right back and tell the jury, how are we going to explain, how did the prosecution explain if this was a car? He's so bent on, oh, that she's not believable because it couldn't be from a car, from a dog, because he got these 3 marks. Well, then I asked the prosecution, what was the expert testimony who came here to testify that this was from a car and explain to you this pattern of abrasions? Did anybody do that? No. Well, then that what does that mean? That means that they didn't prove their case, does it? So I'm just letting you know. Again, I'm just putting myself into that position that you got to be, Hank Brennan's doing a great job trying to debunk our opinion, but then you can completely and totally flip the script. So that's something that I'd be making a note of right now if I was the defense.
And when a dog bites, the bottom jaw with their canines grabs and anchors, and then the top pulls and tears. That's how a dog bite works, isn't it?
Sometimes, if both the upper jaw and the lower jaw actually make contact, but not always do both jaws make contact.
It's a 3rd-prong lever, a jaw, the way it works. It traps and pulls. Yes?
If there's contact, yes,
Right. And so
with both jaws.
most animals don't just bite with their top teeth and drag.
It happens quite a bit.
What happens with frogs, right? There's
I don't know anything
vertical
about
in the area.
frogs.
It doesn't
Right.
happen with dogs. Dogs bite and pull.
They try, but they don't always contact with their lower jaw.
Did you look at the underside of Mr. O'Keefe's arm to see if there was any punctures or abrasions as an anchor that would allow the top canines to pull on this?
I did.
Yep. And what'd you see?
I didn't see them.
And so what would have had to happen in your version of events is that the dog would have had to not create a puncture, but just scrape with its top 2 canines and not anchor into anything else.
That happens often.
Uh-huh. And you can't tell whether the canine started here or started here.
That's correct. I'm not
Right.
sure.
Well, here it's not a puncture, but it's a rounder wound. We're still on wound number 1. The right linear abrasion is wider and rounder, isn't it?
It appears to be.
Okay. And this is a little more narrow up here than it is down here.
Correct.
Right? But there's no way the canines from the top mouth could have started here and worked their way down here. There's no way that could happen, right? Because this arc would mean that the dog's mouth is backwards. The dog's mouth is backwards if it went this way.
I'm not sure I'm understanding what you're
Yeah.
saying.
You see that this here, 2 teeth,
Mhm.
if the dog's canines started here and worked their way down this way, they don't line up. They're not even. It's backwards.
It would be an odd configuration.
Well, odd. It would be like Ripley's Believe It or Not. The dog would have to have their teeth the opposite way.
I could see how that could happen.
Really?
Yeah.
Okay. And these 2 scratches, there is no puncture, you say. You don't know what direction it's going in. There's no anchor on the bottom. But yet, your opinion is that these are dog bites.
I believe they are, yes.
Based on just simply looking at them. And you've seen something before in your experience that makes you think it looks similar.
Again, based on my 30 years of experience.
But you don't have any comparative sample or any type of model where you're looking at this and matching up particular point of interest with specificity, like a fingerprint, a swirl, or a whirl. You're not looking at this and saying, well, this is endemic of a dog bite or a canine. There's nothing about this that is particular or specific.
The pattern is fairly specific. It's highly specific, actually.
This pattern here
The
can only
pattern
be
of
caused by.
the whole configuration, the whole arm.
Let's start with this one, though.
Yeah,
There's
but you have to
nothing-
take things in context.
We're going to go through all of them, then we can talk about all of them in context together. Because I know what you said at the last hearing, but I'm talking about these. There's nothing about these that are particular or specific or endemic to a dog bite. Is there?
If the arm only had those 2
Right?
abrasions,
Uh-huh.
yes, it would be extremely difficult to say that those were dog.
Well, it's not difficult. There would be no objective evidence that it was a dog bite. It wouldn't just be difficult. It wouldn't be accurate. There's nothing about these. It's just dog bite. There's no puncture. The abrasions consistent here. They're different.
There's a
Objection, Your Honor.
Part of you shouting objection adds to the overlay.
What would you like to
So
do?
if you start to stand and say object, that's fine. Dr. Russell, you finish your answer, and Mr.
I'm bad?
Brennan, wait until she finishes her answer before your next question.
I can see the court.
Okay, we'll speed this sidebar up. Oh,
I'm going to counsel sidebar for a minute.
oh, going back to sidebar. Speed that up. And yeah, Hank is kind of testifying. This is what lawyers do sometimes. They try to kind of testify for the witness, and we'll do that. We'll say, you know, it's not this, isn't it? You know, and that's part of their what they're trying to do. That's part of what you're allowed to do in cross examination. Kind of, you're kind of allowed to lead, and a lot of this, by the way, from what I remember, Judge Cannoni did not allow a lot of this type of cross examination in the last trial. She didn't allow the sarcasm. She didn't allow so much fighting with the witness. You know, it was very limited on what they were allowed to do during cross examination. You see that sidebar with like what was that 2, 4, 6 attorneys there? I usually got two or three attorneys there. So okay, going back.
All right, support, please.
Are we taking a break? It looks like we're taking a break. The judge's taking a break. Judge Cannoni, at least. Anybody gonna say how long the break is? Guess not. All right. Well, I guess we're in break for now. I think it was a good break. Probably everybody needed a break. Yeah. Yeah, I got to agree with that. About 4K an hour, at least in that corner. Yeah, you got to imagine something like that. I don't remember what Brennan's getting paid. Was he getting like $350 an hour or something for this trial? $250, $350? It was. I thought it was public. I'm not exactly sure. I'm sure he's making decent money on this, and you know, like I said, he's doing a good job. I mean, it's exactly what he was hired to do. He's doing it. That's how we're going to see a different trial. So we're going to take a little break. I'm going to keep the chat up. I'm going to step out for just a minute, and we'll catch you back here.
So just, you know what, is there any media that stepped out that's not yet? Yeah, Ted. We're not even, can you get a few of them? We just want to talk to you briefly. They're,
They might be in the hall right there.
well, why don't we make an announcement for the media today? You're not in trouble now. That's what they always say when we're in trouble. You're not recording us, are you?
No.
Everything's off.
You have an attorney? You have an attorney?
Not yet.
They can't afford this,
Why don't you appoint this for you?
Yeah, just record, yeah, please, thank you, Counsel.
Come on.
Well, looks like we're coming back.
All right, Mr. Brennan, whenever you're ready.
Thank you. I think we had exhibit 5, please. Thank you. Dr. Russell, we were talking about these 2 scratches or abrasions as wound 1. I want to continue asking some questions about wound 1. And I had asked you, now that your position is that these were caused by the canines of the dog, was it the upper or lower canines?
I can't tell 100%.
Well, not 100%. What's your opinion? Are these upper or lower canines?
I believe they're upper canines.
Okay. And why do you believe these are upper canines as opposed to lower canines?
Because when the mouth of the dog opens and attacks, it's usually the upper canines that grasp first.
And you're saying because there's an absence on the other side that this must be the upper canines? Is that your logic?
I'm saying because it's usually the uppers that grasp first.
There's nothing in methodology or comparative study that would tell you that these are consistent with upper canines. You're just deducing that based on there's only one pattern instead of 2?
There's nothing that makes it definitive, correct?
Well, not just definitive. There's no cues. There's no clues. There's nothing here that says to a person or even an expert that these are caused by canine teeth.
Well, the other consideration is if the victim was trying to defend himself, it's the upper canines that would impact first on that surface of the arm.
What if the victim was defending himself from a 6,000-pound car? That'd be a different type
I
of
don't
wound
believe
than
this is, this is not caused by a car. I
So
don't believe
what
so.
evidence you have that the victim was defending himself, which caused the shape of wounds?
Again, it's very common for someone who's under attack to take their arm and flex it in front of them to protect their vital organs, the
Okay.
neck, head, face.
So if Mr. O'Keefe is flexing his arm to defend himself, that doesn't answer the question, what identifying feature with specificity in these support any conclusion that it was a canine tooth that caused either of them?
Well, first, in general, it's the canine teeth that are going to impact because they are much longer than the incisor teeth.
Right. The question I have is, look at these 2 scratches here. What objective evidence do you have based on methodology, comparative analysis? What evidence do you have that either of these were caused by a dog tooth, a canine?
Again, the methodology is that I looked at the overall pattern of the wounds on the arm, not just those 2 wounds up by the shoulder, but the overall pattern.
So your testimony is, if I look at everything together, I can have an opinion. If I look at this separately, it means nothing.
If I look at it separately, I cannot be as definitive, correct?
Well, not as definitive. I'm asking you for an opinion. You don't have any evidence that this has any relation to a dog bite. Without looking at the whole arm and giving that general opinion we'll get to, you have nothing as far as facts or comparative analysis or studies that would say that this was caused by canines on a dog, do you?
It's consistent with 2 canine teeth. There's a distance between those parallel marks.
Did you measure the distance between where this begins or ends, because you don't know, and this begins or ends?
I would have loved to,
and
but
if I could just finish, I'm sorry. Did you measure the distance between this and this and this and this?
I could not measure it because there's no ruler in that picture.
You know that when a dog bites, the canines don't move. Unlike paws that might open or close, the teeth stay the same distance apart, don't they?
Correct.
There's nothing that you know of in any dog science that canines, when they bite, they open or close, they get wider or more narrow. They're always the same distance, right?
With it, for that dog, yes.
Right, that dog.
Assuming that they're healthy teeth, yes.
And you don't know if they're healthy teeth or not because you never looked at Chloe.
Correct.
Okay. And you're not saying there's any punctures anywhere in here, are you?
I don't see a definitive puncture.
Well, do you see a puncture that's not definitive?
At the very lower aspect of the photo, this area is not well defined.
So you're saying this is possibly a puncture?
I can't rule it out by that photograph.
Well, couldn't you rule it out through other analysis and evidence? Couldn't you rule it out as we just spoke about? Because if this was the puncture, that means the bite is going this way. And if it's going this way, the arc is in the total opposite direction. Couldn't you rule it out just on that?
I couldn't rule it out, but it certainly makes sense that it would not, that the punctures would not be down below.
Well, does it not make sense? It makes no sense that it would go this way. It wouldn't be going up if the dog has an arc going this way. The arc would have to be this way.
It depends on the position of the victim.
A dog arc is not going to change depending on the position of a victim.
No.
And the dog's canines are not going to move depending on the position of the victim.
That's right. But if he's bending over and depending on the position of the arm, the wound can change. The wound can have a different appearance than what you would expect.
Okay. Let's move on to number 2, which I'm identifying as these 2 linear scratches and then the scratch on the bottom. You've testified about this wound number 2, although you didn't characterize it as wound number 2, right?
Yes.
Okay. When you first testified under oath in the voir dire about wound number 2, do you remember what you said that you thought that might be?
I believe I said bites or scratches.
Teeth or claws, right?
Yeah.
Okay. Now at trial, did you change your opinion at all about teeth or scratches?
I'm not sure.
Do you think you said at trial that this was not scratches, but most likely teeth?
I may have said that.
Okay. And then you testified at this hearing, didn't you?
Yes.
And now definitively you're saying this wasn't scratches at all, it was teeth.
Definitively, I cannot say that. They
Okay.
still could be scratches. There's a possibility that 2 adjacent nail marks made that.
So you're saying this could be nails or could be scratches? I mean, this could be nail
Bite
scratches
or-
or could be teeth?
Yes, there's a possibility that those could be scratches.
When you were asked on direct examination, that wasn't your testimony, was it? I turned you to page 101, line 13.
On what day?
I'm sorry, the last hearing date is the thickest of the 3. Yes, it's page 101, line 13. May I approach and help you on that?
Yes.
One.
It's the thick one.
By the way, there's nothing like when you're cross-examining a witness and you're being all tough and you're being sarcastic, and then all of a sudden, like, they need help with something, and you say, "Oh, sure, no problem. What can I help you with? Oh, sure, no problem. I'll give you the transcript," and then you apologize, and then when you get back to the witness the podium, you go right back into your cross-examination. It's just something that I enjoy also. But that's what he's doing.
Okay.
No, that's the wrong site, so we're gonna, you got that one. At that hearing, when you last testified, did you say that teeth made those marks? You were unable to say which teeth, but it was teeth?
Yes, I believe I did.
Okay, so your position from the voir dire and from the trial testimony changed regarding this wound when you last testified at the Lanigan hearing?
I still think that they are probably teeth, but I cannot 100% rule out scratch marks.
Did you say something like, I'm not sure exactly what teeth made these? One of them could, one set of these could be canine, one part of this and an adjacent incisor tooth, but I'm not sure on the second set.
Again, it goes to the fact that that's the wounds are not very specific for differentiating between between teeth and claw marks. However, it's in the setting of a pattern, one can get a whole lot more information, and that is supported by the articles.
So getting back to wound number 2, when you described this for Mr. Alisi, he suggested to you, so even though you may not be able to identify the specific aspect of the dog dentition, you're able to identify this is from some aspect of dog dentition. Is that what you're saying? And you said yes. So you were saying at the last hearing, this is from dog dentition.
Mhm.
Dog dentition is different than toenail marks.
Paw marks, yeah.
So your testimony
Yeah.
that you offered the jury in this case was different in regards to wound 2 than the testimony you offered the court at the first part of this hearing.
The jury?
Yeah, the jury. When you testified at trial, you said it
Right.
was claw marks or teeth.
Uh-huh.
You said at the last hearing this was dentition, teeth. So the opinion has now changed.
I think for the most, well, I'm sorry if maybe I made a mistake.
I don't think so. I think your opinion has changed. You said this was either claw marks or tooth marks. You weren't sure. There was uncertainty at trial.
Uh-huh.
At the Lanigan hearing, when you were asked by Mr. Alisi, he asked you specifically if this was dentition, and you said it was.
Objection, Your Honor.
Okay, so ask the question differently
Okay.
without the commentary.
You're saying now this is not scrape claw marks or toenail marks. This is by teeth, dentition.
I actually think it could be either.
Okay. Now, would you agree that is different than what you said the first time you testified at this hearing?
It sounds like it.
So you've gone back and forth kind of a little bit.
It's not a definite, it's not in and of itself, that set of abrasions is not definitive.
Well, you didn't offer the jury the opinion that they weren't definitive or that you had confusion, did you?
I'm getting a little confused because at the jury, you told me that I said it was one or the other.
Right. And then you changed to it was dentition, and now you're back to claws or teeth?
I think it's still teeth, but yeah, I can't rule out the claws.
Okay. And because you have no comparative standard, you don't have a standard industry where you can look at this and say it has 6 points of contact or 6 features of similarity. You don't have anything like that. You're simply relying on your personal empirical experience.
Well, no, I also saw these 2 punctures, the punctate wounds right there. And that made me think that it was more teeth than claw marks.
This here you're describing
Yes.
as punctate?
Punctate,
Now,
yeah.
you never got the benefit of seeing Mr. O'Keefe, did you?
Personally, no.
Did you know he was Irish? Light skin,
Makes sense with that
Yeah.
name.
freckles, moles. Look at these. They're all over his body. You don't think the dog was puncturing up all over here, did you?
No,
Right. So these are the same. These little things, these skin blemishes, same as these all over the body.
oh,
Aren't
you're a
they?
doctor?
There's no question.
Do you think that what you're describing as dog puncture wounds, you could be mistaken for just his skin and the different types of marks on his skin, like freckles or moles?
I don't believe so, particularly since they're right where those wounds are, the abrasions are.
Well, wouldn't the skin blemishes be there before any abrasions?
I haven't seen a picture of him before this incident.
Okay. So to get back to, we're now at, this is either a dog bite or it's a scratch. What is it about the top 2 that tell you it's a dog bite?
Would you rephrase that? Or, I mean, would
You're
you say it
saying-
again?
You're saying these are either dog bites or scratches. That's what you're saying. You're not
Mhm.
sure which one, but it's definitely a dog. That's your position.
Yes.
Okay. What about these 2 are telling you that this is a dog bite?
I think I said it already previously, that they're parallel lines that seem to have these punctate lesions associated with them. And they're in and around the other lesions, I believe, are dog bites.
When a dog punctures and pulls, there's not an island of skin and then it goes back to the pole. The puncture starts at the pole and then it goes to the bottom, doesn't it?
There are no complete puncture wounds on this arm.
Well, you just cited puncture wound as the reason why you think this was a dog bite. You said these aren't these are not a skin condition, rather they're puncture wounds, and that was the basis for saying these are bites.
No.
If you don't know if these are puncture wounds or not, how can you say these are dog bite?
First of all, I did not say, with all due respect, I did not say they were puncture wounds. They are punctate lesions.
Okay. And so
They're different.
the punctate lesion, is that caused by a tooth?
Yes, I believe it is.
And you know when a dog punctures, it then tears and pulls.
Only if they penetrate the skin. They have to penetrate in order to pull,
Okay. And the
to create a laceration and pull.
and a puncture is not a penetration?
A puncture is, a punctate lesion is not.
And so what about these two linear abrasions? What science, what comparative analysis, what evidence do you have that these are caused by teeth
It's part of the pattern,
of this whole pattern?
of this whole pattern.
But just like wound number one, independently, this doesn't tell you anything. You can't give an opinion to a reasonable degree of medical certainty that this was caused by a dog standing on its own.
By itself, it's consistent with, but yes, I cannot say by itself that it's caused by a dog.
Okay.
That
And this-
lesion by
and-
itself.
And there's nothing about these scratches that are consistent with the horseshoe shape of a nail of a dog, is there?
You mean the horseshoe shape of the jaw?
No, the
of a
dog's nail, the dog's nails,
paw nail,
toenail,
toenail?
yeah.
There's nothing specific, no.
So again, to have any real opinion to a medical degree of certainty, you need to look at everything together. You cannot look at this and tell us any specific identifying feature that would support an opinion or conclusion to a degree of medical certainty it was caused by a dog bite or a dog scratch.
Mr. Brennan, that's the way medicine is. You know, in medicine, you don't just look at one complaint or one wound or one test and make a diagnosis. You usually need several supporting tests or other lesions to corroborate a diagnosis. So that's part of medicine.
So you would agree with my statement, what I just said?
Would you repeat it?
Of course. So there is nothing specific with regards to these three scratches in and of themselves, without looking at the entire arm. There's nothing about these three that you can say with specificity that supports an opinion that they were caused by a dog bite or a dog scratch.
I disagree. I
Okay.
think the combination of the punctate lesions right there and there,
Mhm.
along with the linear parallel abrasions, supports that assessment.
Do you have any papers, any studies that show that a scratch like this, that would look like this, is a dog bite or a dog scratch based just on the appearance of these three scratches?
Just on the appearance, no. Usually the studies that I've read have pictures of multiple lesions, and in those pictures of multiple lesions, there may be lesions like this, individual lesions.
You can't tell, in your opinion, these are dog bites or dog scratches. So is there anything specific about them that can lead you to a reasonable conclusion, to a reasonable degree of medical certainty that these were caused by a dog? Putting aside the whole panoply of scratches, these here, what about them is unique and distinct?
Objection, Your Honor.
I'll allow just that, because it's been called two.
What about them?
Okay, again, they're consistent with dog bites and scratches, and together with the overall picture of the numerous wounds, it paints a picture that makes me sure that this is from a dog attack.
Okay, I won't ask again, but I wasn't asking about the overall wounds. We're going to get to that. I was asking just about these three, but I'll leave your answer as it stands. Let's move to wound number 3. Now, wound number 3 really is a collection of scrapes, and you gave some testimony about the first two. So if we look at 1, 2, 3, 4, 5. So in wound 3, we have 5 larger abrasions on the top of the elbow. You see that?
I do.
And then you see a couple of dots down here. Yes?
Yes.
And I want to ask you some questions. And what I'll do, even though this is wound 3, I'll talk about scrape 1, 2, 3, 4, and 5 so we know what we're referring to. Is that fair?
Yes, but
Okay.
again, any one little tiny part of the component of the image or wound is, it's not going to be sufficient to make a diagnosis. I need the pattern.
You never recognized that in your voir dire testimony or in your trial testimony before the jury that you needed the collection of all abrasions to have an opinion. Instead, isn't it fair to say that you were talking about individual wounds as if they stood on their own?
I believe that
Objection, Your Honor.
Can you answer that? I'm gonna
that
allow
is
if you can
unfair.
answer.
That's incorrect.
It wasn't until Mr. Alisi directed you that you started talking about dog attack and collection of wounds as a whole.
That is incorrect.
Okay. So looking at these wounds, wound number 3, and I know it may be a series of wounds, it might not be one wound in your opinion, but let's talk about this collection of abrasions, okay? Do you remember in the voir dire talking about this collection of abrasions and you were saying they were consistent with teeth or claw marks?
Okay.
Is that what you said at the voir dire?
I'd have to look again.
Okay. Well, why don't we look at page 38, line 13?
Mine is gone. I don't have a board there.
Okay. We'll have to get you one.
Yes.
Thank you.
Thank you very much. Yes, it's 48, line 13.
What page?
That one's not right either. No. Okay. Well, let me withdraw that question. Did you testify previously that these are consistent with teeth or claw marks?
Did I testify when?
Previously.
Possibly, yes.
Okay. And do you have a different opinion today whether these are teeth or claw marks?
No.
So you think that these could either be teeth or claw marks?
I think they're more likely teeth marks.
Which one of these 5 do you think are teeth marks?
All of them.
You think all 3 are teeth marks? Do you think a dog bit Mr. O'Keefe and inflicted these at the same time or different times?
I believe that this was this configuration, this collection right
Yes.
here. I
Yeah,
believe this is one bite.
one bite. And so if we were to follow your theory, this was one bite, this would be the arc of the dog's mouth?
Yes, it could be.
Well, is there an arc here?
There appears to be.
Okay. And we know that when a dog punctures it, then from the top teeth pulls down, the bottom pulls up, right?
Push it.
So if this is the arc of the dog right here, and it's like a half of a sun or a half moon over the elbow, you claim these 2 dots are consistent with puncture wounds?
No, punctate lesions.
Oh, punctate lesions, I'm sorry. Which teeth, upper or lower teeth, do you think caused these 5?
I believe those were the upper teeth.
So you believe this is a canine on the left, number 1, and a canine on the right, number 5?
It could be.
Okay. Now, if here's the arc of the dog's mouth, and this is a canine on 1 and 5, where do the canines puncture and pull? Up or down?
I'm sorry, say that again?
Where do the canine teeth puncture? From the bottom or from the top?
So if these are, let me use my pointer here. If these are canines, and this could, by the way, be two, this also could be 2 separate bites, but if these are canines, they usually would start on the, based on this picture, the upper or higher area and
Right.
pull down.
They would have to start up and pull down if that was a arc of a mouth, wouldn't it? But you see the bottom of these wounds, right? The round part
Mhm.
that is closer to a puncture is on the bottom. Aren't they going in the wrong direction? If this is the arc of the mouth?
No, I don't think that they are going in the wrong direction. You have to keep in mind that presumably Mr. O'Keefe was not standing there and letting the dog just chew on his arm. Okay, that there's
How do you know
relative
that?
move.
Objection, Your Honor.
How do you know that?
No, but she's not finishing her answer, Your Honor.
The question's allowed.
How do you know what he was doing?
Because it's normal human behavior that if you're,
How do you know what he was doing? How do you know what Mr. O'Keefe was doing that night?
again, it's normal human behavior to pull away from someone that's attacking you, a person or an animal. That's normal human behavior. If he was still throughout this whole attack, I would be looking for a different set of wounds.
You're speculating about all of these comments about what he was doing and not doing. You have no idea what he was doing, do you?
I'm just
Objection, Your Honor.
The question, or can you answer that question, Doctor?
basing it on normal human behavior.
And so you would disagree with me that if these were dog bites, the part that's thicker, that is more similar, although not a puncture, would start at the bottom and work up, meaning the dog's head was over here on the top. You disagree with me about that?
Do I disagree?
Yes.
Yeah, I believe that that's
Okay.
incorrect.
And if these are canines, did you measure the distance between the canines?
Again, there's no ruler, but the other thing is we don't know what position his elbow was in at the time of this. So it could be, although it looks like it's a larger, a larger configuration than a normal canine distance, intercanine distance. That's what you're referring to, the intercanine distance. If his arm was flexed, that distance would be shorter. So you cannot make any assessment based on this picture.
Do you notice the differences between the left mark and the right mark are a greater distance than wound number 1, where you said that it was 2 canines that caused these linear abrasions?
And there's no elbow between the linear abrasions of wound collection number 1. There's no elbow up here to be flexed.
Let me ask again, do you notice the difference between these two is wider than the difference between wound number 1 when you said it was 2 canines?
You mean this mark here versus this mark here? Is that what you're talking about?
Wound 1 on wound 3, number 1, number 5, where you said these could be canines. You notice the distance is different than the distance where you claim that wound 1 was caused by 2 canines. Do you notice the difference in distance?
Again, I'm not clear what you're asking me. Are you asking me the distance between this tooth and that tooth? I think what you're asking me is the intercanine distance. Is that what you're asking me about?
Intercanine distance, I've never heard that word.
Well,
Is that a new one?
no, that's
Okay.
well known in medical literature.
Let's just look at simple math or size. The distance between these 2 wounds is a greater distance than where you said it was canines in wound number 1, isn't it?
Again, I believe I just explained it, that if the elbow was flexed at the time that the wound was inflicted, or the bite was inflicted, you would get these 2 wounds that are closer to one another than they appear here, because the arm is partially extended here and skin moves.
Are you saying this is a full bite, puncture wound top and bottom?
Excuse me?
Are you saying this was a full bite of puncture wounds, bottom canines, top canines? Are you saying this is a full bite?
I don't believe no, this is not a full bite. There is no significant penetration of the skin. So this is not a full bite or a complete bite.
Did you say at trial, at the elbow, there's another different series of marks that again have linear abrasions? up where the pointer is, and then down below some punctate, superficial, round, small abrasions, again representing upper and lower teeth, in my opinion. Was that your opinion at trial, that this represented upper and lower teeth?
Yes.
And these lower teeth, what teeth were these?
What teeth?
Yeah.
I don't know.
Were they the canines?
Could be a canine, could be incisors.
Okay. There we go. Thank you. And so your opinion at trial is these 4 could all be canines.
Which 4?
1, 2, and then the 2 punctures or punctate.
That is a possibility. It is actually, and I think I said this too, that this could actually be a configuration of 2 separate bites. Where you have canine puncture wound, punctate lesion from the, so upper canines, lower canines. And then this could be a separate one. Just can't tell. There's not enough specificity in this configuration of wounds.
And you have nothing to compare it to either.
No.
Do you see the distance is different between what you said is a 4-set upper and lower canine and this one here, this canine? Do you see the obvious difference?
With all due
distance?
respect, Mr. Brennan, again, the elbow moves, so the skin moves. The skin overlying the elbow moves, and we don't know the configuration that this arm was in at the time those wounds were inflicted. You cannot make a generalization.
I'm going to ask you one more time. You don't have to answer. Do you see the obvious distance between wound 1 and 3 where you say that it was the canines? Do you see that?
Objection, Your Honor.
So I'm going to strike the part that says you don't need to answer. Can you answer that question, please, doctor? And then we'll move on, Mr. Brennan.
I see the difference, but I understand the difference.
Okay. If these were canine wounds, they can't be claw wounds, right?
Yes.
And based on your knowledge and study and whatever you're relying on, you have no way of telling if this is canines or claw.
Not 100%, correct.
Not even 100%. You don't have an opinion to a reasonable degree of medical certainty whether it's canines or claws, do you?
I believe those are canines.
Did you testify at the Lanigan hearing when Mr. Alisi was asking you questions? Did you observe any claw marks with regard to the injuries? And you said it's possible.
Possible, yes.
How can you give an opinion to a reasonable degree of medical certainty it was canines, and in the same breath and statement say, well, it's possibly claw wounds as well?
Objection, Your Honor.
I'm going to allow it.
My opinion about reasonable degree of medical certainty is about the whole arm, the configuration, the pattern of the whole arm, and not any one individual wound.
Wound 4 up here. What do you think this might be?
I don't know. I'm not certain.
Well, I mean, in the totality of a dog attack, it has to be something related to a dog because we don't know that it was there before. Had to have been something, right?
It's probably related to the dog, yes.
Well, you don't think he just had this independent wound and then all these came from the dog attack and this one just happened to be hanging out waiting for them?
That's correct. I don't
Right.
think that he had a separate wound.
You don't think this one maybe was caused by the broken shards of glass from the taillight during an alleged collision, but the
No.
other ones were from something totally different, do you?
No, because it has an orientation about it. It's oriented, again, in a somewhat vertical orientation, similar to many of these other sets of wounds.
I don't know what that means. It has a vertical orientation. How does that help us understand if this wound existed before or after the so-called dog attack?
It has some similarity of pattern.
So you think this was caused during the alleged dog attack?
Yes,
Okay. What caused this wound during the alleged dog attack?
I don't know.
Is that because there's no methodology or comparative standards, so you can't compare it to anything?
No, because there's not enough specificity in that one particular wound all by itself.
What are the options? How could it have been caused during this dog attack?
By a tooth or
Okay.
or claw, most likely.
Could have been caused by the ground?
I doubt it, considering that, again, it's oriented in a similar fashion to the rest of the lesions.
Okay. When you read the background facts of this case, well, let me ask you, if a dog attacks an arm, it's going to create force on the arm, wouldn't it?
It depends on how much penetration. Yes, it depends on how strong the bite is, how much penetration, it gets through the clothing, into it, clothing that's on, on the intervening, between the arm and the dog is going to present a little bit of a buffer.
Well, let's talk about the force on the arm.
Mhm.
If this was a dog attack, as you claim,
Mhm.
that means the teeth and or the claws penetrated that sweater and caused an abrasion on Mr. O'Keefe's arm, correct?
Yes.
So there had to be an amount of force pulling on the arm to create that friction, which led to the abrasion.
Yes.
Okay. Did you know from any of the facts that you reviewed that when Mr. O'Keefe supposedly left the car, he had a glass in his hand with a straw in the glass?
I'm aware that there was a glass in his hand.
And you're aware when he was found by the side of the road that glass, the broken part of the glass, was right near him with the straw?
I don't know anything about the straw, but yes,
Okay. And so if there's a dog attack and somebody's holding a glass,
uh-huh.
right, they're not likely to continue to hold on to the glass throughout the duration of the attack and then move somewhere else with that glass.
I don't know if he was holding onto the glass during the dog attack.
Well, hypothetically, assume that the evidence is he supposedly was holding the glass. Wouldn't a dog attack rip that out of his hand? Wouldn't he drop the glass?
There are many possibilities here. He could have transferred it to the other hand.
Let's look at wound number 5. Do you remember testifying about this?
Yes,
And you said it looks like an arch.
it does to
Okay.
me.
Are you saying the arch is on the top or on the bottom?
No, I thought the arch was on the bottom. But by bottom, I mean what we call proximal part of the arm. So here, right here is where I think the arch is.
And if this is an arch and these are dog bites, these would be the canines.
They could be, however, I can't rule out that this is, because of the curvature of the arm, I can't rule out that this was.
Just at the top of this comment, BC seen Brennan motion regarding ARCA file today. No, I did not. Is he asking for another Daubert hearing on him, on the ARCA experts? Because then this is going to be a long preach on another ARCA Daubert hearing. But no, I did not see it yet. So I have to take a look. But thank you for letting me know about that. Definitely have to take a look at that.
From a canine and incisor teeth.
Well, this is a different angle than here, right? But there's no flexion like in the elbow on this wound area. This is the bottom of the wrist, right?
That's correct. However, that part of the arm has a different configuration than the upper arm. And it's got it's got a bone right underneath it.
So you're
The
saying,
ulnar bone.
I'm sorry, I didn't mean to interrupt you.
Oh, it's got the ulnar bone. So
Okay.
a wound to that area is going to look different than a similarly placed or caused wound to this area, which has a lot of padding underneath it from the soft tissue, subcutaneous tissue, and doesn't have the protuberance of this bone right here.
We have a distance problem when we compare these, don't we?
We have a what?
A distance problem. The distances are different. If these are canines, obviously it's a different dog or something else that caused it because the distances are clearly different, right?
Again, one has to.
Okay, just answer this question. Martin, were there no Daubert hearings before the first trial? The only Daubert hearing that I'm aware of is the Dr. Marie Russell Daubert hearing, which happened in the middle of trial. That's the only Daubert hearing that I'm familiar with. And there's also, during that same time, apparently a Daubert hearing for the ARCA experts. That all happened in the middle of trial, I believe, but nothing before trial. So, but who knows? This is a prosecutor who's very aggressive, and maybe he's going to start demanding Daubert hearings for the ARCA experts as well. I wouldn't be surprised.
To know how wounds occur. And I'm not, and I didn't say that those are definitely two canine teeth on the periphery. I'm saying that I believe that this is a combination of canine and incisor teeth.
When a dog bites and tears, you see a missing tear pattern, don't you? You see the skin gets torn on many occasions?
Yes, but we don't have any of that here. We have no penetrating wounds here.
Right. Is it remarkable to you that if this was a dog bite with canines, there is no tearing of the skin? Is that remarkable to you?
No, because that dog was not able to create the force enough to penetrate the skin through that sweater.
Could I have exhibit 32, please?
And I absolutely need a drink after this. I think lunch is going to be some drinks involved.
Okay. You've seen this picture before?
Yes,
Okay. And this is allegedly is a dog bite from Chloe?
yes,
And you see the tearing of the skin, don't you?
yes.
And you can see the corners where the incisors would penetrate through a puncture. Yes?
I'm not sure what teeth punctured this, but yes,
And it-
I
and
see.
this-
I see the skin is all penetrated.
This is consistent with the literature of a tear and a hold and a pull, right?
No,
Okay.
no, absolutely not.
This is not consistent with the dog biting and then pulling the skin.
This is consistent with an avulsion wound caused by a dog.
Very different wound than we looked at on Mr. O'Keefe's arm.
On
Mr. O'Keefe's arm, very different, right?
correct.
Okay. If we can go back to 5, please. Now, your opinion that this is a dog attack.
Mhm.
Have you ever had peer review of this opinion with this photograph?
No,
No. You would agree that this dog bite science is what they call a soft science. Would you agree with that?
I don't know what you mean by that.
Okay, well, it's not like DNA. It's opinion-based. It's subjective-based, the science of dog bites, isn't it?
It's based on a lot of training.
Yeah, and a lot of subjective opinion too, wouldn't you say?
There's opinion here, yes.
Uncertainty,
There is some, yes.
right? And being that type of science, haven't you read in the studies about peer review, how peer review works?
What specifically are you?
That you have another qualified professional look at it and question and vet whatever opinions you're giving. Did you go through that process at all?
I've been through that process, yes.
You've been, okay, and who peer reviewed?
You mean
findings?
this case?
Yes.
Oh, no, not this case. No, I thought that this information was rather confidential. And I didn't share this
Okay.
information.
Well, you discussed with the defense other information in this case, didn't you, about the accident and about people's opinions? You've discussed that as part of your opinion, haven't you?
Yes,
Okay. Did you know that the U.S. Attorney's Office employed a deputy medical examiner to look at these bites? And then he had commented that the wounds of 2 to 3 millimeters up to 7 centimeters were documented on Mr. O'Keefe's right arm, and the injuries do not photographically appear to be, nor are described as puncture bite wounds, and thus are highly unlikely to be the result of an animal bite attack. Did you get that expert opinion from the United States Attorney's Office when they investigated this case to consider as part of peer review?
Objection, Your Honor.
no, I did not get that, but
Did you say you did get that?
no, I did not get that.
Oh,
However, I have a comment about that.
Go ahead.
Please.
Not very medical exam, not very many medical examiners have the experience that first of all, have experience with dog bites, seeing hundreds and thousands of dog bites and treating them. And not very many medical examiners have even autopsied a case of dog bites. So although, some physicians have certain opinions based on what they know, they don't have my experience. I'm
Do you
sorry.
know if Mr. Walsh had your experience or not?
I don't know who
The
is it?
gentleman who gave this opinion that was employed by the federal government, do you know if he had your experience or
What's
not?
his name?
Mr. Walsh,
I
John
don't.
Walsh.
No, I don't.
So he could have more experience for all you know.
Oh, I'm highly unlikely.
Okay, you have more experience than anybody in the country.
I think I have at least as much experience as any other possible person in the country. And I have it from both aspects, from the clinical aspect and from the forensic aspect.
Did you review the opinion of Dr. Kenneth Kinsey, who said that those injuries were not caused by a canine?
Dr. Who?
Kenneth Kinsey.
No.
No. If you look, I believe Mr. O'Keefe's arm were completely bent when he sustained the injuries. A lot of them match up. They're a continuation of another injury.
And I don't even know who Dr. Kinsey is.
Okay.
Is that
So-
a medical doctor?
So you don't have any peer review at all. You have nobody who's given an opinion similar to yours about this being dog bites, do you?
Is that the case? I'm sorry.
You have no peer review. You have no peer endorsement. Everything that you have no peer endorsement for any of your opinions, do you?
I didn't think I was allowed to show these pictures to anyone.
When you're giving opinions about the teeth and suggesting that there's might be bend, things you don't really know about, you would agree it would be best to look at the dog, Chloe itself, right?
Not necessary.
If you looked at Chloe and examined Chloe, you would know whether or not there are any irregularities in Chloe's teeth, wouldn't you?
Yes, I might.
You would see it, wouldn't you?
Well, if I got close enough, and
Right.
I don't know if I want to get close enough to Chloe.
Well, why wouldn't you want to? You're a medical doctor. You want to have an opinion to a degree of medical certainty. Why wouldn't you want to see the best evidence of the distance between the teeth and Chloe? Why wouldn't you?
I'd have to make sure that I wasn't putting myself in danger.
Okay. And if you saw Chloe, you could see if there was any missing teeth, couldn't you?
Yes.
You could actually measure the canines in Chloe, and then you could compare them to what you're calling dog wounds on Mr. O'Keefe's arm. You could do that, couldn't you?
I would have to get a veterinarian
Mhm.
to sedate the patient, the dog, because that going near that dog would be very dangerous. They'd have to sedate the dog to measure the intercanine distance.
What if you did get a veterinarian to sedate the dog, and then you could safely go and look at Chloe, and you could actually take a mold of Chloe's mouth, right?
Mhm.
Yes? You've read that in the literature. The best way to
one could.
I'm sorry.
There's only one person who's not doing
You've read in the literature the best way to compare the teeth and the mark is you actually do a mold of the dog's mouth. You know how valuable that can be in analysis, don't you?
It can be, but the question, I believe the question here is not which dog created these wounds, but did a dog create these wounds?
That's not my question. My question.
And in fact, remember that this whole science of odontology to say that a specific wound is from a specific dog, everybody agrees it's not a good science. So why would you go take a mold to try to prove that it's this specific dog? They already debunked that idea that you can draw conclusions from a specific wound to a specific dog. So not the greatest argument here, but he's still going to use it because, and you got a witness on the ropes. You're going to throw everything at him or at her.
If you took a mold of Chloe's mouth, you would see the distance between the canines, and you could measure it, quantify it, not guess and speculate, quantify it, correct?
Your Honor, could we approach, please?
Okay.
Thank you.
Who wants to bet that after this sidebar, they're going to take lunch? Something tells me that we may be heading to lunch right now. And who knows how much longer. Maybe she'll ask how much longer. And then maybe we'll ask how much longer on redirect, which I think we're going to be here for the rest of the day at the rate that this is going. So I just also want to point something out that he's doing very well, Hank Brennan. But something you have to keep in mind when you're the defense attorney on this case, for the following, that you can have an opinion to a reasonable degree of medical certainty. Still, it's possible that your opinion is wrong. Okay? It's not an absolute opinion. It's not 100%. So yes, the answer to all those questions are, isn't it possible? Well, then how can you say that it's a reasonable degree of medical certainty? They don't conflict. And this is what good attorneys do. They try to create a contradiction when there is none. And if you don't have a prepared enough witness, or the witness is not realizing what's going on, or the defense attorneys right now are not realizing what's going on, you can miss this. And they can say, then they can make this argument to the judge saying that she's not qualified because she keeps saying that there's so many different possibilities out there that none of her opinions are within a reasonable degree of medical certainty. But the answer to that is that, Your Honor, anything can be possible. It still doesn't take away the fact that her opinions are still within a medical degree of within a reasonable degree of medical certainty. There is room for other possibilities. That doesn't negate the fact that all her opinions are still within a reasonable degree of medical certainty. So that's just the point. Again, you have to bring this out again on redirect to tell the doctor, say, doctor, I know we Mr. Brennan went through a lot of different possibilities. Maybe it's possible that it was a claw mark as opposed to a bite. It's possible this, it's possible that, the other thing. But does that really take away from the fact that your opinion is still within a reasonable degree of medical certainty? Can an opinion, doctor, that's within a reasonable degree of medical certainty still possibly, is there still some possibility that it's wrong? Of course. No one can be 100% about anything. So all of these possibilities that Mr. Brennan was saying, isn't it true, doctor, that really it still doesn't take away from the fact that within a reasonable degree of medical certainty, everything that you said still stands. And once you hammer home that, well then, that's going to be a much stronger argument to say, Your Honor, you're right, Mr. Brennan pointed out a few different possibilities. That still doesn't take away the fact that she still holds all these opinions with a medical degree of certainty. So, we'll still see what we have left here, at least maybe before lunch or not. I didn't think this would take so long, Lisa. And after that first hearing, I think nothing surprises us at this point. I thought that it was going to be finished today. I didn't think that his cross-examination is going to go so long. But a lot of times when you have an outline for cross-examination, I may have, let's say, like 4 points that I want to make in cross-examination. And really, if the witness would cooperate, then I would be able to get through those 4 points relatively quickly. But what happens a lot of times is that they fight back, the witnesses, and they try to become combative, and they try not to give you anything. And when that happens, when they do that, they're just making the job for themselves much harder, because I'm going to make them look like a fool. Like, it's a little bit what Hank Brennan's doing here. It could be he could have been through these points already within a half hour, an hour. But because he's getting a lot of pushback from Dr. Russell, so he keeps exploring each individual point that he's trying to make, and it's requiring him to ask 25 more questions about this point to be able to actually make his point. So this is all part of what happens by cross-examination. You can think, Your Honor, I'll be done in a half hour, and really it can take 3 hours because the witness is becoming so combative with you. So I think we're seeing some of that right now. And again, a lot of this point and a lot of this about what she didn't see. And of course he's going to hammer home about this. And this is definitely okay, decent for cross-examination. Everything that the expert did not have. That's always something that you bring out on cross-examination. This comes back to some of the arguments that we've been hearing about the ARCA experts. What evidence that they did not have? You talk about, well, you didn't go down to the scene. You didn't do a mold. And like I said in one of my videos, you can go check it out. One of my videos when I was explaining, when you go through all the evidence that a person does not have, an expert does not have, it's not a question of how much in quantity the person didn't have, because you can literally list a million things that every expert did not have. The question really is whether that makes a difference, whether they had that or not. So that would really also be a very easy way for for redirect in this case, where Robert Alessi can get up and say, well, let's go through all the things that Mr. Brennan said you didn't have. This, and this. Now, doctor, just tell me candidly, do you need all that information to come to your opinion? And the answer is going to be no. Of course I don't need all that information. All the information is just argument for the prosecution. That really doesn't change my opinion at all. And really knowing that information wouldn't have changed my opinion either. And that's just a very easy way to take a lot of the wind out of that. So, but he still is going to point this all out, because this is what lawyers do. They try to create problems and create doubt and create all these things that the expert didn't have. And that's just can be expected. So here's the ultimate question of the day. Do you think the judge will exclude her? And the answer to that is we're yet to see. We got to see how good the redirect is, because if I was going on redirect, I would have to show up. And again, judges can also be convinced by lawyers. Okay, I've seen this a lot of times. So what you'd have to do is you have to get up on redirect and show how this is not just her experience. Her experience alone is not going to do it. Her knowledge and experience is not going to do it. That definitely gets you a lot of the way there, but it doesn't completely get you there. The methodology has to be sound. And the way that Brennan's trying to create it is that if there is no standard, he keeps trying to say that there's no methodology. And he keeps saying that there's no methodology, because ultimately is what it comes down to, whether there's sound methodology. Are you comparing this with other comparative analysis, or just basic regular research or standards or methodology that you base your opinions on? So if you're on redirect, you have to say, Dr. Russell, we understand that you're very experienced here. You have a lot of experience in dog bites, which is why we would all trust you to treat us. And that goes a long way in court, Dr. Russell. But we also need to just know that your methodology is sound. So all of these research papers that you cite, and then go through some of those research papers, this paper and that paper and the other paper, and this review and that review, are all these devoted to a proper methodology in how to diagnose dog bites. Oh, they are? Okay, so this is not just you and your experience. This is also you relying on these peer-reviewed articles, numerous articles, which explain to you exactly what your method should be in determining whether these are dog bites. And you have to make that very clear to the judge, that this is not just her because of her experience of 30 years, but this is applying all the methodology. And yeah, there may not be one specific standard of how you are supposed to apply, looking at this pattern and that pattern and this punctate wound and the abrasion and whatever. But what all these papers do tell you is your approach, what your method should be, how to evaluate these wounds. And if that's what you're relying on, and these are all peer-reviewed articles that are accepted by the medical and scientific community, well, then you should be able to survive this Daubert challenge. Okay, so that's what you got to do on redirect. So we'll see if Robert Alessi does that. Let me see what else we have here. Creed, does the defense now get to have a free 2-day cross of any prosecution expert? The defense can also file Daubert motions. Yeah, they could do that. And they can seek these Daubert hearings. So are they going to do that or not? We're not sure. But they can definitely do that. Okay, here's a question. Marty Vale Esquire, which is fictional, so I'm assuming that means that he's not really a lawyer. How can the same judge reverse herself without creating an issue? She approved her in trial 1. For her to exclude her now means she screwed up at first trial. Well, so we discussed this. The law on this issue is the following, and judges are allowed to reconsider rulings. Okay, there's a specific process in which how you do that. You file motions for reconsideration. Judges can definitely revisit their rulings. Okay, so that's what happened in this case. She made the ruling initially, but she said she's going to leave it open. And if you can show that there's new evidence or new arguments or new cases or new law that was enacted since her last ruling on something, then she can revisit it and change her ruling. This happens all the time. You file motions for reconsideration, a judge will rule on something, and then you ask the judge to change their mind. Now, usually you have to base that on something new that arose. New evidence or new law that no one was aware about, something like that. So yes, it is possible to do that. And just pull up Jessica Pinkerton. As of now, I think the biggest threat to the prosecution's case is the ARCA experts, and I would 100% agree with you. Like I said, I was watching this trial from the beginning, completely open-minded, completely objective. I'm still objective, by the way. But I did not make up my mind. In fact, while I was watching this trial, which is a long time, I was on different shows. People were trying to pressure me into taking a specific position, and I wouldn't do it because I said I need to see all of the evidence come out. I need to see all of it come out. Once I see all the evidence, then I can tell you what my objective opinion is. And once I heard the ARCA experts, that was really what to me, sealed the deal that the Commonwealth just simply did not prove their case beyond a reasonable doubt. So yes, the ARCA experts, in my mind, is the biggest factor leaning in Karen Reed's favor and saying why the Commonwealth did not meet their burden. If there's some way, I'm sure Brendan's trying to figure out how to do this. If there's some way that he can exclude the ARCA experts, or if he's able to get this new guy, and somebody on Twitter or X let me know that who this new expert is, and I don't know where he got his information from, but apparently Hank Brendan's trying to get a biomechanical expert. Maybe he did get one already. And if that expert is so convincing, then you may have a problem with your Karen Reed. So see what happens.
All right, so you can continue, Mr. Brennan.
Thank you, Your Honor. Dr. Russell, when you're examining these separate wounds and the distances and the depths between them, and guessing whether or not it was a canine or incisor, wouldn't you?
You love the way that he says guessing. I mean, this is just the way that cross-examination happens, and you're guessing in that way. Like it's just a way to really poke at the witness. And Brennan does this very, very well. This is what very fierce advocates do. They try to change your positions and make it sound very weak on cross-examination. What do they do? And they say guessing as opposed to anything else.
You'd agree it would be helpful if you had a safe opportunity to actually examine the dog Chloe.
It could be.
If you had a safe opportunity to examine Chloe, you could look at the size of Chloe's jaw.
It could be, but those wounds on you're shaking your
It's
head.
not my question.
Okay.
My question is, if you had an opportunity to go safely and look at Chloe, you would be able to tell the size of Chloe's jaw. You could measure it.
Possibly, yes.
You could determine the gape of Chloe's jaw, couldn't you?
I don't know what the gape of.
How it bites, how wide it opens up.
I'm not sure I could determine that.
Okay, you could look at Chloe's teeth.
As they are now, yes.
You could measure the distance between the canines if they still exist in Chloe's mouth.
Yes, from a model or imprint from Chloe's mouth.
You could take a mold,
Right, a mold.
or you could take a tape measure or a ruler and you could measure. You could
Oh,
do
that
both.
would be very reliable.
I see. You could determine whether or not she had one incisor or whether she had 2, 3, 4, or 5, or 6
By the way, I lost the bet. I thought we were going to be going to lunch now. So it's a good thing I didn't bet any money.
incisors.
Currently, yes, but I can't tell what the condition of the teeth were during the incident.
You could tell if there's any missing teeth.
Correct.
You could look at Chloe's paws, couldn't you?
Yes.
You could do moldings of those and measure those as well, couldn't you?
I'm not sure that would be useful.
Well, if
Measuring
you think that some of these wounds could have been scratches, you could look at the nails and the shape of the nails, couldn't you?
Well, nails are frequently cut on a regular
course.
basis, and the distance between the nails, as you mentioned earlier, can change depending on whether or not the paw is in a compressed state or a more relaxed state. So that wouldn't be reliable.
So you would not even consider measuring the paws because you think that would be unreliable?
I don't think it would be reliable. No.
You wouldn't study the toenails to see the shape of them?
If I could, I'd look to see if there's an abnormal toenail,
Right.
for instance. Yes.
And so there would be a benefit to doing that. You didn't do that though, did you? You didn't go see Chloe and take a mold of Chloe's mouth, did you?
It wasn't necessary.
Well, did you go up and take pictures or measure the teeth of Chloe?
No.
Did you ask to?
No. It was my understanding that Chloe was in another state, but again, I didn't think it was necessary, and I have reasons why I didn't think it was necessary.
You thought that Chloe was in another state. Did you ever discuss going to see Chloe and doing these studies on Chloe so you could see if they were dissimilar to these abrasions?
I was asked to evaluate the wounds.
Do you know that Chloe exists, that we provided notice to you, that we went up and saw Chloe and took molds? Did you know that?
Objection, Your Honor.
Did you know that was going to allow? Did you know that, Doctor?
I do know that now. Yes.
Did you know that before you testified the last date in this case, that we actually went up and found Chloe and took molds and measured the paws and the teeth? Did you know that we did that?
I don't know. I don't recall.
Before you came in and testified at the last hearing, you don't recall whether you knew that Chloe was available?
I believe I knew that there was a consultant, that you hired a consultant, and I didn't know what that consultant was going to be doing.
Okay. Now that you know, that Chloe's available, wouldn't those modes be helpful? Wouldn't you want to look at them and compare them to the distances on the abrasions on Mr. O'Keefe's arm?
Objection, Your Honor.
I don't think it's necessary for many reasons.
If the distance of Chloe's canines is significantly different than these abrasions in this picture, you would agree that the abrasions in Mr. O'Keefe's arm could not have been caused by Chloe. Would you agree?
No, I wouldn't agree to that statement. Again, because of the various factors such as elasticity of the skin, shrinkage, there's various factors.
So if I understand, you have no interest in examining or seeing Chloe. It's irrelevant to your opinion?
I don't think I need to see Chloe.
Well, you said earlier when I asked you about particular wounds, it would be helpful to know these things about missing teeth and spacing and distance between the canines. Is that no longer helpful to your opinion?
No, I think you're mischaracterizing what I said. I believe I said that it would give information about the condition of the teeth now, but it wouldn't give information about the condition of the teeth when that incident happened,
In the spirit of medicine and science, isn't more information good?
generally.
Generally. But you generally would not want to go see and examine Chloe.
I don't think it's necessary, and there's so many reasons why.
Okay. Thank you for your time.
Yes.
All right, Mr. Lessie, go right ahead.
If I could have you read the order
Sure.
of the exhibits, thank you, Your Honor. They're organized, I just wanted to make sure I have the right ones. Thank you, Mr. Brennan.
For the record, we have pre-marked number 33 through 37.
Thank you.
In Your Honor, and thank you, Mr. Sullivan, I have provided the court and offered to counsel, but counsel already had the copies, a notebook that has exhibit numbers.
Thank you.
You're welcome. Mr. Brennan has agreed that all the exhibits in the notebook can be in evidence. So that's number 2. And so if I'm remembering correctly, Your Honor's previous direction that if they're in evidence, just refer to them as such. So that's what I
Yes.
plan on doing.
Yes.
And what I also plan on doing, Your Honor, is taking the exhibits that are in the notebook. I've got non-binder ones individually for the witness that are
Okay.
pre-marked. Does that work also?
Sure, you can just put them up on the stand with Dr. Russell.
In my approach to do that?
Sure.
May I talk to the witness and just point out where they are?
I think you can give them to her. I think
Okay,
she can
that's-
figure out
okay.
numerically what's what. All right, Mr. Leslie, I'm not rushing you at all, but is it safe to say that you won't finish in 20 minutes?
That is safe, Your Honor.
Okay, so we will plan on breaking at 1. Mr. Clerk will have to cancel our afternoon list. What, how long do you think it might take? And I'm not holding you to this, just curious.
I appreciate the question. If I can just have a quick moment, because I knew what my redirect was going to be until Mr. Brennan went, and I'd like to consider what he did.
And whatever he says, double it.
My best estimate is approximately 2 hours.
Okay, I'd like us to finish by 4.
Yes, Your Honor, understood.
Mr. Brennan, I know you have no idea how long recross might be, but we'll try and finish by 4 today.
Understood, Your Honor.
May I now proceed, Your Honor?
Please.
Thank you. Dr. Russell, during cross-examination at this Daubert hearing on December 12th, you were asked whether you believed you were an expert in the areas of orthopedics, accident reconstruction, biomechanics, motor vehicle accidents, and defensive wounds. In your 29 plus years of experience as an emergency medicine physician in training emergency medicine physicians, are you aware of any emergency room or emergency department physician being board certified in orthopedics?
No,
Are you aware of any emergency medicine physician being required to be an expert in overall orthopedics?
no. General orthopedics, no.
But do emergency medicine physicians nonetheless routinely evaluate and treat people injured in motor vehicle accidents?
Yes,
And did you, in your 29 years of experience as emergency medicine physician, routinely evaluate and treat people injured in motor vehicle accidents?
yes. I worked at a busy level 1 trauma center.
During your cross-examination in response to a question, you stated that you were an expert in emergency orthopedics. Can you please explain that?
Yes, so emergency orthopedics is a subset or just a part of the overall field of general orthopedics. So in emergency orthopedics, physicians care for, evaluate, diagnose, treat patients who have acute injuries and that don't need operative care. So acute fractures, acute dislocations, those types of injuries are done in many busy emergency rooms, right in the emergency room. And that's what I have expertise in.
Did the rotation at the, you just said busy hospital that you were at, did the rotation when you were training, were you required to take a part of the training in emergency orthopedics?
I was required to take a 1-month rotation in orthopedics.
Now, you were asked during cross-examination at this voir dire about one particular specialized training that you had involving motor vehicle accidents. And you, in response to a question from Mr. Brennan, agreed that that particular course was rudimentary. Do you recall that?
Yes.
When did you take that course that you referred to as rudimentary?
It was around 1979.
And what profession did you have when you took this rudimentary course that you were asked about?
I was a police officer at that time.
And since that one rudimentary course that you had, have you had further training with regard and experience to humans injured in motor vehicle accidents?
Yes, much.
And describe the much that experience and training you've had in that area.
Well, during my 29 years working in the emergency department, we saw motor vehicle accident victims on every shift. And usually there were multiple victims on every shift. So that was part of it. Plus we had lectures and seminars on motor vehicle accidents, victims.
And is your focus in your testimony, both in June of this year and in December of this year, on wounds from motor vehicle accidents or how motor vehicle accidents occur?
So as a physician, my focus is on the wounds and injuries caused by motor vehicle accidents and how to diagnose and treat them.
So are you sitting as a medical doctor giving opinions on medical causation of the injuries to Mr. O'Keefe?
Yes.
During cross-examination, in this hearing, you were asked about whether you were an expert in accident reconstruction. Is being an expert in accident reconstruction necessary to practice emergency medicine?
No,
Does an emergency medicine physician need to be an expert in accident reconstruction to evaluate and treat people injured in motor vehicle accidents in the emergency department?
no,
In your 29 years experience as an emergency
And this is exactly what I was telling you got to do. You got to go through all the things that they say that she's not and say, is that even relevant? Why is that relevant, whether you know accident reconstruction, in order to treat someone for a broken bone because of a car accident? Just explain to us that. So obviously that's exactly what he's doing very methodically. So that's good.
emergency medicine physician and training emergency medicine physicians, are you aware of any emergency medicine physician being an expert in accident reconstruction?
no,
Is accident reconstruction even relevant to the practice of emergency medicine?
no,
Is whether an emergency medicine physician and expert in accident reconstruction a reasoned question in the field of emergency medicine?
no,
During cross-examination in this hearing, you were also asked about whether you have a degree in biomechanics. In your 29 years experience as an emergency medicine physician and training emergency medicine physicians, are you aware of any emergency medicine physician who is an expert in biomechanics?
no,
Is being an expert in biomechanics necessary to practice emergency medicine?
no,
Is whether an emergency medicine physician is an expert in the field of biomechanics a reasoned question in the field of emergency medicine?
no,
In your 29 years of experience as a medical doctor, where do most people go for the treatment of acute injuries from motor vehicle accidents?
to the emergency department.
Do you know, or have you had any experience where a person who has an acute injury from a motor vehicle accident goes to an expert in biomechanics?
No,
Do you know whether anybody who's injured in a motor vehicle accident, acute injury, goes to an expert in accident reconstruction?
no,
On cross in this hearing, you were asked about your expertise in, quote, self-defense. Was your direct testimony in this hearing in your report of December 9 about self-defense or defensive wounds?
would you repeat that question?
Sure. Was your direct testimony in this hearing in December and the report that you prepared dated December 9th, was that about self-defense or defensive wounds?
My testimony was about defensive wounds, not self-defense.
What's the difference between self-defense and defensive wounds?
Well, I believe self-defense is something like martial arts and study and techniques of defending oneself from an attack. That's what I believe self-defense is.
You were also asked on cross in this hearing about whether not observing how a wound to the posterior side of a forearm occurred provided you with sufficient context to determine whether a wound was a defensive wound. What context did you have with regard to the wounds on the right arm of the decedent to reach your conclusion that those wounds were defensive wounds?
Well, the context is the configuration, the location of the wounds, and the presence of a dog.
In the cross in this hearing, you've been asked whether you have observed how wounds are created. In your experience, do emergency physicians or forensic pathologists get to observe how wounds are created?
No,
Do emergency medicine physicians and forensic pathologists nonetheless often reach medical diagnostic conclusions without observing how the wounds are created?
yes, they do.
And is that a common or uncommon practice for emergency medicine physicians?
Well, that's common.
How common?
I think it's fairly common.
You were also asked whether someone could, and this is on cross in this hearing, whether someone could incur wounds to the posterior side of the forearm if they fall to the ground backwards. Did the wounds to the right arm of the decedent in this case arise from him falling to the ground backwards?
No,
Why not?
because of the configuration and the pattern of the wounds.
And do you come to that conclusion to a reasonable degree of medical certainty?
Yes,
You were also asked on cross in this hearing about when someone hits a moving or a floating object, whether the patterns are dynamic and changing all the time, and the hitting concept. Can you please explain the question that was posed to you about moving, floating objects and hitting objects and how you evaluated those issues with respect to the decedent in this case?
I'm sorry, I don't understand the question.
Doctor, did you understand the question?
not exactly.
Okay, ask the question differently.
On cross, you were asked about when someone hits a moving or floating object, whether the patterns are dynamic or change. Can you please explain those concepts in that question and how you analyze them with regard to the wounds of the decedent in this case?
Okay. When there is movement and there is contact, there is movement of the, for lack of a better word, inflicting object, such as a tooth or something else. There is movement along the skin during the period of time in which they are in contact. That's what I understood that I was being asked.
On cross-examination, you were asked several questions about pattern recognition and pattern recognition methodology. And you were asked about the development, that's what I want to start with, of your pattern recognition skills with regard to dog-inflicted wounds. How did you develop your pattern recognition skills with regard to dog-inflicted wounds on humans?
Well, as I testified earlier, I've seen many dog bite victims. And sometimes I was able to talk to, I closely examined their wounds. And not only examined, but evaluated, treated. But in many cases, I was also able to talk to them and ask them about how the wounds were inflicted. And I did this over and over and over again, hundreds of times. I think I testified to about at least 500 times over the years. So as you do that, you learn. You know, you recognize, you get sharper. So that's how I did.
And did you also edit any peer-reviewed publications that were relevant to pattern recognition and pattern recognition methodology?
Yes, I did. Now, pattern recognition in general, first of all, pattern recognition in general is a really important feature of medicine. It's critical. It's so important. And we start learning pattern recognition from medical school, from the beginning of medical school, learning how to recognize patterns of cells in pap smears and biopsies, patterns of cells. That's what a lot of pathology is pattern recognition. And so, and even radiologists use pattern recognition when they look at x-rays of pneumonia, for instance. You know, different pneumonias have different patterns. So pattern recognition is something that I've been doing since, you know, beginning of medical school, and actually a little bit before medical school. So that was 50 years ago, I think. 40 years
Is
ago. 40
pattern
years ago.
recognition some novel or unscientific process, or is it rooted in evidence-based medical science?
Oh, it's definitely evidence-based medical science. And in fact, there are textbooks on how to recognize certain patterns. So there, for instance, in pathology and
See, very good. You got to get back to the textbooks. You got to get back to the research articles. Even though she wants to talk about her experience, you got to get back to, and this is a Daubert hearing, so you got to get back to what text she relied on and how they teach methodology. So that's exactly what what Alyssa is bringing out right now, which he needed to do. So that's what she's saying. She's saying, yeah, this is rooted in textbooks that you see in medical school. This is not a new idea that I'm pulling out of my head, which is what you need in the Daubert hearing.
you know, in medicine, there are textbooks on how to, you know, how to tell if somebody's got liver cancer or somebody's got, some other disease. This is pattern recognition for the most part, and X-rays too. It's in textbooks. There are huge textbooks and numerous textbooks written about this.
Is pattern recognition methodology that you've been testifying about, is that generally accepted in the medical community?
Pattern recognition as a methodology? Absolutely.
All right, Mr. Alessi, we're going to take our break. We'll be back at 2 o'clock.
Thank you. All right, so go please.
All right, everybody. We are taking our break. So I'm going to turn the volume off. Everybody have a great lunch. I'll leave the chat open. I'll leave this open, and we'll see you back here at 2 o'clock for more of this and some more of my analysis. We will see you then. Thank you all.
Really,
Why?
because the pathognomonic features mean that you have the entity or the condition that that is explained.
Does
It's like we're back. That was
pathognomonic
pretty
mean
quick.
that the features themselves rule out other possibilities?
Yes, that's what I believe it means.
And is that how you interpret what the author is saying in this article?
Yes.
Please proceed lastly to the next 2 paragraphs, and then we can move on to the next study, I believe.
In conclusion, to identify a lesion.
So I don't know what just happened. We were just sitting here like 15 minutes. I guess the feed didn't start. So looks like they're going through some studies from the papers that she relied on for her methodology, which is very, very important, because that's what the Daubert hearing is all about. Not just your experience and knowledge, but also what peer-reviewed studies and literature you're relying on. So that looks like what they were doing for the past 15 minutes. Unfortunately, for some reason, Law and Crime didn't have the feed up. So we're just going to do the best that we can.
As a dog bite wound, it should have ragged and irregular wound edges, show multiple parallel linear scratches or drying scuff abrasions, include a puncture wound and sometimes an avulsion with irregular borders resembling a dental arch print.
And could you please, as the last paragraph we'll focus on, read what you consider important in the next paragraph?
The shape of dog bite wounds depends on the size and breed of the dog and will differ whether or not the full dentition was used to produce them.
Let's stop there. What does it mean to you when the author says, and will differ whether or not the full dentition was used to produce them?
So what that means is that if the bite does not include the full, let me back up. What it means is the appearance of the bite will vary depending on whether or not all of the teeth impacted the skin or just some of the teeth impacted the skin.
Please read the next sentence.
Only in ideal circumstances will a complete impression of all frontal teeth be found, and often only a prominent canine impression can be seen.
Is what you just read relevant at all to what you analyzed with regard to the wounds of the decedent in this case?
Very relevant.
How?
Because many of those wounds on Mr. O'Keefe's arm were only partial bites. They did not have the complete dentition.
Do you recall Mr. Brennan saying various times that you have no support for your pattern recognition methodology?
Yes.
Is this support for your pattern recognition methodology?
Yes.
Is it direct support for the pattern recognition methodology you have applied in this case?
Yes.
Is there another article? You mentioned 2, you mentioned DeMunich and Pollock. So let's turn to, and Your Honor, this will be the second and last article.
Okay.
Please turn to Exhibit 34. And is this the Pollock, P-O-L-L-A-K, study that you have mentioned multiple times in your testimony and that's in your report?
Yes.
Please, like we just did with the DeMunich article, please identify the portions of this study that support, you've testified, support your pattern recognition methodology.
Okay.
And let's
Well,
do
start in
a
the beginning.
seriatim from the beginning.
Yeah,
Yes,
I'll do it
please.
from the beginning. So the dog's front, so the first paragraph here.
Okay, the summary?
Yeah, this says summary. Yes, summary. In the absence of her parents, a girl of 4 months was killed by a 2-year-old male Rottweiler dog belonging to the same same family. The dog's front teeth marks of individual circular or scratch-like abrasions, as well as slit-like skin severances of the skin, arranged in curved lines. There seems to be a word or two missing.
No, you missed a word. That's
I
okay.
did.
That's
Yes.
okay, go ahead.
Okay. The pattern of skin lesions largely corresponded to the anatomy of the dog's set of teeth.
Let's stop there. How does the sentence you just read, what's the key component of that sentence that supports your pattern recognition methodology?
That sentence, the pattern of skin lesions.
Now let's go down to the keywords. Is there anything in the keywords that supports and roots your opinion that you've given several times that there's in dog bite wounds on humans, there's a pattern?
Yes, so there's about five or so keywords. One of them is injury pattern.
Why is there a section in many medical studies of key words?
So when you're researching, you can find the articles quickly.
And is there any importance to the use of key words when there is a study published?
Well, yes, because it's a key concept of the paper.
Please proceed to and I know it may take a little bit of time, and with the court's permission, to the next section of this article that supports your opinion that there is a pattern to dog bite wounds on humans, and that there's a pattern recognition methodology used to discern them.
Well, I think the next significant section would be 3.2,
And what is the title of that section?
morphology of dog bite injuries.
What does morphology mean in the medical community?
Basically means form.
And could it mean something in addition to form?
Form, pattern, appearance, yes.
So with regard to morphology section, please identify the sections, the parts of the article under this section that you believe, that you have concluded support your opinion of both the existence of patterns and a pattern recognition methodology with respect to dog-inflicted wounds.
Well, I go to the second paragraph.
Please read that.
Okay. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors also leave an impression, smaller skin lesions, round pressure marks, or streaky glide marks can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly. A gap in the injury pattern can have several causes: oblique biting, curvature of the body surface, interposition of textiles.
What does that mean? I'm going to stop you. What is interposition of textiles in layperson speak, and how, if at all, is that relevant to this case?
It's clothing overlying the area that was bitten.
And was there clothing overlying the bite mark wounds of the deceased?
Yes,
And what clothing specifically was that?
it was a hoodie type sweater.
Please continue reading.
Okay, interposition of textiles, different tooth lengths, tooth loss, form and positional anomalies of the teeth.
And keep reading, please.
On the next page,
Yes.
the spectrum of possible injury forms is extremely diverse. Depending on the type and intensity of local tissue damage, skin contusions with epithelial loss, linear abrasions, tears and/or crush wounds, as well as puncture-like lesions can be distinguished.
Thank you. So do these studies directly or indirectly support your opinions in this case that there's both a pattern to dog bite wounds on humans and that there is a pattern recognition methodology to discern them?
They do.
And is it direct or indirect support, these studies?
I believe this is direct.
And do you believe it's robust, these studies, or do you believe there's equivocation with regard to pathognomonic features?
No, I think it's robust, and these articles are cited elsewhere.
And are these articles, particularly the Munich article, is the citation ubiquitous in the medical literature, or is it sporadic? Are there a lot of citations to Munich in the medical literature, or are there only a few?
There are quite a few.
And do you recall the book that Mr. Brennan showed to you earlier on in the hearing?
Yes.
Does that book cite to Munich as support for a section in the book?
It does.
Now, there was confusion. You can put those.
And by the way, I mean, obviously he's doing a great job, because after Brennan was done with her, it seemed like she didn't know anything. Nothing was methodical. These studies didn't help her. So he's really doing an amazing job rehabilitating a witness. I mean, this is great lawyering. I mean, this is really, really great lawyering. You know, if anybody wants to see what real lawyers are like, this is it. I mean, Brennan, you know, really did a good job trying to tear her down, and he's doing a real good job building her right back up and saying everything's based on the studies. They show the methodology. These aren't, you know, one-off studies. These are highly cited, often cited studies, and they say exactly how to determine patterns of bite marks. So he's doing a great job. I mean, it's really great to watch some good lawyering. And again, I'm not saying him over Brennan, but I thought, like I kept saying with Brennan was doing a great job for what his job entailed. And now we're just seeing the other side of it, and he's completely rehabilitating her. It's great.
Those studies to the side for now, Dr. Russell. Thank you. Now, there was some confusion on cross-examination regarding where these articles could be found. Some were looking for them in your CD. I'm sorry, Mr. Graham.
All right, so I'll strike that part of it. Just go ahead without commentary and just ask the question, please.
Yes.
Be direct.
Sure, I will, Your Honor. Where are the references? Well, are the references to these articles in your CV, or are the references to these articles in your report?
In my report.
During cross-examination, it was stated that you, quote, suggested that you came to your pattern recognition skills because of communication difficulties or because people couldn't share with you or report to you the cause of the wound. Is that an accurate statement about how you develop your pattern recognition skills?
I don't know where that statement comes from.
I'm happy to provide it, or I could read
So
it.
let's strike that first part of it.
Okay.
And just ask the question, please. Again, this is redirect. It's not cross-examination.
Understood. Yes, understood. Thank you. Have you ever suggested that you came to pattern recognition skills because of communication difficulties or because people wouldn't share with you or report to you the cause of a wound?
No.
Would that be an accurate statement at all about how you develop pattern recognition skills?
No.
And why is that not accurate?
Because pattern recognition skills are, again, taught in various subjects in medical school. And I actually started even before medical school, but in medical school, they're taught in various subjects and in internship and residency. And that was long before I started interviewing patients, with the dog bites of unknown etiology.
Is pattern recognition common or uncommon in the practice of medicine?
Very common.
Can you please give some examples of pattern recognition and the use of pattern recognition methodology in the practice of medicine?
So I think she already did this before the break, right, Doctor?
I mentioned it earlier with pathology, looking at biopsies.
Oh, I'm sorry, Dr. Rizzo. This is about you, and so you've heard it, and I'm going to move on.
Thank you.
You're welcome. I'm going to move on to a different section. You have been asked on cross about whether in your emergency department experiences, well, let me rephrase that. In your emergency department experiences with dog-inflicted wounds, Have you ever gone to see the dog in question?
No.
Do emergency medicine physicians need to go see the particular dog or any dog in question to determine whether a wound is from a dog as opposed to some other cause?
No.
Do you, Dr. Russell, need to go to the particular dog to determine whether a wound is from a dog?
No.
Have you ever heard of an emergency medicine physician needing to go visit a dog to evaluate and treat a wound from a dog?
No.
Is that a rational proposition?
I don't believe so.
There was much discussion. Well, let me strike this. You were asked a number of questions about whether your testimony here for this hearing and your statements in your report are different from what you testified to in June 18 and June 21 of 2024. What I'd like to do is to compare the two and go through some questions with regard to that. So what I would like to do is to have you have Exhibit 35, which is the transcript of the December 12. Do you have that? It's a thick, it's the December 12, 2024. You should have that.
I do.
Okay. And what I would like you to do is to also have available exhibits 35 and 36 and 37, because that's what we're going to do side by side comparisons. So let's start out with the foundation for this. Do you have an opinion with regard to the nature and source of the wounds on Mr. O'Keefe's right arm?
Yes.
What is that opinion?
They're from dog bites, dog attack.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Now, at the June 2024 voir dire hearing, the claim is that you didn't say to a reasonable degree of medical certainty that the bites you looked at were a dog. So can you please go to tab 36, pages 1-30, line 13 to 1-31, line 1. Stop at 1-31, line 1. These were questions in response to what you were asked on direct by Mr. Jackson. And I would, with the court's permission, like you to read the question in the answer to what you actually testified to at that voir dire hearing. So please go to tab 36.
So can I see counsel at sidebar, please?
Yes.
So remember, one of Hank Brennan's lines of cross-examination was the inconsistencies that Dr. Russell testified to when she was testifying by voir dire, meaning the quasi-Daubert hearing that happened in the middle of the trial, her actual trial testimony, and then her first voir dire, which occurred about a month ago. So he was going and comparing and trying to show how she changed her opinion in all these different places. So now, to rehabilitate her, Robert Alessi is trying to go through those statements again. And if you're an attorney, you can kind of pick and choose the statements that look bad for the person, and that's what Hank Brennan probably did. And now Robert Alessi is going to try to probably give the full context of the question and the answer. And then once you have the full question and the full answer with the context, then you'll probably see that it really didn't conflict with each other too much. So that's probably what he wants to do here. Brennan objected to that, and that's probably what they're discussing, what type of leeway he's going to be able to have to go read through all of the questions and answers that she previously gave and compare and contrast exactly if there's any sort of discrepancy between the two statements. So that's probably what they're discussing at sidebar right now. And And by the way, I just wanted to let everybody know that hopefully, once this is done around 4 o'clock, I think that's what Judge Cannoni said, I will be, hopefully, God willing, putting out a recap video like I usually do when these hearings happen, hopefully to recap the entire day in 30 minutes or less. So hopefully that is what I'm going to be doing. So in case you're missing a lot, hopefully that 30-minute recap will recap everything that happened today, and you'll be caught up. Okay, the other Karen, and there's a few Karens in the chat, I think, aside from the Karen that we are looking at right now. But hello, apologies if this question is duplicate, coming in late. If judge rules against defense, can defense challenge? Okay, so the question is it appealable? Yes, it's definitely appealable. So the problem is that they're going to have to go through the trial. And if now it's very clear, and Brennan right now is trying to strike this witness. He's just filed a motion to strike the ARCA witnesses. Well, I should say, he didn't file a motion yet, but he did file something today saying that he's going to file a motion to strike the ARCA witnesses. So he's trying to get rid of all their experts. Okay. And then if the defense doesn't have any of these experts, it's going to be a lot harder for them to win this case. So we'll see what happens with that. But all these rulings could be challenged. The problem is that if people, if Karen Reed is going to be convicted, then she'll be sitting in jail while all of these issues are going to be appealed, and it can take years. So that's obviously something that the defense has to really argue, that these experts should not be precluded from testifying. So Dr. Russell is obviously very important, and they also need really the ARCA experts. And then you have those other experts. We'll see if they get to the medical examiner experts. We'll see. Maybe Brendan has maybe another motion to file to strike all those experts. So the defense will be left with Brian Lucky Law Firm. And perhaps he's going to try to strike him too. So this is what Hank Brennan's trying to do. I mean, this is what a very fierce advocate tries to do. They try to take away all of your witnesses and try to win the case. And that's what they're trying to do now. There's going to be an argument after this witness is done, Dr. Russell. And then we'll see what happens with the ARCA experts.
Yes.
Dr. Russell, first of all, do you recall in questions on cross the claim by Mr. Brennan, or the statement in his question by Mr. Brennan, that you did not express certainty in response to Judge Cannoni's question about the certitude of your opinion? Do you recall those questions?
Yes.
Do you recall? Well, let's go and look exactly at what you said in response to the question that Mr. Brennan raised, that was raised by the judge. If you could turn to Exhibit 36. And if you could read page 1-51, lines 10 through 23. I'm sorry, bear with me a moment. Bear with me, I want to give you the correct citation. I want you to go to, did I say 37? I wanted to say 36. Did I say 36?
You said 36, but you said page 151. You might have meant page 131.
Right. That's what I want to go to, Your Honor, which I will. Okay. Bear with me a moment, Your Honor.
Sure.
This is going to be one of only 2 questions in this area.
You may have meant page 130. That's where we started before we came to sidebar.
Thank you, Your Honor. What I'm trying to do is to get to Your Honor's question. That's what I'm going to pull out.
My question was on page 151.
I'm sorry?
My question was on page 151.
150.
151.
Can you go to page 151 and read the questions from the court, Judge Cannoni, and what your answers were?
Yes, from line 10. The court, question. I just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion? Answer, yes. These injuries in the arm are, my opinion is that they are the result of animal bites or scratches. Question, do you know what kind of animal? Answer, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical certainty. Very sure, high degree of medical certainty. Question, reasonable degree of medical certainty? Answer, yes, definitely. Question, and okay, and another question.
No, that's
it.
That's it. Yep. Now, to be fair and accurate, has your opinion that the wounds to the right arm of the decedent were caused by a large dog attack strengthened from June of 2024 until now?
They have.
Why?
Well, because between then and now, my opinions have been challenged. And as any good doctor would do, they go back and reevaluate what they base their opinions on. And I did that. I reevaluated. I looked at the pictures again, the evidence again. I looked at peer review studies, and I was convinced that I was correct.
And had you looked at, well, what caused you to go look at the peer-reviewed studies? What were you doing?
Well, so I looked at the peer review studies, and I periodically would do that throughout my whole career in terms of dog bites. But I looked at the peer review studies again because I was asked, why I didn't write a report, and so I was asked to write a report.
Were you asked to write a report before in June of 2024?
No.
But you were asked to write a report after June of 2024.
Correct.
Now let's go to is this what doctors and scientists do? Go back and analyze a matter, especially when maybe there's a challenge, another doctor is a question, there's a peer review process, whatever it is that something that's common or uncommon in the medical community?
That's very common.
I only have a few more questions, Your Honor. I'm just looking at them to conclude. On cross, you were asked about whether you were aware of, or whether you saw a need to peer review your opinions and conclusions in this matter. You recall that?
Yes.
Was that necessary?
No.
Why not?
Because there, first of all, there was no question in my mind that these were from dog bites.
And are there any persons that you're aware of in the entire country who have experience with emergency medicine and forensic pathology that you could even send it to for a peer review?
No, and that was the other issue, is I wouldn't even know who to send it to because I don't know of anybody with such experience.
I am going to, let's assume hypothetically that Mr. Walsh has stated that these injuries do not photographically appear to be described as puncture bite wounds and thus are highly unlikely to be the result of an animal bite attack. The abrasions are unspecific. Abrasions occur in body moves over a blunt or rough surface, such as a skin knee. Do you find that analysis sufficient to evaluate whether the bite wounds in this, the wounds from the right arm of the right arm of the decedent are from a dog or not?
No.
Why not?
Well, clearly that person, whoever wrote that, didn't even recognize the pattern. And so thus couldn't really even make that opinion and, just didn't recognize the features.
In the hypothetical that I just gave you, do the facts that are used in any way support the conclusion that is stated?
I don't believe so.
You don't believe so, or can you answer whether they do or they don't? Do the facts stated in that hypothetical support the conclusion that is made in that statement?
Actually, they don't.
Assume the same person said a vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Would you agree or disagree with that statement? Or the conclusion? Would you agree or disagree with the conclusion?
Would you please read it again?
Sure.
Sorry.
A vehicle backing into O'Keefe is one of many possible causes of his death, though the absence of documented injuries of his torso, hips, and legs appear to be inconsistent with a vehicle impact of significant force to simultaneously shatter a rear taillight. Do you agree or disagree with that statement?
I agree up until the point, the mention of the taillight.
But what is it that you agree with in that statement?
Well, I agree to the part that says that that it was insufficient to cause the injuries, the death of Mr. O'Keefe.
Now, aside from that hypothetical question, what is your opinion of whether a motor vehicle caused the injuries to the right arm of Mr. O'Keefe?
Motor vehicle did not cause.
And do you hold that opinion to a reasonable degree of medical certainty?
Yes.
Are you aware that only microscopic pieces of plastic were found in the hoodie sweatshirt of Mr. O'Keefe as opposed to, quote, littered, end quote, aspects?
I am.
Are you aware of any evidence of littering of pieces of plastic or glass in the hoodie of Mr. O'Keefe?
No.
Are you aware that there was pig DNA found on the decedent? Are you aware?
Not on the decedent.
On any aspects of the decedent's clothing?
Yes.
Do you know, from your experience, with regard to dog-inflicted wounds, your many emergency room evaluations and treatments of them, whether or in your knowledge of dogs and dog dentition in general, are you aware of whether dogs eat any type of food or treat that has pig in it?
I'm aware that the dogs, some dogs eat treats that have the pig chews and other kinds of chews. So yes, they do. Some dogs do eat things that contain pig.
Your Honor, just if you will, a point of information. I believe I'm done with my questions, and the reason why I say I believe I'm
Why
done.
don't you come to sidebar instead of having
Okay.
discussion across the courtroom?
Well, that wasn't 2 hours. I thought he said about 2 hours. So I'm not complaining. I'm just saying. I think he did a good job rehabilitating her. I think he did. The only other thing I would have said is when he asked about the car not being a cause of the death, and then when he said, "Do you hold that to a reasonable degree of medical certainty?" I would have also said, "Do you also base that on some literature or research articles or studies that you've seen and you've relied on in terms of your methodology to come to that conclusion?" Just to really button up that issue also. So we'll see. So Jen Clareman says, so we're supposed to believe that dogs treat DNA as left, but no other DNA. So yeah, I mean, that's the question. I mean, and I think a lot of it goes to the question of how much DNA was left, how much was not contaminated, sitting in the snow all day and all night for hours, how much of that DNA got ruined and contaminated or wiped off, and how much was left, and is it possible that some pig DNA would be left and not DNA from the dog? And again, that's also with the consideration of the 3 months that it took to actually get to the lab to get tested and what exactly was going on with those DNA swabs during those 3 months. So, I mean, this is all part of the question of this case. By the way, thank you, Blurry Lights, for 5 Brother Council memberships, Cyber memberships. It's a great time to join. We're going to be having a Q&A for members only
So recross examination.
on any topic. So that's going to be fun. And now we are going to recross.
You need a moment?
I'm holding Mr. Brennan up. I just
That's
want to
okay.
move my stuff, and I'll be ready in a moment.
Okay.
Dr. Russell, Attorney Lisi, pardon me, asked you about Dr. Walsh's statement about the cause of injuries. Do you remember? He just asked you that?
Yeah.
What he didn't offer in the report is this, and let me know if you agree with it. Decedent John O'Keefe was documented to have craniocerebral injuries, including skull fractures of the optical skull and the right parietal bone with associated subdural and subarachnoid hemorrhages. These injuries of the scalp, skull, and brain are consistent with, among other things, a backwards fall, unobstructed, unprotected falls due to various reasons and known to result in serious craniocerebral injuries resulting in death. Other mechanisms of injury cannot be excluded. Do you agree with that?
Objection, Your Honor.
I'm going to allow him to do it.
Do you agree with that part that you didn't hear of Mr. Walsh's opinion?
Yes.
The documented changes in color, swelling of soft tissue around the eyes are most consistent with the medical finding of periorbital ecchymosis, as documented in the autopsy report. Periorbital ecchymosis is a passive accumulation of blood around the eyes secondary to the documented skull fractures. These findings are less consistent with and are not documented as contusions of the eyes. The 1 centimeter laceration of the right upper eyelid, laceration of the anterior right tongue, and abrasion of the anterior and left aspect of the nose are documented, considered nonspecific, and may have occurred to a variety of mechanisms. Do you agree with that?
Yes.
Okay. The 2 red contusions on the dorsal aspect of the right hand were documented. The hand injuries may represent an injury sustained during an unprotected fall in which the back of the hand impacts the ground. These hand injuries are nonspecific and may have resulted from impact of hand with any blunt object. Do you agree with that?
It's possible, but there are other mechanisms.
Okay. When you talked about those articles that Mr. Alisi had you read, there is nothing that details what pattern recognition analysis is, the specificity which you are looking for when you're looking for a wound, does it?
I disagree.
Okay. When you looked at that Exhibit 5, if you could pull that up, you said individually, none of those wounds could you say to a reasonable degree of medical certainty were caused by a dog. It's only if you looked at them collectively.
Yes.
Okay. When you look at those collectively, it does not tell you the order in which the wounds were incurred, does it?
No.
It doesn't tell you if they're all incurred at the same time, does it?
They were occurred around the same time, I can tell you that.
Yes. But they don't tell you the order, the chronology, do they?
No.
No. In fact, when you look at the studies that you introduced with Mr. Alisi, let's talk about the Munich one very quickly. There's a chart, page 298. It talks about the things you would want to do to identify a wound. It talks about scene investigation, doesn't it, in the chart, table 2?
That's a fatal case, though.
Scene investigation is something you would look for?
That's in a fatal case caused by a dog. The cause of death was the dog.
This whole thing is, the whole excerpt is a fatal case that you're relying on for this pattern recognition analysis. This whole article is about a fatal case,
That's
isn't
what
it?
I'm saying.
Right. And in this fatal case that you're relying on to say this pattern recognition analysis, it points out scene investigation is the priority, doesn't it?
I think you misunderstand. The focus of that article is to identify the dog that caused the fatal injury. In this particular case, I don't believe any of those are fatal injury. That is not the purpose of the identification of those injuries.
Does the chart also say examination of the victim?
Excuse me?
Examination of the victim. Does it also say examination of the victim?
I don't have it in front of me anymore, but.
Well, you relied on it. You don't remember
Yes.
this?
I think we have it. We don't have it.
Do I have it? Oh, yeah, it's a minute. Okay,
Table 2,
okay.
page 98, examination of the victim. You did not examine the victim, did you?
Table 2.
Yes, table
No.
2, page 90. And the last part is examination of the,
I examined photos.
the last part is examination of the dog. You did not examine Chloe, did you?
No,
Okay, so the 3 things in the table it tells you to do, you didn't do any 3 of those, not one of them.
those, again, the purpose of this article was about the fatal, how to, the forensic approach to a fatal dog attack. We did not have a fatal dog attack here.
You didn't do any of those 3 things, did you?
No,
Okay. The shards in the sleeve, exactly where those wounds are, same area, same limb, right? The
That's what I
shards,
say.
how many shards were in that sweater?
Objection, Your Honor.
So I'm sorry, you said that's what you say, doctor? Is that what?
yeah,
Is
and
that what your
he
answer
said,
is?
Mr. Brennan said that the shards were in the exact same location as those wounds.
Okay,
And
let me
that's-
rephrase that. The shards in the right arm of the sweater, the shards from the taillight that was
Mhm.
shattered,
Yes.
those shards, how many were there? How many
I believe
Microsoft?
there were only a couple.
Why do you believe there were only a couple? Where did you read that?
This is what I was told
This is you were told by who?
by defense.
Oh, so instead of looking at the actual criminalistics report, you simply rely on what they tell you to base your facts?
That's what I was told, yes.
Wouldn't it be more prudent to actually look at the criminalistics report and make your own determination objectively and medically rather than regurgitate a point of the defense?
Well, I was told, this morning you said that the sleeve was littered with glass. And I was told that it was not littered.
Have you ever looked at that criminalistics report for
I'd be
yourself?
happy to do so now.
I'm asking if you've ever looked at it before you offer this opinion.
No.
No. If the glass shards were in that sweater in the arm, and we know glass can cause a hole in a sweater, in a fabric, can puncture it, and it can cause an abrasion to skin. Have you done any tests or studies to rule out that the broken taillight that was in the arm sleeve of Mr. O'Keefe, did you do any studies to rule out that it didn't cause those injuries?
Objection, Your Honor.
I'm going to allow it.
The glass shards would not have caused all the round wounds in the sweater. Those holes. The defects in the sweater mostly were round. They were not slit-like defects that I would expect with glass or plastic.
You're telling us that a sharp piece of glass cannot cause a hole to a sweater.
No, I didn't say that.
I-
I said they would not, especially on multiple sites, the same exact type wound,
Well-
defect.
If the glass was shattered and the glass had a number of pointy edges, wouldn't you agree with me that can cause a number of punctures in somebody's arm if the glass went into the arm and then came out?
Yes, but they wouldn't look like that.
You don't have any past case of history to suggest what the glass shards would look like randomly when they hit somebody, do you?
That's incorrect. I have seen hundreds of motor vehicle accident victims who have been cut by glass. They don't look like that.
So from your perspective, the glass just remained dormant in the sweater, but never protruded through the sweater and caused the abrasions. That's your opinion?
I didn't say
Your
that.
Honor, could we have a sidebar on this? Sure.
I have no further questions. I'm good.
Well, he said he doesn't have any more questions, but they're going to sidebar anyway. So I guess now we're just going to go back to argument. So they're going to argue whether, and I think we kind of know what Judge Canoni is going to do. I imagine she's going to take it under advisement and issue an order. So she doesn't have to do it right now on the record. And then we'll get that order, and we'll be able to analyze the order and discuss it. So.
Dr. Russell, when I'm referring to these shards, and I've said glass shards in Mr. O'Keefe's sweater, a more accurate way to define it would be that these were plastic shards, the plastic covering of the taillight, not glass. Okay?
Okay.
All right. Thank you.
Dr. Russell, you are all set.
We're done?
We're done. You're done. We're not done, but you're done. You can step down, Doctor.
Thank you.
If counsel really can keep your, Mr. Lessie, if counsel really can keep your arguments to 15 or 20 minutes, I'll give you 5 minutes to pull them together, 5 or 10 minutes to pull them together.
Thank you very much, Your
I
Honor.
really
All right.
can't keep the arguments.
All right, so I'll be back out at 3:15.
All rise, please.
Okay, well, we'll see. Now they're going to put their arguments together and argue whether she should be allowed to testify based on this 2-day Daubert hearing. Yeah, finally is true. I'm not sure what Law and Crime are doing now, playing with the video, but very interesting. I will say that it's always good to see good lawyering, so we definitely saw that. And just pull this up, Kim Hastings. I was always taught to respect my elders no matter what. He should be ashamed of himself. And I'm not sure you're referring to maybe Hank Brennan, but I mean, look, this is the job that he has. You know, he's not going to be nice just because she's older. He wants to win. That's why he was hired. So he's going to do his best to win, even if it doesn't look like he's being such a nice guy. The lawyers have to do sometimes. We have to be the bad guy. So, you know, whether his points are going to win or not is another question, but he's trying to do the best that he can. So let's pull this up, Island Girl. I hope the jury doesn't like a bully lawyer. So that's something that you got to be very careful about when you're a lawyer, because when you've got a witness who's really damaging your case, it can come across like you're being very combative with them, and juries generally do not like bullies. I one time had a case where I was in trial, and the other attorney was bigger than me. He was like a few inches taller than me. He had a real deep, strong voice. And it seemed to me that he would just come across as a big bully. And that entire trial played like the soft-spoken, I still made my points, but like I just came across as much more the timid one. And I kind of stressed that because I wanted to show the jury that I'm just the reasonable, timid one, using my logic and reasoning to win the case. And here's this guy who's just being a big bully over getting the witnesses and screaming at the witnesses and things like that. And it ended up that I was like, I think I'm going to win this case because I think this guy is just so unlikable, coming across such a bully. Now it happens to be that he won that case. And I was a little surprised because I thought he was a big bully and I was being the very respectful, timid one. So you never know what juries are going to do. It's sometimes, the general advice is don't come across as a bully. Juries don't like that. On the other hand, I've seen sometimes where it actually works. Sometimes there's different ways to make your arguments. I mean, you can try to paint the other person and the other lawyer and the other what's it called, the other defendant or the plaintiff as a big liar and someone who's either money hungry or doesn't care about other people and things like that. And sometimes the jury doesn't like it. Sometimes the jury just wants you to come across and say, look, this is a dispute. We just happen to be right. He's a nice guy there. He just happens to be wrong. So it's a lot of people feel that you have to make the other side a villain, and that's the only way to win your cases. Some people don't feel that way. And I think it's really jury dependent, and you're never going to know. So you just kind of play the card, do your best, play the cards you're dealt, and hope for the best. So we'll see whether, this, and again, like we said, Alan Jackson is not a snowflake. He can come across very strong and aggressive also. So. Okay, well, we'll keep monitoring it. When they come back, I'll come back. So for now, I'll keep the chat open and see how soon they get back and for the argument. All right. Let's get ready for our oral argument.
All right, did council have enough time to pull your thoughts together?
Yes, Your Honor.
Okay.
Yes, Your Honor.
All right, Mr. Brennan, it's your motion, so I will hear you.
I agree with the judge, Mr. Brennan.
I'd like to start with a couple of very important cases for your Honor's consideration. The first is one out of the District of Massachusetts Federal Court. It's Hines 55 Federal Supplement, second, page 62. It's a 1992 case, authored by Judge Radner. It had to do with a soft science handwriting analysis. It was a very thorough and thoughtful case that talked about soft sciences, methodology, and when there is an absence of methodology. In that case, I'm sure Your Honor is aware, it had to do with a proposed witness who wanted to look at a handwriting exemplar and provide an opinion of a so-called match. The court said there were very important canons, very important principles or foundations that have to be considered when we're discussing a soft science. Empirical study is not enough. Simply because somebody has seen something before, whether it's once or twice or 100 times, it's not a science. It's not a methodology. It's not medicine. It is a personal aside. A potential expert has to be in a better position to understand and explain to jurors rather than a simple layperson. That means there has to be some level of methodology, some type of guidance, some type of study, so that they can assist the jury in better understanding what they believe their conclusions are. Empirical is not enough because a subjective opinion without medical, factual, scientific support is just an opinion. A person can look at the constellations and see the Big Dipper, they can see Orion. It's a matter of perspective. It's no different when we have something like a soft science, something different than DNA, where a person wants to give an opinion because they've seen something before. That's not enough. And in this case, Dr. Russell has never been in the business of identifying dog bite wounds. She treats them. She's an emergency room physician, had some experience as an ME. She treats a wound that is brought to her. She's not diagnosing the wound or determining the mechanics of injury. She doesn't have the education. She doesn't have the qualifications. She doesn't have the training for that. That is not what her job is. It is to treat the injuries. And so all of her perspective and opinions are empirical. She doesn't have a book. She doesn't have a study that teaches her how to do. She never took a training. She never took a class. She never got a degree or certificate. She's looking at her past experience when someone reports to her that it was a dog bite wound, and she's trying to use her memory and make a decision whether or not she thinks this is similar. That is not science. That is not medical certainty. And so there's nothing to suggest that whatever method she used, I still can't identify it because I don't know, despite many questions of asking her, what her methodology is, other than she says it's pattern recognition analysis. It's empty phrasing unless you can identify and articulate what is the specificity. What is the standard? And we still don't know. After all of this testimony, we don't know. In Cromwell versus Rintala, that case had to do with a prosecution expert talking about paint spill. And this is, could not fit more closely to this case. The conviction was overturned because the prosecution called the paint spill expert. It was found to be prejudicial because the expert relayed their past experience about paint spills. Exactly what Dr. Russell did in this case. No more, no less. Her past experience treating injuries that were reported as dog bites. A person with a past experience with paint spills. The court was very specific in Rinaldi about why this was improper and why it was prejudicial. It said that just because a witness has experience or a particular experience and decides to use that as a methodology does not make it methodology. And it's just like Dr. Russell's testimony. There is nothing about it that employs methodology. In Rinaldi, pardon?
Rintala.
Thank you. In Rinaldi, direct the court to page 39. And it talks about when the expert used methods to determine that paint was poured or spilled. And the problem, why this case was reversed, the court said, instead, meaning the expert, he simply relayed his past experiences working with and around paint and drew conclusions therefrom. That is exactly what Dr. Russell has done. She has relayed her past experiences working with and around treating dog bites and drew her conclusions from that. They cite Combo versus Franceschi. Probably saying that wrong as well. But what that quotes is, while training and experience, to which the expert referred, might have taught the expert methodology, it is not itself a methodology. And so while Dr. Russell may have taught herself or been intrigued or interested in dog bites, it is no methodology. The defense has introduced a couple of articles. Those articles do not describe or lay out methodology for identifying dog bite wounds. They don't provide a standard. They do not provide a comparison. They don't provide any guidance. And so the danger in having somebody go before a jury and portray themselves as an expert when they have no methodology is they can pretty much provide any opinion they want to the jury that can be unchecked because it's not factually based. It can't be compared. It can't be analyzed. It's not peer reviewed. It's just an opinion. And when an expert lacks methodology, classic things happen, which happened in this case. What happens is that a witness does not actually have certainty about what they're saying. A witness is prone to change their opinion because there is no standard or methodology to confine them. A witness can just change their mind without new information because it suits their purpose. When we looked at Exhibit 5, and we actually broke down the wounds into separate wounds, 5 wounds, the doctor, I believe, concedes when you look at each of those abrasions independently. She cannot say with scientific certainty. She can't say with any certainty that those were caused by a dog. Her fallback was when you look at the entire series of wounds, that equals a dog attack. No basis, no reason why we reached that bridge from uncertainty to dog attack other than just because she said so. That can't be challenged because there's no methodology. And so the risk we have is you have an expert who gets up in a voir dire and they give opinions that wound number 1 could have been teeth marks, could have been claw marks. Wound number 2 could have been teeth, could have been claw. Wound number 3 the same. Really no idea. It's just guessing or speculating. And then they get up later and they change their opinion that more benefits their side. She later testifies at trial, sometimes maintaining teeth or claws. And then she appears in this hearing after writing a report and consulting, and she is emphatic that these are not scratches, but that they are dog bites. Think about the posture of that. If she is now saying that these are dog bites and they're not scratches, and she's changed her opinion, that impliedly concedes that her testimony in front of the jury, for which she was allowed to testify as an expert, not only was inaccurate, not only unsure, but inevitably it's misleading. It cannot be helpful testimony if an expert provides an opinion to a jury and they later on, without any real changes in information, changes their opinion for whatever reason. They're not constricted because there's no methodology or standard. And so the fact that this witness was allowed to testify at the last trial with opinions she no longer endorses or stands behind, and the fact that we can reasonably conclude that is misleading to the jury, well, that begets the argument that she should not be given another chance to go in front of a jury and give a different opinion without having actual factual and medical and scientific support, and she does not. There is no doubt about one thing. She has no idea. When I walked her through the different wounds on Exhibit 5, I invited her to explain to your honor, why is it that this wound was caused by a dog? There's no circumstantial evidence to support that, none whatsoever. It's just her personal empirical history dealing with dog injuries in the ER. And when I asked her for wound 1, what direction were these canines? She couldn't tell. Where's the puncture wound where the dog anchors and pulls? There is none. The distance and width of those wounds, how could she reasonably and fairly say they were caused by canines? Any indication, any support, any pattern recognition that would tell us that was caused by canines, and she couldn't give us any information. Not weak information, not information that I could fight with another expert, not information that I could say, wait, not the admissibility. None. She could just fall back on, well, when I look at everything, it's a dog bite. Same thing with number 2. Number 2, interestingly, the widths are much different than wound number 1. It doesn't take an expert to know that it wasn't the same mechanism that caused the injuries to wound 1 and 2. And if they want to continue to pretend it's a dog bite on wound 1, there's no way they can reconcile that wound 1 is any way similar to wound 2. It would have had to be a baby dog or a different dog or the pack of dogs I asked her about the first time I talked to her. It is totally different. And again, when I asked her for any specificity, these weren't hard leading questions. I opened to her to explain to us, why is that a dog bite now? She would only give us a conclusory answer. It just is. There was nothing about teeth or detention or about the dog, about anything that would support the claim that that was a dog bite and why she changed it from scratch. None. We get to the elbow wound number 3. There's the speculation that the arm could have moved, would have moved. Yet she has no idea. She has no factual support for this. None. And she vacillates between this being potentially bites, scratches. All 5 of the different points on wound number 3 could be canines on both sides, or maybe there was a 4-point canine in a smaller fraction of number 1 and number 2 in wound 3. That cannot be. It defies common sense and reasonableness to say the same dog caused wound number 3, points 1 and 2, with the so-called punctures, and caused number 1 and number 2. Again, you can simply look at the distance between canines are not going to move when a dog bites an arm. An arm can move, it can change the angle, the depth. The canines are not going to move. Then we get to wound number 4, equally baseless. Wound number 4 at first wasn't sure if it even had to do with the dog attack, but then that made no sense. So Dr. Russell retreated to say, well, it did have something to do with the dog attack, but hard to define. And then wound number 5, again, a 4-point bite that is totally reconcilable with 1, 2, and 3. There is no collateral or supportive evidence to suggest that this is a dog bite at all. It's fertile imagination for her to get on the stand and claim it's a dog bite. Not just that there was no opportunity and that there was no dog that touched her, but the wounds are dissimilar. She cannot point to a pattern, a methodology, a standard to say, this is why this is a dog bite. It's just a dog bite. So it's interesting when we learn that she didn't know about much of the evidence that wholly contradicts the fact that this is a dog bite. She didn't know that there were plastic shards in the sleeve of his arm. The fact that there is physical evidence that results from a collision left in the very place where this wound happens to be there isn't mere coincidence. It isn't mere coincidence. It's exacting evidence. And what is not exacting evidence? The absence of DNA. Now, this is important because Dr. Russell was comfortable taking the scan and providing information to Your Honor for consideration that was totally baseless. It didn't in any way hamper her willingness to do that. She floated theories of taint in the DNA, or manipulation, or the DNA wasn't handled properly. There was absolutely no good faith basis whatsoever for her to suggest for a second that that DNA collection, preservation, and testing wasn't sound. She had a right to look at the evidence in the criminalistic reports and the DNA processing. She knew she could not admit the significance because it would undermine the entire theory. And so she was comfortable on the stand using her experience as a doctor to try to convince Your Honor that DNA was insignificant based on a demeaning of the evidence with no basis. An insulting claim that somebody did something wrong with no basis. The reason why that's important, it shows that this witness has the willingness to testify to Your Honor about a conclusion for which there is no support. This witness has the comfortableness to testify to Your Honor about an opinion that has no factual basis. And her doing that with the DNA was a parallel to her doing it with the dog bites. She is comfortable getting on the stand and simply giving the ultimate opinion that is helpful for her cause without any support. And so that DNA attack by her is reflective of her willingness to compromise fact, science, and medicine to just provide an opinion. Knowing there is no real methodology here, there just isn't. Knowing there's no standard, unable to provide us any balance for why this is a dog bite, having the free rein of an opportunity to look at the exhibit and tell us anything she wants to support as a dog bite, and being unable to do that, the defense employs differential diagnosis. That's a fancy way of saying, well, we might not be able to prove this, but we can disprove everything else. That's the way they presented this expert. They own that. Because when you look at those different wounds, and you can't identify them as dog bites individually, you can't say the whole series becomes a dog bite. Wound 1 has 0 value. Wound 2 has 0 value. So 5 times 0 is 0. Cumulatively, it does nothing for us. Using the word dog attack doesn't make you look at that and say, well, that's methodology. That is nothing. And so differential diagnosis is a very compelling argument for the government why you should not allow this. This witness is in no position, kind of like the DNA and kind of like the opinion on dog bites, she is in no position to engage in differential diagnosis regarding to car accidents. She may have been a police officer, she treats injuries at the hospital, she is not an accident reconstruction specialist. She has never gone to an accident and done a reconstruction. In fact, she never even went to the scene in this case. She never saw Mr. O'Keefe. She doesn't even know about much of the evidence that exists. She didn't consider the black box. She didn't consider the speed. She doesn't know the angle of the collision. She doesn't know what Mr. Keefe was doing in his last moments. She has no idea about any of that, none. Yet she'll be presented on the stand as if she can exclude a car collision as the cause of those injuries. Not that they could be, and it's consistent with what didn't happen. How dare she get on the stand with no experience, no training, no methodology, no facts, and ignore reality and say this couldn't have been a car collision. It's funny that as a emergency room physician, she considers the basis of mechanics of injury based on what people tell her. If they come in and say, I got bit by a dog, or a parent says, my child was bit by a dog, they rely on statements of witnesses. She didn't rely on statements of witnesses here. I hit him, I hit him. Oh my God, I hit him. Maybe I clipped him. Maybe I hit him in the knee. Maybe he dropped his phone. Whatever the statements were. All the various statements. An expert like her, if she proposes to be, would consider the witness statements to try to determine the cause of mechanical injury. So for her to take the stand respectfully and suggest for a moment that this was not caused by the collision to Mr. O'Keefe, not only with any no factual basis, in defiance of actual fact, it's repugnant to the sense of fairness in the courtroom. A witness, just because they have experience as a doctor, doesn't mean they can just come into court and say what they want and then let the government try to counter it. That's not how it works. And so when we consider not only what she doesn't know, but what she chose not to know, it is overwhelming. This is not a qualified person to come in and talk about dog bites. From her perspective, she's probably one, if not a few people in the country who can even do this kind of thing, which suggests that there is no real methodology. If she is the only expert in the country, it is not generally accepted in the community. It can't be. It can't be. And as much as the defense may want her to testify to promote this theory, she does not have the credentials and qualifications to do that. She didn't even take the basic steps, as you'll see in some of the literature, of going to the dog. Chloe, they knew we found Chloe. They know we've done molds. And she says they told her. And she tried to fight with every posturing angle that may be important, but she didn't need to do that. I dare say, if she had taken some steps to try to do due diligence, it wouldn't have ended well for her theory. Perhaps that's why she didn't. She doesn't have the qualifications. She doesn't have the experience. She doesn't have the methodology. Her willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound. There is no DNA. There is plastic shards in his arm. She has done no due diligence. And she can't describe any methodology because there is none. And she, most importantly, has changed her testimony from hearing to hearing, and we should not let that happen again. Thank you.
You know, I would get up now if I was the defense and I would say, Your Honor, that was a very compelling closing argument. And maybe Mr. Brennan can actually say that closing argument to the jury when it's time for closing arguments. But now we're not really discussing here all the evidence of this case and what points to a car accident versus a dog bite. The question here is a Daubert hearing. And I know Mr. Brennan wants to talk about all the other evidence in this case, but that really has nothing to do with why we're here. But anyway, let's just see what they have to say about it.
Thank you very much. All right, Mr. Lessie.
Thank you, Your Honor.
The greatest danger to the issues in this case, the greatest danger to a defense right to a jury trial and present its witnesses to have an entire motion supported by nothing but the assertions of an attorney on the other side. That is the greatest danger to our system. That is the greatest danger to a defendant being able to present their case in their view. Remarkably, all of the arguments you just heard now do not come from a medical doctor, which Your Honor has said causation of an injury to a person in Massachusetts must come from a medical doctor. Where is the affidavit? Where is the report of a prosecution witness to support one statement Mr. Brennan just made in 30 minutes? Where is it? It doesn't exist. I would like to start my argument and tell you exactly where I'm going to go. I am going to go to why we're here and what the issues are for this motion. So I'm going to start my argument with what is the legal standard that Your Honor faces to answer. And I know Your Honor knows it. I'm just doing it for the logic in the presentation. I'm going to go through that. I'm going to identify specific case law of dog wound cases, not paint cases, not others, because it matters, because Daubert and Lanigan are so flexible and so nuanced. It's got to be the issue before it. Paint cases that Mr. Brennan mentioned are irrelevant. So I'm going to go through cases that speak specifically to dog wounds on humans. Then what I'm going to do is to go through the completely inaccurate statements of Mr. Brennan. He said it, I marked it down 8 times in just his argument alone. There's no methodology. I'm going to go through and say what the methodology she testified to was, where it's rooted, and then I am going to go into why Dr. Russell is actually stronger in December than she was in June. So let me start out with the baseline for this hearing. The January 20th transcript, page 1-4. And if Your Honor will indulge me, it's what Your Honor said, and I'm going to read it verbatim. This was when Dr. Russell was challenged by the prosecution the first time. Line 15. I find that she is a medical doctor. She's an experienced ER doctor, albeit, several years ago since she's worked in that capacity, but that she does have specialized knowledge in that field that may assist the jury in that regard. So if you compare the level of information that Your Honor had at that time to reach the conclusion to what we have presented in this hearing, 11-page single-spaced report. And Your Honor noted before that there wasn't a report, so we wanted to respect that and get a report. Your Honor has sat through testimony, which I'm going to adduce, but not too much because you sat and heard it, and went through her qualifications, and we adduced much more of her qualifications, much more than were adduced when Your Honor first found that finding and made that finding. So let's start with the law. Mr. Brennan and I agree on one thing. The Rottola case is relevant. But respectfully, Mr. Brennan went off in a tangent, because what does Rottola stand for that's relevant here? Quote, the crucial issue, in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. What is the subject matter of the testimony? It's what are the cause of the wounds to the decedent's right arm. I submit that if you ran an artificial intelligence program, you couldn't come up with a more perfect witness for the subject matter of this testimony. Emergency medicine physician, 29 years experience, forensic trained pathologist who has co-authored books on dog bites. She's well-versed in the articles. She is consulted by experts like Dr. Vail that you heard about for these types of issues. The crucial issue of whether she's qualified, to me, is 100% in favor, and I don't believe you could find another witness more qualified, and that's the crucial inquiry. What's the second prong of the inquiry? After qualifications, is the methodology reliable? That's the second. Whether Mr. Brennan agrees, and 95% of what he argued, that's for cross at trial. But more importantly, that's for a jury to determine. That's the job and province of a jury to determine whether, assuming Mr. Brennan ever gets a doctor to come in and counter Dr. Russell, it's for a jury to decide which expert do we give more weight to. But the focus of this hearing, why are we here? The second prong is the methodology. Mr. Brennan, 8 times in just this argument now, and he tried it on cross, said there's absolutely no methodology. Your Honor sat and heard the same thing that all of us heard. She went through her own pattern recognition methodology, especially in redirect, but she did it very thoroughly in a report and very thoroughly on direct. She went through what it is. And importantly, counter to what the Commonwealth just said, she says it's rooted in the medical literature. We just heard the statement that there's no support for it. Demunich and Pollock. And we walked through, with Your Honor's gracious indulgence, we walked through specific sentences and paragraphs where that pattern recognition methodology is stated. And here's a key. Remember, please, the word pathognomonic. This pattern is so specific that it almost by itself rules out anything else. That's the definition of pathognomonic. Used characteristic, which he denote and explain what another study said was pathognomonic. It's incredible to me that it can be stated that there's no methodology here and that there's no basis for it. It is generally accepted in the medical community. That's the purpose of the Pollock and the Demunich article, is to establish that it is accepted. Dr. Russell is not coming here to the court and just testifying, it's my subjective empirical statement. Mr. Brennan tries to do in his argument exactly what an expert rejected and for which he has no support. And that is to say, we got to look at these wound by wound by wound. And he said 0, 0, 0, 5 times 0 is 0. He tried that on cross. Dr. Russell rejected that resoundingly. She said, you're missing the point. The point is the pattern. You look at these all together, and it's the pattern that matters. And the authors, Pollock and Demunick, say that pattern is pathognomonic. You really don't even have to go to other causes, although Dr. Russell said she did because that's what good, thorough doctors do. So it is incorrect that Dr. Russell didn't explicate a methodology. It's incorrect that she didn't explicate that there's a rooting in the medical community and that it's generally accepted. Now let's go to the cases. Mr. Brennan cited to a paint case, etc., but interestingly, and in contrast, in our papers, which Mr. Brennan has had for almost a month, and he didn't respond, interestingly, we cited to the Lobello case, the Brinker case, both of which are dog wound injury cases, not pain cases. I know a little bit about Lobello because I know a little bit about the firm that sponsored the expert in Lobello. It's my firm, my law firm. And the exact argument that Mr. Brennan just made was expressly rejected by the court on a dog bite case, a dog wound case. Here's what the court said. The court finds that Dr. Sirota qualified as an expert on the presentation. This is on Westlaw page 10. The court finds Dr. Sirota qualified as an expert on the presentation, treatment, and medical sequelae of an attack by a dog. Here's the key. As explained in his expert report, Dr. Sirota has personally repaired thousands of wounds and lacerations, including wounds and lacerations caused by dog bites. And he's authored a number of peer-reviewed articles in the areas of his certification, et cetera, et cetera, et cetera. And so there is a dog bite case from the Southern District of New York, not an insignificant court, as recent as 2023, saying a doctor that sees and treats all these, that's reliable. And this was a Daubert challenge, Your Honor. This wasn't an incidental question. The challenge was defendant's motion to preclude expert testimony, albeit federal rules of 702, but we know in Massachusetts, it's Daubert, Lanigan. You can satisfy Daubert, the federal, but you also Lanigan, and under Davis, you can have generally accepted in the medical community as well. There's one case. Another dog bite case, we cite Brinker, that Mr. Brennan didn't address, is a federal court case in Indiana where same challenge to a doctor about the cause, and it was italicized, the cause of the injury to the person there. And the court basically said in that case that this expert here, and they challenged the causation issue, said that doctors who have experience in treating them, that's enough in and of itself. We don't need to go into, we know Daubert's flexible. You don't have to use all 5 factors. They're called non-exclusive factors for a reason, which is a good segue now to Massachusetts cases. Mr. Brennan's hypothesis is that you can't just have somebody use their years and years of experience. You've got to have something more complicated. We cited the Goodman case, a Massachusetts case, and I'll read the relevant portion. The challenge in that case was to a burn pattern. So it's not a dog bite case. I want to be clear about that, but it's a burn pattern. And here's what the court said. The foundation for Slowick's methodology, that was the expert here, was simplicity itself. Examine the exterior of the facility for external causes, and finding none, examine the interior of the building to locate the origin of the fire by following the burn patterns. And the court put by following the burn patterns in italics, not me. And so the court basically said, here, it's simple. Just look at the patterns. This person has experience with seeing these patterns. Next case we cite, another Massachusetts case, Pasteur. What's the issue there? Not a dog bite case, I've already given you two, but a firearm examiner in that case. The court said, and I'm going to quote, a judge may also look to his, let's get it correct, her, for this case, own common sense, as well as the depth and quality of the proffered expert's education, training, experience, read on, to determine reliability. All right? So even in situations where courts have repeatedly said, including dog bite cases, if a doctor has repeatedly looked at, treated, etc., they get to testify with regard to whether they believe a wound is caused by whatever. And in the two cases I've given you, dogs. So the law is very clear for what the position is of the defense with regard to methodology. And that's what this hearing's about. That's why we're here. Is her methodology reliable? And there is one methodology. There's a pattern methodology. She testified to it. And the Commonwealth has no competent evidence whatsoever to counter that. It's remarkable to me that we're being faced with the challenge to whether the defense could put up a defense and put up a witness when there's no opposition to her methodology from, as your doctor has, or your honor is required, a medical doctor that is required under law in Massachusetts. I also, Your Honor, want to go to now what the Commonwealth has argued in its papers, which I think further underscores the waywardness of their argument. On page 11 of their papers, the Commonwealth further attempts to criticize, or excuse me, what we said in our papers on page 11, the Commonwealth further attempts to criticize Dr. Russell for being a, quote, trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science, forensic odontology, or canine behavior. How does that square with your honor's standard that it must be a medical doctor that speaks to the causation of this injury? By definition, a veterinary medical science person is not a medical doctor. A forensic odontologist, most always a dentist, is not a medical doctor. And certainly canine behavior. And why are those words there? Because that describes exactly the expert that the Commonwealth has sat on since the trial, Dr. Cosby. That's him. And in the book that Mr. Brennan attempted to use, Dr. Cosby has written some of those articles, interestingly enough, citing the very articles that Dr. Russell relies upon for the very pattern methodology. So again, the waywardness of the Commonwealth's argument is they're not addressing the need to have a medical doctor. We are not here arguing over whether the dog behaved correctly. We are here to determine, and this is the focus, what is the medical cause of the injuries to the decedent's right arm? And what we have done, perhaps too thoroughly, is we have established the credentials of Dr. Russell, not only with regard to dog bites, but with regard to medical causation, a broader umbrella. And under that umbrella of medical causation is expertise in dog bite wounds, expertise in motor vehicle accidents, but importantly, expertise in wounds caused by motor vehicle accidents. We never presented her as an accident reconstruction because if you need to be a medical doctor to be able to opine on these wounds, I've established through Dr. Russell, and it's unrefuted by the Commonwealth, that Dr. Russell has never heard of someone who's an ER doctor who is an accident reconstructionist. They're two different disciplines. And lastly, on this point, before I move to my next, if an accident reconstructionist is going to come in and try to testify about the nature of wounds, I think I can predict what Your Honor might do. So in terms of why we are here, it's straightforward. Her credentials are enormous. Her experience is enormous. She has been truthful and honest. Your Honor has the notebook for the exhibits for today and can look and see that she did not make inconsistent statements. By way of example, when she said, when it was alleged that she said possibly was in the question, not in her answer. When it was alleged that she didn't answer your question to a medical degree of certainty, we proved that that was wrong with specific language. So on the methodology, this is straightforward. In the law, in the cases I've given you, in Massachusetts as well as dog bite cases, it is completely accepted for a medical doctor to use their many years of experience in treating these types of wounds, and that's exactly what Dr. Russell did in this case. Now, a very important, in my judgment, Your Honor, legal point. The Commonwealth has waived its entire motion, and here's how they did it. I asked Dr. Russell what I refer to in these Daubert hearings as the magic question. I said, do you have an opinion on the cause of the injuries to Mr. O'Keefe's right arm? Yes, I do. What is that opinion? I believe that those wounds were caused by a dog attack. Do you hold that opinion to a reasonable degree of medical certainty? I do. The Commonwealth never objected to that question. To me, that's a waiver of the entire issue. If they thought she was unqualified to answer that question, they should have done what Mr. Lally did in the June 21st trial. Because another part I've got in the notebook for Your Honor to see is she never got the opportunity at the June 21 trial to answer the question of whether she had that opinion to a reasonable degree of medical certainty, because Mr. Lally objected, as is his right, and Your Honor sustained it and sustained it and sustained it. That's yet another reason why it's not inconsistent, because at the June 21 trial, she never got to answer that question because of the Commonwealth. But back to the waiver. The Commonwealth should have, at that moment in the hearing, objected, but they didn't, and they have waived that objection for this motion. Lastly, I want to just cover a couple more items that Mr. Brennan had quickly. He kept saying, can't be, equally basis, evidence wholly contradicted. Where's the medical profession to support that? Those are Mr. Brennan's opinions. And respectfully, Your Honor, I don't believe that's even for the court in this hearing to decide. That's for the jury to decide. As almost all of these cases go to, the Labello case that I cited, those arguments go to the weight of the testimony. They go to cross-examination. As Your Honor well knows, you're the gatekeeper to see whether Dr. Russell gets to go to the jury, whether you're going to keep that gate open that I believe you very carefully and judiciously decided on June 18th. And I respectfully submit that gate should be much wider open now, given what Your Honor has heard and the basis for it. But even if Your Honor might be inclined to be interested with, maybe even persuaded by some of the things Mr. Brennan said, those have nothing to do to whether there's a methodology or whether it's reliable. Those are easily answered by DeMunick and Pollack. And that's the end of the inquiry. Everything else is beside the point. With regard to the DNA that the Commonwealth has tried to make so much about, there was only one reason why that was brought up. It was brought up because Dr. Russell answered she didn't need to know much about the DNA. Why? Because the pattern of the wounds are so highly characteristic of a dog bite and a dog attack, and because the authors used the word pathognomonic. But because she was careful, she went through a differential diagnosis, but she was consistently honest and forthright. When she didn't know something, she said so. So in terms of this particular matter, and I'll conclude my points at this point and keep to below the 20-minute mark.
30 minutes.
I'm sorry, 30-minute mark. The tremendous importance of a defendant's right, especially in charges of this seriousness, to present a defense, to present a counter argument to the whole theory of the prosecutor's case. Their theory is that a motor vehicle hit the decedent and caused these injuries to the right forearm. The presumption should be the defendant gets the right to present evidence. Now, they don't have an absolute right. You got to satisfy Daubert, but I believe the satisfaction on the crucial inquiry of qualifications and then the methodology and reliability is overwhelming. So, Your Honor, I would urge that Your Honor find that Dr. Russell is qualified. She's qualified as a medical causation witness, which has her able to not only testify at trial with regard to whether those wounds are caused by a dog attack, but also she can testify, and she's qualified to do so, that it's not from a motor vehicle.
And that was exactly the point that I said they should argue. Because remember, last trial, she was only allowed to testify that they're consistent with a dog attack. And I said now they should argue that she should also be able to testify that they're inconsistent with a motor vehicle strike. And that's exactly what he just did. I'm glad he's listening to my channel.
Accident. And she's also allowed to testify with regard to her forensic pathology hat, because contrary to the impression of the first in June, she's been doing forensic pathology as recently as her time at Corcoran. My last point, Your Honor, is this, and it blends in with the point I made earlier about the jury. Shouldn't a jury be able to hear the alternative theory of the defense? Shouldn't the jury have that information so that justice can be served, so that the best decision can be made about whose theory about these injuries is right? We've satisfied, beyond my view, respectfully, any reasonable doubt about her qualifications and methodology. Let's let everything else go to the jury and decide, so Ms. Reed can have her fair day in court.
Okay. Thank you. We have some scheduling things that we should take care of. There's another motion from the Commonwealth on another Daubert hearing regarding the digital evidence expert.
There is, and also, I don't know if it's documented, but I filed a notice to the court regarding my concerns about ARCA witnesses. And the reason I filed that prior to filing an actual motion is because I appreciate the trial court date. I do not want the defense to be unaware of my intention.
All right. So let's set a date for a Daubert hearing. Any idea how long you expect it will take regarding the digital evidence expert?
Well, Your Honor, when you say a Daubert hearing, you don't mean an evidentiary hearing. You mean a hearing on whether or not an evidentiary hearing is required.
So we can do that tomorrow, or we can set it. Well, then we'll stay now and do that. Are you ready to do that, Mr. Jackson?
We just got this on January 31st.
Okay.
We've not had an opportunity to respond
Just
to it.
December 31st, probably.
What did I say?
January.
Yes. New Year's Eve. We've not had an opportunity to respond to it. We
Okay.
expect to have an opportunity to respond to it.
How long will it take you to respond to it?
Probably a couple of weeks.
All right, so what I want to do, because I want to set some dates, and if we're not going to have a hearing, we'll cancel it. It's easier than getting the motion, deciding that there'll be a hearing, and setting a date, because we're sticking with that April 1st trial date.
I understand that, but the problem with setting a date for a hearing and an evidentiary hearing requires us to bring someone in from out of state.
You know, so what I'm saying is file your paperwork.
Okay.
All right, we'll set a date for a hearing.
Okay.
We'll set an evidentiary hearing date. I just want to lock those in. I'm trying to do them
Okay,
on Mondays or
that's fine.
Fridays for you,
Understood.
thinking that it would be better for your schedule if we tried to accommodate that. But we've got a full session, so.
Mr. Brennan and I talked briefly, I don't want to speak for him, but we talked briefly about the January 27th date. I think all counsel have that date cleared because it was a trial date at one point in our,
Right.
in our history. So what about the 27th for the motion on Mr. Brennan's Daubert request?
On all witnesses, not just, you said you're filing,
The only one he's got is for Rick Green.
what did you file a notice of, you said today?
Notice that I expect that I will likely move to exclude the ARC witness failure on Article 14. It's not a Daubert hearing.
Okay.
It's compliance with Rule 14.
Okay, so
Notably,
that's different.
Yes. I am waiting for a response from the United States Attorney's Office that we're supposed to expect next week.
Okay.
If that changes my position, I'll notify the defense in the court. If it doesn't, then I'm going to pursue that motion.
Okay.
We see briefly at time on scheduling.
Okay, so what they're talking about now is, remember, there was a motion that was filed by Brennan to either strike Richard Green or to have a Daubert hearing like we just had with Richard Green. On top of that, he just filed a notice today. He's going to move to do something like that with the ARC experts. Well, actually, it was more of like that he's going to wants to strike the ARC experts. So there's going to have to be a hearing for that. So we'll see. Larry, do you think they are waiting for the SJC decision before they schedule the trial? Well, they had no problem scheduling the trial before for January 27th. So that date was going to stay, but things happened, as we see. So I don't think they're considering that at all. That's my personal opinion. Thank you for sticking with this all day, fellow counsel. Well, had to watch it one way or the other. Like to keep up to date on this anyway. Trying to sneak in some other work. Maybe you noticed, maybe you didn't. But definitely on the breaks. Trying to sneak in some other work here. Yeah, a lot of times I'd be watching this on double speed. So instead of spending 7 hours on it, I would spend maybe 3.5 hours on it. So I did spend some more time so I can hang out with you guys today, but it's interesting. And these are good lawyers. So it's nice to watch. Definitely nice to watch good lawyers and good lawyering. How did I like the dog case law? So interesting. If you're listening carefully, the dog case law actually is not Massachusetts case law. It's actually from a federal case. Nevertheless, it's always good to. Oh, looks like they're going to be finished
Yeah,
now.
the 31st will be oral argument at 9 a.m. And if there's an evidentiary hearing, it will be conducted on February 6th. We'll block off the day. And February 7th, and we'll also hear the ARCA motion if there's something on that. So we'll go for the 6th, but we'll leave time if it carries over so we don't have what happened with Dr. Russell, such a big gap in between. Okay. All right. We'll see everybody then. Thank you.
Thank you.
Okay. Well, as expected, they did not. She did not rule from the bench, as you're kind of expecting. So she's going to have to prepare an order. And that's it. So now I've got 7 hours to recap, which hopefully I'll do in a video that's under a half hour. That's the goal for today. So if you guys all stuck with me, I appreciate spending the day together with Brother Counsel. And what an interesting day it was. So appreciate everybody coming. Appreciate all of the memberships, the members, the Brother Counsel membership that's been growing thanks to some of you guys. And definitely a good time to join because we're going to be doing another Q&A, members only, which includes all topics, not just legal topics, not just cases that I'm following, but any topic at all. We have been discussing in the Q&A and the members only. So definitely join the members. It's very, very cheap, very easy way to support the channel and get some extra content. And do that. Send some questions, submit some questions to me, brothercounsel99@gmail.com, and we'll answer them during that members only session. So thank you all again for joining. I'm going to be putting out another video hopefully today with the recap of everything and some of my thoughts. And that's going to be it for now. Thank you all. See you next time.